ನಿಮ್ದೇನ್ರಿ ಸರ್ ಅದು ಸರ್ ಇಷ್ಟ ಅದಾವ ನಿಮ್ ಸಿಕ್ಕಿಲ್ಲ ನಿಮ್ದು
हेलो भाई यो भाई सॉरी भाई तुफेल को बोल भाई कॉल करके मैं वो देर घर में चुका भाई हाँ ओके बाय बाय
ಇದಲ್ರಿ ಸರ್ ನಿಮ್ಗೆ ಅಡ್ಜರ್ಮೆಂಟ್ ತಗೋಬೇಕಾಯ್ತದ್ರಿ ಕ್ವಶನ್ ಕೊಡ್ತಾರ ಮೋಸ್ಟ್ಲಿ ಬರ್ತಿತ್ತು ನೋಡ್ರಿ ರುದ್ರಪ್ಪ ಅವ್ರಿಗೆ ಹೇಳಿ ಮೊನ್ನೆ ಹೇಳ್ಯಾರ ಕಾಪಿ ಸಿಕ್ಕಿಲ್ಲ
ಹಲೋ ಕೋರ್ಟ್ ಆಫೀಸರ್
ಸರ್ ಹೇಳ್ರಿ
ಕೇಳ್ತಾ ಇರೋದು ಓಕೆ
ಕೇಳ್ತದೆ
ಸೀರಿಯಲ್ ನಂಬರ್ 13 ಐತೆ ನಂದು
ಅದರ ಕೇಳ್ತದೆ
ಥ್ಯಾಂಕ್ ಯು
PCR ಬಂದು ರಿಕ್ವಿಡ್ ಅಂತ ಸಮಸ್ಯೆ ಅದಾವಲ್ಲ ಕಣ್ಣು ಹಿಂಗೆ ತೊಗೊಂಡ್ರಂದ್ರೆ ಬೇಕಾಗ್ತದೆ ಬಂದ್ರೆ ನಾನು ಬರ್ತಾರೆ ಬಿಡು 10:34 ಅದ್ರ ಡೇಟ್ ಮ್ಯಾಟರ್ಸ್ ಅದಾವ ಕೆಳಗೆ ಹೋಗಿ ಈ ಹೆಂಗಿದ್ರು ಇಷ್ಟು ಜಲ್ದಿ ಮುಗಿತು ಆಮೇಲೆ ಬರೆಯುತ್ತಿಲ್ಲ
ಎಷ್ಟು ಮ್ಯಾಟ್ರು ಮೆನ್ಷನ್ ಎಷ್ಟು ಮ್ಯಾಟ್ರು ಮಂಡೇ ಮೇಡಮ್ ಒಂದು ಫ್ರೆಶ್ ಮ್ಯಾಟ್ರು
notice.
ಆ ಲಿಸ್ಟು ಆಯ್ತು ಮಾಡ್ತೀನಿ.
ತಗೊಳಕ್ ಮೇಡಮ್ ಟಾಪ್ ಆಫ್ ದ ಲಿಸ್ಟ್ ಹಾಕ್ತೇನೆ. ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಮೆನ್ಷನ್ ಮಾಡಿದಂತ ತಗೊಳ್ರಿ.
ಅದು ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಇವತ್ತು ಎಕ್ಸ್ಕ್ಲೂಸಿವ್ಲಿ MFA ಅದಕ್ಕೆ
ಅದೇ ನಾನು ಹೇಳ್ತೀನಿ.
ನೀವು ಹೇಳ್ರಿ ನಾ ಇಟ್ಕೊಂಡಿರ್ತೀನಿ.
10:30 ಸ್ಟಾರ್ಟ್ ಆಗುತ್ತೆ. लाइटनिंग अर्जेंसी क्या बात? लाइटनिंग अर्जेंसी क्या?
ಕೊಡ್ರಿ. ಏನಿದ್ರು ಹೇಳ್ಕೊಡ್ಬೇಕು. ಎಲ್ಲಾರ ಫ್ರೆಶ್ ಮ್ಯಾಟ್ರಸ್ ಅಂತ ಹೇಳಿ ಅಂತಾರ, ಕೊಡ್ರಿ ಅಂತಾರ, ಕೊಡ್ರಿ ಅವ ಆ ಕಡೆ ಕೊಡ್ರಿ.
ಅಲ್ಲಿ ಫಸ್ಟ್
ನಿಮ್ದ ಹೌದಲ್ಲ.
ವೇರಿಯಬಲ್ ಕೋಡ್ ಮಿಲ್ सर 2:30 मूव किया वो अभी फाइल नहीं किया और आगे ना है 10:30 कल बोला हूँ कल आपको मीटिंग मूव करना पड़ता इसलिए आज मूव कर रहा हूँ ನಮ್ಗೇನು ಮಂಗಳವಾರ ಕೊಟ್ರು ಬುಧವಾರ ಕೊಟ್ರೆ
Done, sir. It's fresh matter ಬಂದ ತಕ್ಷಣ ಕೊಟ್ಬಿಡೋದು. ಬಂದಾದ್ಮೇಲೆ Lords, with your lordship's
For a
kind.
half day, only matters which cannot wait till Monday. Memos, please give the memos. Otherwise, please don't give.
Tuesday, I'm Lord, your Lordship. Tuesday, I'm Lord.
For Tuesday, huh?
Monday is a holiday, Tuesday.
For Tuesday, you're giving the memo today. Take it. Take all the memos and before posting the matters, show the list to me. Tomorrow's list.
Lords, with your lordship's kind permission, I am moving one for end of the list, one auction matter, my lords. I have not taken any loan. Some third party firm has taken the loan. 28th is the auction, my lords. Tomorrow half day sitting. The matter won't reach.
Even if it, now once they have issued the auction notification.
So,
Once they have issued the auction notification.
please, my lords.
Before auction or after the auction, the purchase, you will be in the same position. We can always,
My lords, my only submission is that, my lords, at, if I'm losing that land, I'll be caused irreparable damage.
How?
Mainly, my lords, I have not taken any loan. Some third party and
I'm saying,
Please,
whether the before auction, after auction, we can reverse it. We can put the clock back. For that, no lunch motions are required. Yes.
at least tomorrow, my lords, please, kindly.
Let it
My
come.
lordship, my lordship,
Lords, yesterday
my
also
lordship
I
on
had moved
submission,
it.
my lordship.
Kindly.
It's a labor court.
No mentionings today. Yes, call the list.
May
Because
please,
of-
my lord. My lord, serial number 9. my lord.
Call the list.
Kindly, next week. Serial number 9, my lord.
Serial number?
9, my lord. I am for claimant, my respondent claimant, my lord. Kindly be first week, my lord.
Why you want adjournment in the?
Liability, my lord.
Huh?
Liability.
That also we can decide.
File, not seen the file.
Huh?
Not seen the file, my lord. Kindly be first.
If a court is going to pass any adverse orders, then we will adjourn. Please don't ask for any adjournments in MFA matters. Call the second list. Yes.
Serial number 1, my lord, I had made a request yesterday. Now it is regard to auction of, my lord, commercial stocks. Yesterday matter was
Yes.
displayed. The lordship has said it. Requested to take up that.
Lords, in this I appear for the respondent number 1.
Oh, matter is there in the list. I am asking for adjournments if any. Yes.
Serial number 11, my lord.
Huh?
Serial number 11, list 2,
Yes.
it may be referred to mediation, my lord. Other side is also.
Get request.
Please.
Matter is referred to the mediation.
Please,
Yes.
my lord.
Serial number 53, my lords.
She'll call.
Lordship, serial number 25, Lordship. Short accommodation, Lordship. There's some personal inconvenience. Kindly on 28th, Lordship, please.
You appear for whom?
Petitioner, Lordship.
What about the respondent? Have you informed?
Inform, Lordship, yes, sir, please. Inform, Lordship.
You already informed?
Yes, Lordship.
At request of learned counsel for the petitioner, this is matter in the month of March. It is submitted that the same is already informed to the counsel for the respondent.
Please.
Serial number 53, my lords. 2 weeks time I begin. The matter has been settled before the trial court.
Hmm?
Serial number 53, my
Have
lord.
you informed the other side?
Yes, ma'am. I have informed, ma'am.
Same thing in this also.
Interim orders may begin.
Yes.
Please.
My lord. My lord.
Doesn't matter, they will file after the matter is disposed of also. We will not adjourn any of the MFAs. They are specifically listed for disposal, no adjournments.
My lord.
Without looking at the file.
My
Yes.
lord. In the first list, 48 and 54 pertains to the DL, my lord. 29th, my lord. Some of my matters are listed on 29th. Kindly have it on 29th. I will address my lord.
Why not today?
Kindly on 29th, my lord. No, my lord, it's on DL, my lord. DL point,
It is on DL, if it is on something.
my lord,
what is here
no
to hear?
DL
Listen
case,
to
my
the-
lord. Kindly have it on 29. 29 I will, without fail, I will address the court.
Right foot.
48 and 54.
If matters are not listed, every day 3 rows for adjournments, everybody will say memo. Matters are listed, adjournments. Why not today? That's what I'm asking. Thursday is a day for the MFAs. We have to hear it today.
My lord, next Thursday, my lord, 29th, without fail, I will address the court, my lord, regarding particular point. 48 and 54.
No, and why should I take an exception to your case when I'm saying rejecting everybody's request? I can't. Call the list.
Serial number 56, my lord. My appeal is pending. Company appeal only listed today. Kindly connect with one more appeal, my lord. 56. Company appeal is listed today. But
Your appeal is listed.
not listed, my lord. Only company appeal is listed today.
Claimants, sir. No, we will decide the liability. Liability
My
in
appeal
that-
is also necessary.
It will come. It will come. Yes, call the list.
With the kind permission, my lord, This matter, my lord, the person who has lost confidence of 26 members out of 27 executive members has been removed and new committee is formed and charge has taken. By virtue of an interim order of this court, my lord, he is squandering away the amount of the society. A request should also have it on 27th and hearing on IFR vacating stay.
We will see, we will see. Take the memo.
27th,
We will see.
please.
Yes.
May I make one request? List to serial number 1. No, process has started now. It becomes infructuous.
What will happen? No, if something is wrong, we will set it right. We can, today itself, nothing will happen. Call the list. Yes,
My lords, claimants appeal for enhancement, my lords, case of injury.
case of
In
injury.
the first matter, I am for the respondent, madam, insurance company. I am ready, madam.
What is this? Call them. Yes,
My lords, the appellant has sustained the fracture of the amputation of.
come to the table.
Please, my-
Table at page number 16.
Please, my lords.
What are the injuries?
My lords, the amputation of the toe, my lords, fifth toe. Fourth and fifth toe, my lords.
That's the only injury?
Yes, my lords.
Yes.
Yes. Medical expenses as it is?
Yes, no changes, madam.
That she has to say.
No,
Yes,
no.
my lords, medical expenses.
No, it is not case, not their case that tribunal has
How many days was in
rejected the
hospital?
medical.
How many days was in hospital?
3 days, my lords.
3 days.
3 days. It is evident from exhibit
Incidental
R.
expenses 3,000.
Please.
3,000. Court has already granted 3,500. Yes, we will maintain that. Loss of income during laid up period. Which year is the accident?
2018, my lords.
18, madam. As per the chart,
11,750.
please.
11,750 into 3. It comes to 35,250. How much was how much the disability was considered?
10,000 is given by the doctor, my lords. 10%, my lords.
Come to that paragraph.
My lords, it is at page number 15, my lords.
Please read.
F.
5% is considered by the tribunal.
Doctor has assessed a 10%, but the tribunal has taken
Why should
5%.
the tribunal take 5%?
Of course, that is wrong.
On the ground that only injury to
Take
the right
10%.
foot. Please.
What is the age?
Age 60, my lords. As per the wound certificate, it is 60. 60.
Why? What happened? They have done. It comes to 2,67,815.
Please.
No, no, no.
Agreed with our.
Sorry, madam. Disability is considered at 3%, madam.
10%.
10% as per the medical evidence. Tribunal has taken 5%.
Why should it take, there should be some reason,
No,
contrary to the medical evidence.
No. As per the Employees Compensation Act, my lord, in case of
We look at Employees Compensation Act.
no,
Why would we look at Employees Compensation Act? Under the
Because-
Motor Vehicles Act, we are looking at the medical evidence.
that is true, my lord. But in case of amputation of any toe, as per this act, the disability will be 3%. However, the tribunal has considered 10%.
Has the tribunal considered it? Tribunal has taken 5%, not 3%.
No, tribunal has taken 5%, my lord.
That's what I'm saying.
Please.
I'll record your submission. Agreed with the word passed in MBC
As
number
per this,
1244.
the disability for loss of one toe, it will be 3%, ma'am.
I'll record that. MBC number 1244 of 2018, dated 4th August 2021. The claimant is before this court seeking enhancement of the compensation. The tribunal has awarded the compensation as per the table given below. The table is at page number 16 extracted. Land counsel appearing for the claimant submits that there is an amputation of the toe, and the tribunal on all the heads, the compensation that is awarded by the tribunal is on the lower side. It is submitted that when the doctor has reported that the disability is 10%, but the court had taken 5% as disability without any basis. Hence, the claimant is before this court seeking enhancement of the compensation. Next, land counsel appearing for the insurance company submits that the tribunal has taken the disability at 5%. It ought to have taken the disability at 3%. As per the Workmen Compensation Act, if there is a loss of any toe, the disability is 3%, but the court had considered 5%. And
May
on
I
all
one-
other counts also.
One more submission, sorry, madam. Even the doctor has stated that 10% disability to the limb.
Not to the whole body.
No, not to the whole
That's
body.
what is, where
Not
is
to
evidence
whole
of the
body.
doctor?
10% PDF of the right foot to the particular limb. That is F. In the judgment itself, madam.
The doctor has opined that the petitioner has sustained permanent disability to an extent of 10%. Where do you get that? He said
That
it
is
is to the limb.
In F only, my lord. In F, may I read it? Further, he has not justified clearly as to how he has arrived at a 10% PDF of the right foot.
Let's see.
In
The
F
evidence
only.
of the doctor.
Please. I am not having the
PW2
copy.
evidence.
PW2, my lords.
You have a copy?
Yes, my lords.
Pass on.
I am not having the copy of that. Further, he has not justified clearly as to how he has arrived
There
at
is,
10%.
it is not about one toe. There is loss of fourth and fifth toe.
But in the judgment, it is stated that.
But that is what the judgment shows, fourth and fifth toe.
Acha.
Write it. He has lost the fourth and the fifth toe. He didn't say about limb disability. What did you write? 5%. And it is submitted that on all other heads, the compensation that is awarded by the tribunal is just and reasonable and no enhancement is called for. Next para, having heard the land counsel on either side, peruse the material on record. The petitioner, there is an amputation of so and so that considering the same under the head of pain and suffering, this court is granting 40,000. Medical expenses, there are no reasons to interfere. Even under incidental expenses also, court had granted 3,500. No enhancement is called for. Coming to the loss of income during the later period, considering that this accident had taken place in the year 2018, 11,715 to 35,250. Coming to the loss of future income, there is amputation of 2 toes, fourth and fifth, and the court, the doctor has opined that the disability is 10%. Without any basis, the court tribunal had taken 5% as disability, and this court is taking the disability at 10%. 11,750 into 12 into 9 into 10 by 100 is 1,26,000. In the light of the law laid down in Makel versus so and so, legal expenses 10,000. Altogether, the claimant is entitled for an amount of rupees 2,67,815. Accordingly, the appeal of the claimant is partly allowed by enhancing the compensation from 1,29,000 to 29,585 to 2,67,815. The enhanced amount shall carry 6% interest. Yes, next matter.
Please, much obliged.
I have sought for recalling of the order. Dismissed for non-prosecution, non-compliance of office object.
At least have you complied the?
No, I may be permitted to comply.
Pending consideration of I number 1 and 2, the appellant is permitted to comply with the office objections. Once office of within 2 days,
Please,
like he has to comply the office objections by 29th of January.
please.
Yes.
My lords, there's a delay of 231 days in filing the appeal, my lords. Claimant's appeal for enhancement.
I number 1 of 2034 is filed. 1 of 2024 is filed to condone the delay of 231 days. Delay is condoned on condition that they are not entitled for interest for the delayed period. Yes.
My lords, case of injury, my lords. Appellant has sustained the fracture of right tibia and fracture of left tibia, my lords. It is at page number 11 of the judgment, my lords.
How many grievous injuries? As per the wound certificate, come to the
My lords, it is at page number 13. Fractures are mentioned at page number 13 of the judgment, my lords.
commuter segment fracture right tibia, fracture of the tibial right leg. So only one grievous injury, 40,000 towards pain and suffering. Medical expenses as it is. How many days he was in hospital?
11 days, my lords.
11,000. Loss of income during later period. Which year is the accident?
2019, my lords.
2019.
19.
13,250 into 3. It comes to 39,750. Now please come to the, in the other case, another 10,000 towards loss of amenities. That I forgot. Add that. Yes. What, according to the doctor, what is the disability?
32%, my lords.
To the limb.
Particular
limb. Particular limb.
Particularly.
So
10% is taken by the tribunal.
Disability certificate has been obtained after lapse of 3 years.
10.6, we will take 11.
Please.
The disability certificate has been taken after lapse of 3 years.
But we are not in appeal.
Please.
So it comes to 10.6, we will take 11.
Please.
Loss of future income, 13,250 into 12. What is the age?
19, my lord. Multiply 18.
18 into 11 by 100. It comes to 3,14,820.
Yes.
Loss of amenities. Another 10,000, another 5,000, 15,000. comes to 4,65,320 against 3,88,450. Please come. Agreed with the award passed in MVC number 580 of 2020, dated 24th March 2023 by so and so. The claimant is before discoursing enhancement of the compensation. The tribunal has awarded the compensation as per the table given below. In this, no facts are required. Whatever I am dictating, it should come like that. Paragraph from paragraph number 18, you will find the table extracted. When counsel appearing for the claimant submits that when the claimant had sustained two injuries, one is commuter segmental fracture right tibia and fracture of L3 tibia right leg. The court, under the head of pain and suffering, had granted only an amount of rupees 20,000. When, as per the evidence of the doctor, the disability is 32,
my lords.
32%.
32%.
32%.
The tribunal had taken the disability at
10%, my lords.
10%. It is submitted that even under the head of loss of income during the later period and other heads also, the amount that is awarded by the tribunal is not just and reasonable. Next parallel, counsel appearing for the respondent corporation submits that the court has granted a just and reasonable compensation on all the heads and no enhancement is called for. Next para, having heard so and so. Considering the two injuries that are sustained and particularly one grievous injury under the head of pain and suffering, this court is granting 40,000. Medical expenses and conveyance. No enhancement is. How many days you said he is in hospital?
11, my lords.
As he was in hospital for 11 days under the head of incidental expenses, 11,000. Coming to the loss of income during the later period, this accident had taken place in the year 2019. 13,250 into 3, 39,750. Loss of future income. 32%, 1/3 of it comes to 10.6, and this code is taking it as 11. 13,250 into 12 into 18 into 11 by 100 is 3,14,820. Under the head of loss of amenities, considering the 11% disability, this code is granting 15,000. In the light of the law laid down in Make Allowances so and so, legal expenses 10,000. Altogether, the claimants are entitled for an amount of rupees 4,66,320. Accordingly, the bill is partly allowed, enhancing the compensation from 3,88,450 to 4,66,320. The enhanced amount shall carry 6% interest.
My lord, I have filed Wakala for respondent. My name may be.
Your name is there.
Please.
SC.
Please.
Yes.
Claimants appeal for enhancement.
Yes.
Yes.
Case of injury or death.
Injury, my lord.
Come to the table.
My lord, para.
This before that, one more thing. What has to be there is now the delay is condoned. They are not entitled in the operative portion for the set period. Yes. Now in this also, I number 1 of 2024 to condone the delay of 106 days, condoned on condition. Yes.
My lord, fracture of the fracmula, my lord.
Come to the table. Table.
This is a case minor. Claimant was a minor.
14 years
in the
old,
case of injury, 14 years.
14 years.
14 years. Mallikarjun,
How much it has to be as per Mallikarjun?
The 1 lakh is awarded. 1 lakh.
2,28,798.
As per the, my lord, the disability 19%, my lord.
How much?
19%.
Where is the judgment of Mallikarjun? There is. What is the age?
14 years, my lord.
14. As far as medical expenses are concerned, as it is.
Please, my
Hmm.
lord.
61,978.
Please, my lord. Pain and suffering.
Then pain and suffering, that is under Mallikarjun, there are different heads.
The
Only loss of income to the parents has to be considered.
Please.
Loss of income to the
Future
parents.
earning.
1 minute. That all, as per the table, we will see. Which year is this accident?
Please.
Which year is this accident?
17. 10,000.
10,250.
Please.
They didn't bring the judgments from Bangalore? All the PS? You have the judgment of Mallikarjun, Master Mallikarjun? You should have brought it when you are relying on it.
Sorry, I am not, today I am not.
But there is no state company.
Huh?
The master Mallikarjun assessment is.
As per the Master Mallikarjun, my lord, 3 lakh rupees.
That's what I want to just look at the judgment.
At page 13 of the judgment, it has referred.
All the PS, they must have brought from Bangalore.
Para 13 of the judgment, it has referred.
Para?
13 of the judgment. Para 15. Page 13.
If the disability is above 10% and up to 30%, it is 3 lakhs. 3 lakhs. So pain and suffering, all incidental expenses will cover in that. What are the other heads?
Other heads is properly given 50,000 pain and suffering, 61,000 medical
There's
expenses.
no pain and suffering in Master Mallikarjun. This disability and all, everything coupled with that would be that 3 lakhs.
In addition to that,
That's why I want to look at the judgment.
it has referred.
No, what are the other heads are there in Mallikarjun? In the judgment it is there. It only refers to this, what the permanent, how much, if it is up to 10%, it is 1 lakh.
1 lakh.
Yes.
Medical expenditure.
Yes.
And the loss of income of the parents.
That is already granted. Only 3 heads. Just will have.
The other one is medical expenditure. And third one is the loss of income.
Everything, pain and suffering, everything will, that's.
It covers it.
Last one. Pain and suffering, inconvenience caused to the parents. Pain and suffering already undergone to be suffered in future. Everything all put together, that 3 lakhs.
3 lakhs.
Loss of amenities, then discomfort, loss of earning to the parents, medical expenses. But incidental expenses are given and a separate head.
Up to 30%, 3 lakhs.
For medical expenses, that incidental expenses are given. Incidental expenses. No, but it look, no, if you see in this judgment, no, pain and suffering already undergone and to be suffered in future, mental and physical shock, hardship, inconvenience, discomfort, loss of amenities on account of permanent disability. That is one head, 3 lakh, 1 lakh depending on. Then discomfort, inconvenience and loss of earning is a second head. Third head is medical and incidental expenses during. Both. For 58 days, court had granted 25,000. Future medical expenses for correction of the mall union of so and so, that is granted. Yes, in this, what is the
17 days he is hospitalized.
attendance, conveyance, food, nutrition? How many days he was in hospital?
17 days, my lord.
This head we will add.
Yes.
Did you speak to her? They are there. It is there. They got it. Come, they can forget that. It's coming to 4,19,728. 2,28,798. Please come. Agreed with the vote passed in MSC number 178 of 2021 dated 28th February 2024 by so and so. The claimant is before this court seeking enhancement of the compensation. The tribunal has awarded the compensation as per the table given below at paragraph number 16. Then counsel appearing for the appellant claimant submits that the claimant is aged about 14 years. 14 years, and the accident had taken place in the year 2017. And as per the evidence of the doctor, he had suffered disability of
19%, left lower limb.
19%. It is submitted that the court had relied on the judgment of the Honorable Apex Court in Master Mallikarjun's case, Master Mallikarjun versus Division Manager National Insurance Company Limited.
My lord, out of 19%, one third has to be taken into consideration. Out of a total disability assessed of 19%, one third is to be taken into consideration. Out of 19.
Should have said, submitted before doing all this exercise, isn't it?
To whole body.
Where is the
Page number 19, my lord, page number 19.
Page number 10.
Page number?
In page 19, my lord, 19.
Yes, please read.
Please. The petitioner has got examined PW2 that the PW2 has disposed that the petitioner has RTA 35/2017 has sustained the crush injury to the left foot with fracture of the third two proximala, and he has got a disability 90% left lower limb and third two fixed in the norm functional positive 6%, complete loss of sensation in the 9%, shortage of the half inches of 4%, that in evidence has to be witnessed the petitioner has got marked disability certificate exhibit P15.
Give the evidence of the doctor.
Para 15 last page.
No, we will see the evidence.
15 the last line.
Where is PW2's evidence?
PW2, my lord.
He said it's
Girish,
not
Dr.
there.
Girish.
You have the evidence of the doctor? You
Girish,
have with you?
please, my lord.
Pass on that. That's how it has to be taken 1/3.
1/3 if taken to whole body.
Limb disability.
Whole body.
That's what the doctor's evidence is.
The doctor given a particular limb. Particular limb, the doctor given a particular limb.
Particular limb. Then in that case, how can we take it as 19%? How much the court had taken?
Well, future
It comes to 6.3.
Correct.
6.3 is below 10. If it is below 10 under
10,000.
the Act of Pain and Suffering, it's only 1 lakh.
well, the tribunal has not awarded future earning.
Huh?
The
That
tribunal
we
has-
will consider.
Please.
We are only on this point.
Please.
They have it. Where is that entire? They're not brought judgments. Judgments are not brought from Bangalore. Why? Ask Varna why it is not. It's coming to 2 lakh. If you calculate, it is coming less than what has been granted.
My lord, other rates.
Even after granting legal expenses of 10,000, it's coming to 2,28,000, 2,19,728. What has been awarded is 2,28,798.
Yes.
Then I'll say there is nothing to interfere.
But the tribunal awarded future.
I have added that. I have added the parents' loss of income to the parents. Because all other heads, what are granted, we can't grant it basing on Mallikarjun's case.
Yes.
So if we calculate that way, it's coming to 2,19,000. What has been awarded is 2,28,798.
Please.
We'll dismiss that.
Please.
What did you write? His contentions. But it is submitted that the disability is 19% and court ought to have granted 3 lakhs under the head of pain and suffering. It is submitted that on all the counts, the compensation that is awarded by the tribunal is not just and reasonable. Then counsel appearing for the respondent insurance company submits that the tribunal had rightly considered the disability and rightly granted 1 lakh towards pain and suffering. It is submitted that according to the doctor, the disability to the limb is 19%. 1/3 of it is 6%, which is less than up to 10%. And as for the judgment of Mallikarjun's case, the court had rightly granted an amount of rupees 1 lakh. Hence, there are no grounds for enhancement of the compensation. Next para. Having heard so and so, this court has perused the award and the compensation that is granted by the tribunal. First, coming to the contention of the land counsel, the petitioner, that the disability ought to have been, as per Pastor Mallikarjun's case, 3 lakh has to be granted under the head of pain and suffering. This court do not find force in the argument of the land counsel. If the disability is up to 10%, it is 1 lakh. The evidence of the doctor is the disability to the limb is 19%. Then it comes to 6%. In that case, the court had rightly awarded, and this court do not find any reasons to interfere and enhance a compensation. Accordingly, the appeal filed by the, give it to him. The appeal filed by the claimant is dismissed.
Please.
Give him the paper.
Please, it's claimant's appeal for enhancement.
Yes.
A delay of 104 days.
That we will do. Will please argue. I number 1 of 25 is
refer
filed
to
to
look
condone the
that-
delay
On
of.
submission, my lord. Already connected matter refer to the Lok Adalat, my lord. It may be referred to this also, my lord.
I number 1 of 25 is filed to condone the delay of 104 days in filing the appeal, condoned on condition that they will not be entitled for interest for the delayed period. It is submitted that what is the connected matter?
10060. Please.
So and so is referred to the Lok Adalat. Hence, this matter is also referred to the Lok Adalat. Yes, next.
It's injury case corporation appeal, my lord. Stay is already granted. The petition filed after the lapse of 3 years.
Let's see. Now they are served.
Yes, my lord. And charge sheet is against the respondent, and we have already submitted 100% amount. We have already submitted 100% deposited.
Come to the order.
Yes, ma'am.
We'll see. We'll dispose this of already notices are served.
Yes, my lord.
Come to the order. You're ready?
My lord,
You're ready?
my lord, please records for call for my lord.
Admit. Post of file name, call for the PCR. Yeah, IN number 1025 is filed to condone the delay. Condone. Yes, 7.
There is a delay of 3 days. Only the company is challenged on the point of quantum.
Please come to that.
Please.
Case of death or injury.
Pardon, Lordship.
It's a case of death or injury.
Injury, Lordship.
Please come to the table.
The only, in the evidence, he admits that he is 69. But tribunal has considered based on the cost title, he has stated 60. Based on that, award is possible. So there is a difference of age. So the multiplier reduces accordingly.
Let's see.
Please.
Basing on what you're saying, he is 69.
He 69 based on the evidence he is in the cross-examination, he has admitted.
Where is that?
In the cross of PW1, ಈಗ ನನ್ನ ವಯಸ್ಸು 69 ವರ್ಷ ನಡೆಯುತ್ತಿದೆ ಅಂದರೆ ಸರಿ. He admits that 69 is running age. In the cross-examination, he admits. Though in the chief he says 60, and in the cost title he says 60, in the cross-examination he admits that he is 69. Thereby, the multiplier.
What about the medical records?
Medical
Records will also have this.
Medical records, what he has stated goes on varying.
So they have
66.
In the medical records, they must have mentioned the age.
Age, one Lordship, 55 has been stated in the medical records. There's a lot of variation between the medical records and his own CR, Lordship. Yeah. 55 is stated in the medical records.
In the chief affidavit, he says he's 60.
60. But actually when cross-examined, he says 69. There will be a difference of at least 4 multiplier.
No, 22 is accident.
2021. 2021.
When was the cross-examination? In which year?
25.
25. Because 55 then and 5 years thereafter.
Then also if it is considered 7 multiplier should have come, not 9.
No. In medical records, it was shown as
55.
55. By the time he was subjected to the cross-examination, the trial, by the time 4 or 5 years have passed by.
Then
so
also.
he has become 60. He has become 60. Yeah, in the chief examination, he said 60.
Chief examination 60.
Correct.
And claim petition also 60 years stated.
What is his occupation? What is his education? Because why did you put such a question in the cross-examination? There should be some basis for that.
Only basis on the cross-examination.
No, what happens is a person who is illiterate and all, in the cross-examination, you ask him some question.
Actually, we asked him to produce the Aadhaar card. He has not produced. That would be the best document, government document.
What is his occupation?
Occupation is agriculture coolie.
No, even for you also, they to question him in the cross-examination, saying that you are not 65 years, you are 69 years. What is your basis? The question itself looks very, no, there should be, unless and until there is some material on record. So for that
Actually-
you feel that he is not 60 for 60 years, he's 69 years. And then for that he answered, yes, I am 69 years.
That is,
That is somewhat, doesn't sound logical at all. What is the occasion for the insurance company to put such a question in the cross-examination? There should have been some factual basis for
that is the Aadhaar card. That was the intention. We called for Aadhaar card and it is not. He says he doesn't produce it.
And now, even if that is taken,
Please.
pain and suffering, what are the injuries he has sustained?
That we did not dispute regarding the tribunals, whatever 18% has been considered. That we don't dispute.
When the court is reassessing the compensation.
Please.
If the court comes to the conclusion that either it is on the higher side or on the lower side, without there being an appeal from the other side, the court can as well interfere with that. So he has sustained how many grievous injuries?
It is said that 2 grievous injuries.
2 grievous injuries, he is entitled for 60,000 towards pain and suffering. Loss of income during the later period also, if that is also enhanced, what will happen to that whatever the multiplier you are saying? We'll dismiss your appeal. Yes, please. Agreed with the award passed in embassy number 679 of 2022, dated 15th March 2025, whereby the tribunal has granted compensation of an amount of rupees 3,66,628. The insurance company is before this court, questioning the quantum of compensation. Then counsel appearing for the insurance company submits that in the cross-examination, the claimant had stated that he is 69 years old, but the tribunal has considered his age as 60 years. If it is 60 years, the multiplier is
9.
Multiplier is 9. If it is 69 years, the multiplier is 5.
5.
It is submitted that on that count, the insurance company is before this court. Though notice is served on the respondents, no wakalat is filed on their behalf. Having heard the learned counsel for the insurance company, peruse the material on record. The accident had taken place on 9/10/2021. According on that day, the claimant is aged about, according to him, he is aged about 55. When it comes to the trial on the day, he stated that he is aged 60 years. As the trial is after 4 years from the date of the accident. Medical records also, it is mentioned as 55. It is a case of the insurance company that in the cross-examination, they have said he is not 60. When in the chief affidavit he has stated he is 60. In the cross-examination, they posed a question to the complainant, to the claimant, that he is not, he is 69 years old, but he is not 60 years old. This court is not able to understand the rationale in the said cross-examination or the question put forth by the insurance company. On what basis they have suggested, and what is the material to say that he is 69 years? 69 years, nothing is forthcoming, considering the age and the occupation of the petitioner and how he has been subjected to the cross-examination. Basing on that, this court cannot consider the age of the claimant as 60. Further, a perusal of the compensation that is awarded under the head of pain and suffering, loss of income during the later period, the court had not, under the head of loss of amenities, the court had not granted a reasonable amount. If this court has to go into the aspect and on the other aspects, then the compensation may have to be enhanced in those circumstances. This court is not inclined to interfere with appeal filed by the claimant, by the insurance company, accordingly dismissed. Amount in deposit shall be forthwith transferred to the tribunal. Yes, next.
Right, there is an Aadhaar card which is not marked, which says 69.
Yes, 8.
Yeah.
8. Mr. Patil. Yes.
The beneficiary appeal, my lord, there is a
In
delay of.
this, in the seventh other matter, IA number 1 of 25, 3 days condoned. Then in this matter, 15 days condoned. Yes.
My lord, the tribunal has taken into consideration the previous district court judgments, but it is not permissible in view of section 26.
The LAC is before this court today.
My lord, the 71,774.
Hmm?
The
Hmm.
without taking into consideration section 26 explains.
What about the delay?
Delay can be condoned, your lordship.
IA
as
number
a-
1 of 25 is filed to condone the delay of 15 days. You are the
His
Beneficiary.
beneficiary.
I have challenged the judgment passed by the district court, my lord.
Notices are already served.
Yes, my lord, served.
Last time it was listed, your lordship.
Last
and
time?
Last time when it was listed, notice was served, your lordship, and then I have taken notice also as government.
The district court has not taken into consideration section 26, 3 explanation, my lord. The considering the
Only of 50% of the amount to be
Yes,
deposited. 50% same, that LAC matters, no? To be deposited and all. Yes.
problem.
Please, I am for the appellant. Owner, my lord. Owner appeal, my lord. I have produced, my lord, some documents, charge sheet and complaint, my lord. Complaint copy and charge sheet, the entire charge sheet, my lord.
Why the liability is fixed on the owner?
Please.
Why the liability is fixed on the owner?
There is no DL on the part of the
That's first question. Whether DL is there or not there?
delay, my lord. No, my lord.
DL is there or not there? Driving
Yes.
license is there or not there?
In charge sheet, my lord, 4% DL was not there, my lord.
Then
At the time of accident, my lord. Both them, my lord, deceased and rider of my motorcycle, my lord. Deceased, my lord, riding the one motorcycle.
here it is like this. First point, as far as your liability is concerned, if the driving license is not there to your vehicle, then you are liable to pay the compensation. They will pay.
No,
and
my lord,
record from-
accident.
One more. Now, the second aspect is, according to you, the deceased was also not having driving license. If you say that there is a contributory negligence, or because he is not having the driving license, that contributed to the accident, basing on the judgment, you have to point out to the court. So please come to the judgment.
Only, my lord, I am citing that in charge sheet, my lord, deceased himself, my lord, fell down, crossing the road, my lord. At that time, he dashed the dog and fell down, my lord. This is the fact, my lord. In complaint itself, saying, my lord.
Then after that, what happened?
After that, my lord, some 2 persons are treating deceased, my lord. At that time, this another motorcyclist, my lord, came rash and negligent, dashed the deceased, my lord.
And where are you?
I am the riding the motorcycle, my lord, in same way, my lord.
Let's read then we will understand how the accident had taken place. Come to the facts of the case.
Please, my lord. On 7/10/2017, my lord, at about 11 p.m. near Puja Dhaba, within the limits of Mantur village on Nipani Mudod Road, State Highway Road, the deceased Sivanand Bhima Perekud was proceeding on motorcycle, so and so.
So you are the owner of this vehicle, motorcycle number 1205.
1205, my lord.
Yes.
1205.
Hmm.
At that time, dog was crossed the road and the deceased lost his control. Thereby, the said motorcycle
Now, when it
was
comes-
skid, my
Now
lord.
the court has fixed any contributory negligence on
No,
the
my lord.
deceased.
No, my lord. My lord, deceased is the rider of motorcycle. Rash and negligent. One dog is came, my lord. He fell down and skid, my lord. And then after later, one added, my lord. Another vehicle is come and dashed to that deceased person, my lord.
What is that?
My lord, he is a A1,
Then there
A1
are
is
only
the
two
deceased
vehicles
man.
involved.
There are first, my lord, only one vehicle, my lord.
First is he fell down.
He fell down, my lord, rash and negligent, and then he fell, then later, my lord, after,
Vehicle has come.
please, my lord, after thought, my lord, another vehicle, my lord, he came, dash to the petitioner, my lord, deceased person, my lord.
This is a cooked story, my lord.
That is cooked.
I am the
cooked story, my
first
lord.
person to
Only
treat
for one vehicle
deceased,
is
my
there,
lord.
my lord. That is also
For the
First person to treat, my lord. He fell down, my lord, on the road, middle of the road. I came on the same way, my lord. I stopped and treated him, my lord. And some people come across the place, my lord, and fought me, my lord. You are the only hit the deceased and all these things, my lord. And file complaint against me, my lord.
actually, my
This
lord.
is the fact, my lord.
1205 vehicle is not at all involved in the accident, my lord. After cooked,
05?
1205, my lord. K27 bar Q 1205 is not at all involved, my lord. After that cooking, that add the vehicle, my lord.
1205 belongs to him.
Please, my lord.
Please, my lord.
He is
That
saying,
is
my lord,
also, it is also
rightly, my
insured
lord.
vehicle, my lord.
Owner of the vehicle.
Please, my lord.
Actually, my lord, this claim petition is not maintainable because 166 claim petition filed, my lord.
160?
166, they have filed 166 claim petition. Even rash and negligent is also deceased person, my lord. Claim petition is not maintainable, my lord. They have filed 163A, my lord.
Understand. Where is this third vehicle has come from, which you don't find here? Only two vehicles. He fell down.
No,
he came.
no
and
third
dashed.
vehicle, my lord. He is saying, Lord, my vehicle. my lord.
Only
Please,
two
please,
vehicles.
Two vehicles.
Please. The fact, my lord, only one deceased, only one vehicle is, my lord. Only rash and negligent charge sheet is also that person, my lord. Even that is also no DL person.
He had been more careful.
Please.
The accident could nothing would have happened to the deceased because he came and hit him.
No, my lord.
After he fell down,
In
this vehicle has come and hit him.
in complaint itself, my lord.
What is the story?
My lord, complaint is also, my lord, adding that another vehicle, my lord. Only for because, my lord, the fact, my lord, only one vehicle dashed to the dog and fell down, and also due
One
to a
vehicle dashed.
serious
He
injury.
fell from his vehicle.
Please, my lord.
Deceased fell from his vehicle. After that, this vehicle has come and hit the deceased. That's the story.
That is
What is the crime? That is what is the charge sheet.
That is
That's
charge
a
sheet
charge
is
sheet.
mentioned, my lord. That is charge sheet is
At
mentioned.
best, it would be a case where there would have been, the contributory negligence on the deceased. But you cannot say that he has nothing to do. Had he been careful, then we don't know what would have happened. He came and hit him. That is an undisputed fact. After he fell down, he hit him.
Please.
So there is rash and negligence on the part of the
Another vehicle.
that is this vehicle, which is insured by you.
Please, ma'am.
So here what we have to see is whether there could be any contributory negligence.
My lord, I think better to remind, my lord. I think it is approved, my lord. The rash and negligent, whether vehicle is our vehicle is in order or not, my lord.
There.
Because, my lord, there is no
Charge sheet is there.
Charge sheet
is
filed
there,
4% against 4%.
Who are the 4%?
Rider of the 1205, my lord, and deceased, and owner of the both the vehicles, my lord.
That is like.
And rash and negligence, my lord, deceased and.
Why now, even if
My
you
lord.
demand, nothing is going to happen. No, it has to be. What is the? We will fix 50-50%.
My lord, if it is contributor negligence is there, my lord. But
That's
first,
why we
my
will
lord,
fix
they have
contributory
filed.
negligence.
There is also, my lord, negligence, rash and negligence. 166 claim petition is also wrong, my lord. 166 claim petition is also wrong, my lord. Because it is proved that, my lord, he is also negligent.
According to you, in every case of contributory negligence, 166 is not maintainable. How can it be?
That is, my lord.
No. What is the compensation that is awarded?
Please, my lord.
My lord, picture perspective is not.
To appear for the claimant.
Picture perspective and
My lord,
income.
9,70,000, my lord.
Huh?
The 9,70,000 is awarded, my lord.
Let's see what is the age.
My lord, age is about 27 years. Death of bachelor, my lord.
Is a bachelor.
Bachelor,
Which year is the
claim by
accident?
parents, man. Claim by parents, man.
Which year is the accident?
Accident occurred on
2017,
2017, my lord. 17. The tribunal taken, my lord, income, 9,000 is taken income, my
We'll
lord.
take 10,250.
10,250, my lord. Into 12, into 7,
Divided by the 40% future prospects,
into 17.
4,100.
And there is no appeal on the part of
Lord, one
claimants, my
submission,
lord.
my lord.
Hmm.
Now, my lord, insurance company have no liability, my lord. They get some one opportunity, my lord, whether it is liability is fixed upon the insurance companies or to take defense before, my lord.
Vehicle is an insured vehicle. Where is the
Insured vehicle,
denial?
my lord. There is no law, my lord. But our contention,
For this court, if your vehicle
please,
is not insured.
please consider our contention.
Insured vehicle, my lord. Only there is no DL,
Yes, yes,
but
I understand,
insured,
I
my lord.
understand. What is the multiplier?
17,
17, my lord.
17 multiplier is there. Ma.
It comes to 14 lakhs 63,700 loss of dependency.
Please, man.
Future perspective.
Parents or the claimants.
Parents.
So 88,000 consortium, 36,000 funeral expenses.
My lord, 40,000, 40% future perspective.
I have taken, that's why it has come.
Please.
My lord, another contention, my lord. Respondent number 2, our insured vehicle, my lord. He is also not having the DL, my lord. There is also not, I am not liable. The owner pay.
That's what I
pay and
said.
recover.
That's
Please,
what
please.
I said.
That is it.
It comes to 15 lakh 97,700.
Please, ma'am.
50% of the
50%.
liability. That is on part of me.
It comes to 7 lakh 98,850.
Please, ma'am.
Compensation.
50-50 is there. Contributed.
The owner of the vehicle is before this court, agreed with award passed in MVC number 5 and 3 of 2018, dated 10th February 2021, whereby the tribunal has granted an amount of rupees 9,70,000 as compensation and held that. Where is the liability aspect?
Please, my lord. In last paragraph. Page number 15, my lord. In page
The
9.
owner alone is liable to pay the compensation as the driver of the offending vehicle is not having a valid driving license. The facts of the case are on 17/2017 at about 11 a.m. The deceased was proceeding on the motorcycle. At that time, a dog crossed the road and the deceased lost his control. Thereby, the said motorcycle was hit. The deceased fell down. At that time, the rider of the motorcycle bearing registration number KA27Q1205 drove in a high speed, rash and negligent manner, endangering to the human life, lost his control and dashed to the deceased motorcycle and caused the accident. Due to the impact, the deceased sustained fatal injuries. Therefore, he went into coma and immediately was shifted to the hospital, wherein he got first aid and shifted to another hospital. There he succumbed to the injuries on 10/10/2017. The charge sheet the charge sheet is filed, wherein the charge sheet is filed against the deceased, the rider of the offending vehicle, and both the owner of both the vehicles.
Both one.
When it comes to the compensation, the tribunal has considered the income at
9,000.
Income 9,000.
9,000.
9,000 and granted the compensation. Next part. When counsel appearing for the owner of the offending vehicle submits that there is a contributory negligence on the part of the deceased. Deceased was not having a valid driving license, and the court had failed to consider the same and fixed a contributory negligence on the deceased. It is submitted that the What is the other contention? It is submitted that there is a policy, valid policy, and the insurance company is liable to pay the compensation. When counsel appearing the insurance company submits that the insurance company is not liable to pay the compensation as there are clear violation of terms and conditions of the policy.
Please.
The tribunal has rightly fixed the liability on the owner of the vehicle. And counsel appearing for the claimant submits that there is no contributory negligence on the part of the deceased, but it is because of the rash and negligent driving of the rider of the offending vehicle, the accident had taken place. And the tribunal has rightly considered. It is submitted that the tribunal, when it comes to the compensation, has failed to grant a reasonable compensation. This accident had taken place in the year 2017, but the court had taken the income at 9,000.
10 to 50. 10 to 50.
9,000 correct, madam.
Taken the
Tribunal
income
taken.
at 9,000. It is submitted that. In fact, though he has not filed the appeal, when the court is looking at the quantum, the compensation needs to be enhanced. Next part. Having heard the counsels on either side, there is a material non record. There is no dispute about the charge sheet that is filed against the deceased, the owner of the vehicle on which the deceased is proceeding, and also owner of the vehicle and the driver of the offending vehicle.
My lord, insurance company one contention, my lord. Our insured vehicle not at a involved in the accident ಅಂತ. ಅದರಲ್ಲಿ ನಮ್ಮ second our insured vehicle, then later add that.
Make some submissions out of the record.
Please, charge sheet is there, my lord. Charge sheet is there, man. Only for contention.
We can't take that kind of contention at all. What did you write? So as per the same, the deceased fell down and later the offending vehicle has come and hit the deceased. There is a contributory negligence on the part of the deceased, which was not considered by the court. In the considered opinion of this court, there is a 50% contributory negligence on the part of the deceased. Then it comes to the liability. In the light of the law laid down in Sharan Singh's case, as a vehicle is insured, even if there is no driving license, still the insurance company is liable to pay and record the same from the owner of the vehicle. Coming to the compensation, this accident had taken place in the year 2017, and as per the chart prepared by the Legal Services Authority, the income has to be taken at 10,250. 40% future prospects would come to 4,100, and the income is 14,350. As he is a bachelor, 50% has to be deducted. Then his contribution to the family would be 7,175 into 12 into 17. And the loss of dependency, it comes to 4,000. 14,63,700. Towards loss of consortium, 88,000, and funeral expenses, 36,000. Altogether, it comes to 15,87,700. As 50% contributory negligence is fixed on the deceased, the 50% amount comes to 7,88,850. The said amount is liable to be paid by the insurance company, and they shall record the same from the owner of the vehicle.
Please.
Yes.
Please, madam.
Amount in deposit, my lord.
The amount in deposit shall be forthwith transferred.
Please.
Please.
Appeal is partly allowed. Yes.
Please.
Lordships, I am appearing for the appellant, your lordships. There is a content appeal. One appeal is disposed, your lordship. This is another appeal. It is a case of injury, your lordships. Is a pillion rider. Lordship, the date of accident is 27/2/2000.
So come to the table.
Please.
Lordship, 30,000 has been awarded as a global compensation, your lordships.
Injuries are my tenderness, my lord. Tenderness injury is there.
There are two MVCs. Which
Two
MVC is this?
At 953, my lord. MVC, my lord.
953.
Para number 953.
953, your lordships.
953.
Para number 23, my lord.
Para number 23, page number 24, your lordships.
1 minute.
Mark P6 is the wound certificate, petition
Wound
sustained.
certificate which is
Three-
marked as,
three-
please read.
Severe
Pain and tenderness present over the right sided chest.
and small wound.
Small wound.
Right parental reasons.
Tenderness
Is
and as per the
tenderness is
opinion of the
there.
doctor, one is grievous.
Globally, 30,000 tribunal is awarded.
This page is contented the death for grievous. Where is the question of this incurring 2,50,000? We'll grant it globally 50,000. Because for the one grievous injury is there, for that 40,000 under the head of pain and suffering is entitled. We'll make it 50.
No, but if it is fracture is there, my lord, it comes that is.
It comes to?
When it is fracture, my lord, then pain, suffering, amenities are different.
That's, we'll grant it, there's a grievous injury, 50,000.
Out of, please.
Read with our about passed in MVC number 954 of 2018. Dated 2nd March 2020, the claimant is before this court seeking enhancement of the compensation. The tribunal has awarded a global compensation of an amount of rupees
30,000.
30,000. It is a case of the claimant that the claimant had sustained 3 injuries, that is severe pain and tenderness over the right sided chest, small wound 2 into 1 centimeter size present over the right parietal region, and tenderness present over the right hypochondriac region.
Hypochondria.
And as for the opinion of the doctor, injury number 1 is grievous and injury number 2 and 3 are simple in nature. It is a contention of the land counsel for the petitioner that he has incurred 2,50,000 towards medical and other expenses. But the tribunal has not considered the same. Land counsel appearing for the respondent insurance company submits that though it is stated that he has incurred expenditure of 2,50,000, no evidence is placed before the court, and the court had rightly granted 30,000 as global compensation. Next part. Having heard so and so. Considering the fact that the petitioner has sustained 3 injuries, and among that 1 injury is a grievous injury, this court deems it appropriate to grant 50,000 as global compensation. Accordingly, the appeal is partly allowed. Yes, next.
Much obliged, Your Lordships. Your Lordship, the matter needs to be connected in this appeal, Your Lordship. There is another matter needs to be connected, Your Lordships.
Connected matter of insurance company or the claimant?
Claimant, Your Lordships.
That need not be. We can independently dispose of this. Who appears for the respondent? Lakshmikant Reddy.
We are for the respondents.
Huh?
We are for the respondents.
Then where is the counsel for the petitioner? Appellant.
11, I am for the appellant, madam. I am for the appellant in serial number 11. And the liability is under challenge, no question of withdrawal, my lord. If they are ready, I will argue the matter.
Please argue. You can argue.
Yes, my lord. The main contention of the insurance company that the person, the deceased, was standing on the trolley, and he fell down and sustained injuries. If he is traveling on a trolley, the company, there is no liability of the company.
Please come to the award, how the court had discussed it.
Yes, my lord.
Let's read issue number 1.
Issue number 1. That is on page number 6 of the judgment, para number 9. The petitioner number 1 PW1 has given her evidence in the form of affidavit. She has reiterated the facts of the petition in her chief examination. She stated that on ill-fated day, place and son was proceeding in the tractor and trailer bearing registration number K with the K06 TA 8486 and K34 T8438 from Ibrahimpur towards Siruguppa. After unloading the gravel, the respondent number 1 being the... My lord?
Now, according to you, the deceased was standing on the trailer.
trailer, step of the
Where is,
trailer.
what evidence, what, now, this contention of yours is
Yes.
contrary to the charge sheet. So basing on what you're making the
No,
submission.
my lord,
and
my
what
lord,
is the
charge sheet,
evidence on record?
charge sheet is there. Charge sheet it is not against me. He is standing on the that trolley. Charge sheet, but it is in Kannada, my lord.
Where will he, no. If he's a labor for loading and unloading, where will he sit?
He has to sit in the trailer, not in the not in the trolley. That is a step of the trolley, trailer. He has sit in the trailer.
Where is the charge sheet?
Charge sheet is a exhibit, my lord.
You can read and tell the court.
Yes, my lord. My lord, it is Xerox copy is very not readable. I will get the some
It's
other.
matter of 4 weeks. Yes. Yes, next. In that case, clear case. Yes.
Appearing for the appellant. My lord, the one more connected matter along with this.
We can also, once this is disposed of, it will come.
My lord, the corporation challenging the quantum and negligence.
This is your appeal.
My lord, this is my appeal, and another appeal also filed by the corporation. That is the rider of the motorcycle. He is a pillion rider. Both are minors. Accident took place, my lord. Entire liability has been saddled upon the.
Post along with so and so next Thursday.
Please.
Yes, next 13.
Let's in the serial number 13, my lord, I appear for the respondent number 5, my lord. I request my 1 week time to my lord. My relative is not well. I am out of station, my lord. Next week, my lord, kindly have
This is
it.
filed by whom? Filed by the claimant.
Yes, ma'am.
Seeking enhancement.
Madam? No, madam. I am the appellant. The tribunal passed the aggrieved judgment and award against the rider of the vehicle. The compensation paid by the rider of the vehicle. So I have challenged
Who are
this.
you are a claimant or you are a owner of the vehicle?
No, no, I am rider of the vehicle. The judgment and award passed against the rider of the vehicle.
Rider of the vehicle means I am not able to understand. Now in a motor vehicle
Yes,
claims, either it will be a claimant, it will be the
Yes,
owner
ma'am.
of the vehicle.
That is, we have questioned here. The tribunal passed the judgment and award against the rider of the vehicle, containing that the owner of the vehicle sold to the rider in an exchange, madam. Considering that the award passed against the rider.
My lord, I request a week's time, my lord, next week, my lord.
Yes, next.
Public.
Here for respondent.
Yes, we'll hear it. It's filed by the
Claimants filed.
claimants. You are for the
Insurance company.
insurance company. It's a case of death or injury.
Case of death, my lord.
What is the age of the claimant? Deceased?
54 years.
54.
54 years.
How many are the claimants? Dependents?
Dependents, my lord, are considering the three, my lord. Major
For
sons
them?
as we consider, my lord.
Let's see who are the claimants. Mother 45
Mother
years.
and wife and children's, my lord.
Three in number.
Three numbers, my lord. Major sons, my lord.
Huh?
2 and 3, major sons, my lord.
But they have to be, they are just 24 and 23. They have to be considered. So, which year is the accident?
10%.
Which year is the accident?
17.
2017.
10,250.
Yes.
One third has to be deducted.
Yes, there are 3 dependents.
It comes to 4783. What is the multiplier?
11. 11.
Huh?
11.
11. It comes to 12,62,844 under the head of loss of dependency.
Please.
Consortium 3 into 44.
Yes.
Lakh 32,000.
Please.
36,000.
Please.
10,000.
There's medical expenses to the tune of 1,18,000.
How much?
1,18,000.
1,18,000.
Please.
It comes to 15,58,844. How much is granted?
What did my lord do? 7,16,000.
Court had considered the income how much?
8,000 million.
8,000. And children were not considered as dependents.
No, my.
Please come.
Please.
Agreed with award passed in MVC number 119 of 2017 dated 2nd December 2019 by so and so. The claimants are before this court seeking enhancement of the compensation. The claim petition was filed seeking compensation of an amount of rupees.
7,16,000. 7,16,000.
How much you claimed?
Claimed, my lord, I have claimed 18,50,000.
18,50,000 for the death of the deceased in the accident. The tribunal, the claimants are wife and 2 sons. The tribunal has not considered the sons, not necessary. The claimants are wife and 2 sons. The court considering the income at 8,000 and not considering the children as dependents had granted the compensation as per the table given below at paragraph number 17 extracted. Then counsel appearing for the claimant submits that the children are 23, 24 years and the court ought to have considered them as the dependents. This accident had taken place in the year 2017. Court ought to have taken 10,250 as income and under all other heads also the compensation that is awarded other conventional heads is not a just and reasonable compensation. Then counsel appearing for the insurance company submits that the court has rightly considered the major sons cannot be considered as dependents. Court has rightly taken the income and there are no grounds to interfere. Next, having heard so and so. The dependents are wife and 2 children. They are aged about 23, 24. Just because they are majors, that itself cannot be a ground for the court not to consider them as the dependents. This court is of the view that they shall be considered as the dependents of the deceased. Even the Honorable Apex Court in Seema Rani's case reported in so and so considered the same. Then coming to the income, the accident had taken place in 2017. Hence, this court is taking the income at 10,250. As is, he's 54 years old.
54 years, ma'am. 11 is the multiplier.
No, no. Rika, come here. 40% is taken, that's why the difference has come. Into 1 divided by 50 comes to minus 10. It's coming to 12,88,000.
Please.
I've done 44%, 40% future prospects earlier.
Yes.
What did you write? We're taking the income at 10,250, considering the age of 54. Future prospects at 10% would come to 1,025. His income would be 11,275. As there are 3 claimants, 1/3 has to be deducted towards the personal expenses. That is 3,758. Then the contribution to the family is 7,517 into 12 into 11. Under the head of loss of dependency, it comes to 9,92,244. Consortium 3 into 44, 1,32,000. Funeral expenses 36,000. Medical expenses, which are already granted, 1,18,000. In the light of the law later on in make allowance so and so 10,000. Altogether, the claimant is entitled for an amount of rupees 12,88,244. Accordingly, the appeal of the claimant is partly allowed, enhancing the compensation from 7,16,000 to 12,88,244. Enhanced amount shall carry 6% interest. Yes, next.
Oh, please.
State's appeal, Your Lordship, challenging the liability, Your Lordship.
All are served.
Please, Your Lordship, all are served, Your Lordship.
Come to the
20% liability is posed on the government, Your Lordship. The only reason is, Your Lordship, we have put the speed breaker is for insurance company.
I am appearing for the insurance company. This matter is covered by judgment, my lord.
Which is the judgment?
In fact, it is an order passed by the Honorable Supreme Court. No liability can be fixed for the government. It is squarely applicable to the facts of this case. So it may be disposed of.
Why the liability is fixed on the government?
In this case, my lord, there was no speed breaker.
No, in our case,
speed breaker was there. Speed breaker was there, and the claimant's case was that the speed breaker ought not to have been constructed at that place.
It is a school premises, Your Lordship. Temple is there and school is also there. For that reason, PWD department, who is the
So the motorcycle jumped over that.
Pillion.
The liability is fixed on.
Fixed on 20%. Please, Your Lordship.
Yes, yes, yes.
80% on owner, Your Lordship, 20% is.
So now the 100% has to go on it. What about
100% will have to be on the owner of the motorcycle.
Why you on
Because the policy did not cover, my lord, the pillion rider who fell from that and died, my lord.
It's an act policy.
Act policy
Act
only.
policy.
The agreed with award passed in MBC number 474 of 2017 dated 13 February 2020 by so and so. The Assistant Executive Engineer, Public Works Department is in appeal. The facts of the case are on 1/8/2016 at about 11:30 hours. The respondent number 1, the deceased were proceeding in a bike from were proceeding in a bike. The respondent number 1 was riding his bike and the deceased was a pillion rider. When they came near Baili Basappa temple, the respondent number 1 drove his vehicle negligently in a high speed without observing the conditions of the road, and as a result jumped the vehicle against the speed breaker constructed there. Due to it, the deceased was unseated and fell to the ground, sustained grievous injuries, in which he succumbed after 8 days of the treatment. The court had held that the accident had happened because of the rash and negligent driving of the rider of the vehicle.
Right. In the present appeal, respond number 5, Your Lordship.
Rider of the vehicle.
To the extent of 80%.
Rider of the vehicle. When it comes to the liability, the court has held that the vehicle, as it is a act policy, the owner alone is liable to pay the compensation and fix the liability at 80%. When it comes to the appellant here, and where do you get it?
Page number 31, in page 15, Your Lordship. Next page, 16, the respond number 1 shall pay, next page, Your Lordship, the respond number 1 shall pay 80% compensation
When is the
amount.
finding?
Finding page number, para 15, 16 and 17, Your Lordship.
As there was a speed breaker, the court observes that the user of the road cannot presume the existence of road humps. On the contrary, they presume that the road is free from such humps. And even if humps are there, there would be cautions apprising them about it. Hence, heavy duty was on the appellant here and to see that the humps on road are readily visible and the users of road are put to its notice. By not putting caution signs and making zebra markings on the said hump, the appellant herein has committed breach of duty to take care of the users of the road, and accordingly, the liability fee is fixed at 20%. Learned HCGP appearing on behalf of the appellant submits that in a motor accident claim, the liability ought not to have been fixed on the government, relied on the judgment of the apex court. In case of Government of Karnataka versus Cholamandala MS General Insurance Company Limited and others, arising out of civil appeal number 5783 of 2019, dated 15/3/2023, wherein the Honorable Apex Court has observed that the apex court has found fault with the High Court in fixing the liability on the government relating to relying on the judgments of parent patriot jurisdiction. The apex court has further observed that in a claim petition that is filed under section 166 of the Motor Vehicles Act, where the compensation was to be determined by rendering a finding with regard to the negligence and the quantum of compensation that is to be paid, as also the liability based on the terms of the contract relating to insurance. In any event, the appellant state, not being a party to the said transaction, could not have been made liable, and accordingly set aside the order passed by the High Court. It is submitted that as such the liability fastened on the state is without any basis, and the same has to be set aside. Land counsel appearing for the insurance company also supports relying on the judgment submits that there is no liability, there cannot be any liability to the state, and as it is an act policy, the tribunal has rightly fixed the liability on the owner. However, it has to be 100%. The having heard so and so in the light of the law laid down in the government of Karnataka above referred judgment, and the fact that this case is arising out of a motor accident claim. And in the light of the judgment, the tribunal ought not to have fixed the liability of 20% on the government. Accordingly, the appeal filed by the government, the appeal of the appeal is allowed, and the entire liability is fixed on the 100% liability is on the owner of the vehicle to pay the compensation. Accordingly allowed.
Please.
Please, madam.
You must have deposited the amount.
Please, sir.
Amount in deposit, the appellant insurance company, the
State.
appellant is at liberty to withdraw.
Please, Your Lordship.
Yes.
Insurance company appeal by on negligence aspect, my lordship. Pillion rider of the motorcycle died. When the rider of the motorcycle drove the same in rash and negligent manner and dashed against auto rickshaw. Auto rickshaw is insured with the appellant United Insurance Company, my lordship. Motorcycle is insured with National Insurance Company, my lordship.
You are representing auto
I
rickshaw.
representing United Insurance Company, insurer of the auto, my lordship. The FIR is filed against the rider of the motorcycle only. FIR is filed by the driver of the auto rickshaw saying that in a curving, he came in the wrong side and dashed against the auto rickshaw. And after investigation, also the charge sheet is filed only against the rider of the motorcycle. In spite of that, my lordship, the tribunal held that without any basis, no eyewitness is examined.
Day
No.
after tomorrow, my lords. Day after tomorrow, my lords.
Why?
Some documents required, my lords.
What documents are required? If some documents are required, this is an advance list, isn't it? You are aware of this.
Senior.
This list is given only for this purpose that you don't, none of you ask for adjournment like this. Where is your senior?
Senior is engaged.
Ask him to come.
Pass out.
Pass over.
I am for the respondent in this case. I represent the respondent.
Claimant's appeal, case for not the death, seeking enhancement.
Yes. What is the age?
Age not is 20 years.
Unmarried?
Yes, ma'am, she is unmarried.
Which year is the accident?
2016 not is the accident.
How much is taken by the court?
9,000 is taken by the tribunal.
Rightly taken. I mean, more than the table it is taken.
But according to me, my lord, she was studying in BCom and also she was working. And it needs to be taken more because 20 years.
What do you say?
My lord,
And
there is no
another-
necessity because nothing has been produced before the court regarding that. No documents.
If you want, if you have not produced anything, we'll remand the matter. If you have not produced anything, we can't assume that. No, what are the?
No, marks cards have been produced.
SSLC, PUC marks card has been produced.
SSLC, PUC.
Please.
SSLC, PUC.
Yes, ma'am.
What about BCom?
The BCom nurse, she died. She was studying in first year. They did not produce it. She was coming from Bangalore to Ballari, madam. She sustained injuries and thereafter she died. And apart from income, madam,
We have to consider her qualification as PUC.
yes. And other ads, madam, conventional ad, only 15,000, madam, is.
That we will. Please
Yes.
come, where is the table? Where do you get the table?
But the income aspect, madam, will.
On page number 21 of the judgment.
So, as far as loss or dependency is concerned, will not interfere. 30,60,800.
Yes.
Mother and father or the,
Claimants.
yes, 4 into 40.
In fact, madam, other total, madam, in all 5 children's. 5 sisters of the deceased. She is one among them. 4 sisters were, they are not impleaded because at that time they were not dependent. Now in view of the Pranay Sethi judgment, my lord, They are also entitled for compensation to the filial love and affection.
They were not parties. What we can
Yes,
do.
yes, I do agree, but
46.
on record, in the evidence it has come that
That's for you to take it, to do that exercise and whatever required. We cannot grant it, assuming something. It's coming to 14,94,800. Please come.
and conventional ID is concerned, every 3 years, 10% is to be made.
Taking 44,000. 44.
That's right, but not 44. It has to be taken 30%. Lordship has taken 10%. If Pranay Sethi judgment is coming there 2017, 31st October. Every 3 years, 10% is to be taken, my lord, is
Will come.
30% is to be taken, my lord.
That's what, how much it will come?
Accident is of 16.
2000?
16, my lord. Adu ಬರೋದಲ್ಲ ಅದೇ, because
2016. So in
16.
2016, what was the convention, what was the amount? 36, sir? Or what was it? In Pranay Sethi's judgment, how much was granted as
10% extra.
what was the amount?
10% in the judgment itself.
No, my lord, I
40,000.
will explain.
40,000 and 50,000. 15,000. 40,000 for love and affection. 15,000 for transportation and in all
That was not
30,000
fair.
is to be awarded.
Because this is
Transportation.
prior to Pranay Sethi. Prior to Pranay Sethi.
Funeral expenses, 36,000 I have granted already.
But it
How
will
much
not
I
be,
have to
my lord.
pay? Tell the court what it is.
30% is to be added.
Nineteen is the
16,
judgment.
3 years it is.
19 is the judgment. 3
When
years.
is the judgment?
19. 31/7/2019.
17.
No,
17,
judgment
Lord,
is
not
19.
17.
Judgment is
Sorry,
19.
17 it is there. I can.
Which year is the judgment? Pranay Sethi?
19, my lord.
17.
31/7/2019.
He's giving the date also, 31/7/19.
19.
No. You lordship kindly see it is extracted in the judgment itself, page 22. Let us be clear about the year. We should not mislead the court. Last line in the down of the page.
Which page?
22 my lord, of the judgment. Page 22. Last line. Pranay Sethi judgment, 31st October 2007.
2017. Therefore, I am telling. Only 2 years. After judgment, it is only 2 years, even not 3 years. Therefore, there is no question of enhancement.
It has to be 10%. So 31/11/2017 is the judgment. So 18, 19, 20. So 10% is how much was taken in the Pranay Sethi's judgment?
40,000 is taken.
40,000. No additional.
No addition was made because that was the.
At that time, it is 40,000. From 2017 onwards, every 3 years, 10% extra. Every 3 years means it is 2020. Thereafter, 2023. Of course, 26 is not come. Of course, 30%.
No, not like that. Not like that.
Yes.
Date of judgment.
20% comes to
48,000 for the.
Not the judgment of this court, my lord. It will be judgment of the tribunal.
48,000.
It may be the judgment of the tribunal, not to be taken till it is disposal. Because the judgment of the tribunal has been passed in 2019. Even it is not 2 years. It is 3 years only. Therefore,
Not
only
about judgment
10%
of the
will be
tribunal.
applicable as per Pranay Sethi.
Whenever an appeal comes, we were granting as on the day what it is. We will never look at what it was on that day. So it comes to 48,000. Then under other heads, it is 30,000.
30, 30 plus 20%.
Huh. 1 minute, 1 minute. 30,000.
36,000 plus 48,000
36,000.
plus 48,000.
I'm already granting
Yes, yes.
36,000 under the head of funeral expenses.
Yes.
So now it will be 48. Today, whatever is dictated in the earlier orders also, 48, 36. Till the other one also. So 48,000 into 2. It comes to 96,000. 36,000 and 10,000. In fact, I was thinking when I came to Karnataka in 2023, I started this 44. The same thing is continuing.
But it has to be changed from every 3 years, 10%.
Correct.
In fact, it will be 30%. It will be 30%.
30% time is there till 2011. After 3 years, after 2011, we'll see that. I mean, 2026, 11th month. So it's coming to 15 lakh 2,800. The
In this,
payment
our
is
liability is
that.
only 40%, my lord. Respondent number
Remaining
3,
liability is only
60% is on the my line fund.
other insurance company.
Yes, other insurance company.
40 on me.
The claimant is before this court seeking enhancement as a compensation agreed with about passed in MVC number 845 2016 dated 31st July 2019. The tribunal has granted compensation. Where is the table?
Para number 21, my lord. Is page number 21. Para number 24.
Paragraph number 24. When it comes to the liability, the court has held that both the court has observed that the offending vehicles involved in the accident in question or belonging to the respondent number 2 and 4 respectively, and they have also admitted to the fact that the offending vehicle in question as on the date of the accident and the said vehicles were insured with the respondent number 3 and 5 respectively. And the court has fixed the liability on the third respondent at 40%. On the fifth respondent, 60%. The insurance companies have not filed any appeal. Learned counsel appearing for the claimant submits that the deceased was aged about
20 years.
20 years and she was pursuing her BCom first year. The court had taken the income at 9,000 and it ought to have taken the income at 15,000. It is further submitted that under the conventional heads, the amount that is awarded by the tribunal is not just and reasonable. It is a contention of the land counsel for the petitioner that the Honorable Apex Court judgment in Pranay Sethi versus so-and-so, as of the year 2017. And as per the judgment, every 3 years, the 10% enhancement shall be there towards the conventional heads. It is submitted that by 2026, 2011, it would be 9 years. As such, 30% has to be taken as that 30% enhancement has to be there. Next paragraph. And counsel appearing for the respondent insurance companies submit that the court had granted a reasonable compensation, is not entitled for any enhancement. Further, the Pranay Sethi's judgment is in the year November 2011, whereas till the 30% will be only after 2026 November.
Pranay Sethi 17.
17. November. 17th November.
31st October 17.
31st October. It will be only in the month of in 2026. But now it can't be considered as 30%. Next para, having got the counsels on either side, there is a material not defined. As far as the loss of dependency is concerned, the certificates that are placed before the court as about the PUC certificate. Court had taken 9,000 and this court do not find any reasons to interfere with the same. Hence, under the head of loss of dependency, this court is not interfered. Coming to the other heads, as rightly argued by the learned counsel, the prenance is the judgment is in the year 2017. And the 2017, October or November?
31st October.
October, 31st October 2017. And every 3 years, it has to be a 10% enhancement. According to the petitioner, it has to be 30% enhancement as it is till 2026. It will be as we are still in February, still in January. This court is inclined to consider the 20% enhancement under the conventional heads. This court is granting an amount of rupees towards loss of consortium, 48,000 and into 96,000. Funeral expenses, 36,000. And in the light of the law laid down in so and so, 10,000. Altogether, the claimant is entitled for an amount of rupees 15,02,800. The appeal is accordingly, appeal is partly allowed, enhancing the compensation from 13,90,800 to 15,02,800. In that, the third respondent insurance company shall pay 40%, and the fifth respondent insurance company shall pay 60%.
And delay, there is a delay in filing the appeal, my lord. The delay is condoned without interest.
If there is that delays on that, yes, they are not entitled. Yes, next.
The interest, no,
6%. Enhanced amount shall carry 6%.
much.
Yes. Take this.
Lord, here is an appeal by NWK Secretary, wherein we are challenging the finding basically on quantum, though the negligence aspect is also asserted as contributing negligence.
Please come to the table.
My lord, here a lady, a spinster lady of 63 years old, she was traveling in the KSRTC bus.
60, what is the age?
63 years, spinster.
And the court had taken?
And she was traveling in the KSRTC bus. Before the bus could be stopped, she tried to alight from the bus and fell down, sustained the fatal.
No, you are questioning on the ground of
Both negligence and quantum. But here I will confine my argument to the quantum only.
Quantum. So
For the facts I am telling about this.
For that, please give the details.
Yes,
That's
madam.
sufficient.
Here, my lord,
She is-
we can
One minute. She's
re-
63
refer to
years
the
old.
quantum internal page 10, para 12. May I read that, my lord? Loss of
Not
dependence.
necessary. If you
So
can
here,
give me,
no, what I mean is,
counsel, if you can give me the particulars, that will make the things easy.
I'll
So
tell.
please tell the court, the age is 63 years.
Yes.
How much is considered as the income?
The facts are different, my lord.
10,000
Here,
is taken.
here,
10,000 is taken.
the lady.
From 10,000 is taken.
10,000. Which year is the accident?
2017 loss.
My lord, I'm permitted to argue.
Yes.
Here, the lady has gifted his property by stating that you are the person who is taking care of me. I have also faith on you that in future also you will take care of me. That has come in the judgment also. But in spite of that, having been taken care by you, you cannot set yourself to be dependent on that lady. She has gifted the property, whatever she was owning. That I'll read the English translation on this thing, page 11. Just para 12, I'll read this. That will give a clear picture, my lord. The petitioner has contended that the deceased Shantawad, daughter of Fakir of Belgi, was his sister, and she was remained as spinster during her lifetime. It is further contended by the petitioner that the dependency was constituted among him and the deceased during her lifetime. But the respondent has seriously disputed the claim made in this regard. The petitioner has produced the gift deed and got marked those documents as P10 and 11. Those documents discloses that the deceased gifted the property involved in the gift deed in favor of the petitioner. Herein, in the body of the gift deed is mentioned. So Kannada is there. I read in English what I've done. You are my own brother. I have much love and trust on you. I am unmarried and I'm getting old. In this age, you are looking after me nicely and I have trust on you that in future also you will look after me nicely. Your life should be good because of me. This is Kannada translation. Further, I read English. The aforesaid recital documents clearly indicate that the dependence was constituted among the petitioner herein and the deceased. Therefore, the stand taken by the respondent in this regard is not tenable, and the defense falsified by the petitioner by producing the reliable document. As such, the petitioner is entitled to claim a compensation under the law due to the death of the sister. Here, the 11th para read, my lord. The deceased has gifted the properties which are held by her in favor of the petitioner here in Exhibit 10 and 11, and she has not retained any property. Then it shows that the deceased depend on the petitioner herein for her livelihood and services. So when she was dependent on her husband, on her son, and with the love she has gifted you property, now you cannot claim that the deceased was burning a vegetable vendor and earning, and I have lost the dependency. So whether it can be considered, madam, because you were looking after her, that's why she gifted the property you. Now you come with the case that she was earning and you are dependent. How it could be? When you come to the conclusion, the finding is also to that effect. So she is not at all a dependent. Here the MACT has considered the income of deceased at 10,000 and deducted 50% and awarded 4,20,000 on the head of loss of dependency. That cannot be done. At the most, he is entitled for filial consortium to the extent of 40,000, not on the loss of dependence, because you are taking the care of her.
Who are you?
You are the son of 53 years old, alleged to be dependent on a sister of 63 years old. You are never. So here he is entitled only on the head of loss of filial, this thing, not loss of dependency or even loss of state. Because whatever the state she has given to you in her lifetime. So even the loss of state cannot be considered. So I submit the court that the amount of is 4,20,000 awarded on the head of loss of dependency. She is not entitled. At the most.
What do you say about Manovalgan's case?
He was not a dependency because he was second layer here, but he is the second layer. He is the brother of the deceased, Lordship. The petitioner is the brother of the deceased.
Yes.
Deceased was his sister, and he was produced the gift deeds, Lordship. It is that she mentioned that she is unmarried. She was lived along with his, and she also stated that her lifetime also she is along with him. As per the deed, he is stated in the English translation. That's why, Lordship, the tribunal has taken he is the dependency because he is unmarried, and she has only another 3 sisters are there. They are also died, Lordship. Only she is there. She is living.
How will you become dependent on her with your age of 40 years?
Please, Lordship. She stated that she was about the age of 63 years. She is unmarried. That's why she is living along.
Unmarried, you will be dependent on her.
Please. But that's why, Lordship, he was become the second legal heir. Loss of estate, one
Thought as per Manovalgan's case.
please, loss of estate you taken. One fourth of the dependency, Lordship, and other heirs, Lordship. And tribunal has taken 10,000, Lordship, as per chart of 10,250 has to be taken. This 2017 accident.
How is the calculation to be made as per Manovalgan's case? 10,250?
10,250, and the dependency comes to 4,30,000 to 500, Lordship.
10,000 has been taken as income of the lady, madam.
Total comes to 4,30,500, Lordship. In that, 1/4 has to be taken. That comes to 1/4, Lordship, dependency.
How much was the loss of dependency?
Dependency 4,30,500, Lordship. It is
4 lakh, where do you get it? 4,20,000.
Please, it comes 4,30,000 because they have taken only 10,000, Lordship. 10,250 you have taken as per chart.
50% has been deducted towards personal expenses. If 1/4 is taken, it is to made half. So it will be about 2,25,000.
12, what is the multiplier?
Multiplier 7, Lordship. Age 63 years.
Multiplier?
7. It comes 4,30,500. 50% deduction.
50 is all.
You said 7 is the multiplier. It comes to 4,30,500.
Please.
Here the income was taken to the extent of 10,000. So deducted 50%. Now if 1/4 is to be taken, then it comes to 25,000. 25. And this thing, half of the what has been awarded under this thing, not 4 lakhs. Because 50% is taken, the amount is coming to 4,20,000. So if 1/4 is to be taken, it will again be deducted. It will be 2,10,000 because 1/4 loss of state.
10,250 is the income.
Please. Yes.
50% comes to
1/4 loss of state, 1/4 of the income is taken, not 50%. He has taken 50%. So it will be 4,10,000 under the loss of dependency as against 4,20,000, 2,10,000.
two lakh 15,208.
Please. Yes.
Plus the loss of the estate
8,000.
48 plus 36,000.
36,000.
Please.
It's coming to 3,09,208.
Please. As against 4 lakh.
The insurance companies before this court agreed with the award passed in MVC number 1739 of 2018, dated 19 November 2020. The claim petition is filed seeking compensation of an amount of seeking compensation for the death of the deceased in the road traffic accident that took place on 23/9/2017. It is a case of the claimant that the deceased was his sister and she remained as a spinster during her lifetime. It is his case that the dependency was constituted among him and the deceased during her lifetime. The court had considered the dependency and taken the income at 10,000 by deducting 50% towards her personal expenses, has granted compensation of an amount of rupees 4,95,000 as per the table given below. Table is at paragraph 20, extraction. Then counsel appearing for the insurance company submits that the deceased is aged about 63 years and the claimant is a brother who is aged 40 years. He cannot be considered as a dependent of the deceased.
Claimant was 50 years old. Brother.
40 years, I think.
No, because he has given the evidence when he was the age of 52 years.
So it doesn't matter.
No, that is wrong. It has come.
As per the cost title, I'm looking at
Okay.
40 years and he cannot be a dependent of the deceased. The court, without considering all this, has granted the compensation. Next, parallel counsel appearing for the respondent, claimant submits that in fact, the claimant is dependent upon the deceased. This aspect was considered with the court and court had rightly granted and there are no grounds to interfere. Next, having heard so and so, considering the fact that the deceased was aged about 63 years and as per the cost title, the petitioner, the claimant is aged about 40 years. Just because she has executed a gift deed in his favor, it will not make him a dependent of the deceased. As such, this court is not inclined to consider him as a dependent and as per the law laid down in Manovalgan's case, he is entitled for the loss of dependency at 1/4. Hence, considering the income as this accident had taken place in the year 2017, considering the income at 10,250, 1/4 comes to 2,562 into 12 into 7 is under the head of loss of estate comes to 2,15,208. The consortium 48,000, funeral expenses 36,000, 36,000 altogether. Altogether, the claimant is entitled for an amount of rupees 2,99,208. Accordingly, the appeal of the insurance company is partly allowed by reducing the compensation from 4,95,000 to 2,99,208. The amount in deposit shall be forthwith transferred.
Obliged.
Yes, next. Next, on the next date of hearing for dismissal, next Thursday, no representation. Case 20.
Lordship, Serial number 19, Your Lordship. I am appearing on behalf of respondent number 2, Your Lordship. I'll have next week any date, Your Lordship.
Yes, next, 20.
Appeal by the claimants for enhancement of compensation, my lords, case of death, my lords.
Yes.
Only point is that income is taken at 9,000, my lords.
Take this, even that. Income is taken at
9,000, my lords. Accident is of the year 2019.
2019.
19.
What is your case? How much is your income according as per the claim petition? Getting income of 3 lakh per annum. Which year is the accident, you said?
2019, my lords.
13,250. What is the age?
32.
How many are the claimants?
3, my lords, wife and 2 minor children.
The multiplier. You said age is 32.
Please, my lords. Multiplier 16.
Multiplier is 16.
Income 13,000.
Comes to 23,74,460. 3 into 48. 1,44,000. 36,000.
ಈಗ ಇಷ್ಟಾಗಿದೆ ಇದು 4.
From 17 lakhs to 17,77,802. 25,64,464.
Please.
The agreed with the award passed in MVC number 894 of 2019 dated 2nd March 2021 by so and so. The claimant is before this court seeking enhancement of the compensation. The tribunal has granted the compensation as per the table given below at paragraph number 21. Extract. Learned counsel appearing for the appellant claimant submits that accident had taken place in the year 2019 and the court had taken the income at 9,000. It is submitted that on all the other conventional heads also the compensation that is awarded by the court is not just and reasonable. And counsel appearing for the respondent insurance company submits that the court has considered all the aspects and granted a just and reasonable compensation and there are no grounds to interfere. Next para, having heard so and so. This accident had taken place in the year 2019. Hence, as per the table, as per the notional income fixed by the Karnataka Legal Services Authority, this court is taking the income at 13,250 as the, any confusion?
No, madam. It's with regarding to delay, madam. I was just asking her about.
Table
Delay.
is here.
Please.
Consider taking 13,250 as income. As his age is 32 years, future prospects at 40% comes to 5,300. Then the income is 18,550. As there are 3 claimants, 1/3 has to be deducted towards personal income expenses. It comes to 6,183. Then his contribution to the family would be 12,367 into 12 into 16. Under the head of loss of dependency, the claimants are entitled for 23,74,464. Towards loss of consortium, 3 into 48, 1,44,000. Funeral expenses, 36,000. And in the light of the law laid down in Michael houses so and so, legal expenses, 10,000. Altogether, the claimants are entitled for an amount of rupees 25,64,464. Accordingly, the appeal is partly allowed, enhancing the compensation from 17,77,800 to 25,64,464. Yes, the appeal is partly allowed.
Twenty-one. I'm for the appellant one.
Yes,
Appeal by the corporation.
21 appellant is here.
Sorry. 22.
Yes.
Appeal by the corporation challenging the quantum,
Where is the table?
My lord, the discussion is at, my lord, page number 25, page number 21, my lord, para number 29.
Injuries?
Please.
What are the injuries?
Injuries, my lord, as per the, my lord, wound certificate, she sustained simple injuries. But the discharge card shows that, my lord, she sustained, my lord, fractures. Page number, my lord,
So there is nothing to dispute it.
No, my lord. She sustained, my lord, simple injuries. But the tribunal has taken, my lord, the 10% disability.
No, there must be evidence in that regard.
Please, my lord. He has, my lord, the doctor has been examined to show that, my lord, she sustained fracture.
Even the wound certificate, when they primarily examine, that's one aspect. Later, if on an X-ray is
Please.
found, so
She sustained one my lord, of fracture.
40,000 will maintain.
Please.
Next, medical expenses, any dispute on that?
No, my lord. Medical expenses, as per the bill, my lord, they have awarded the medical expenses.
27,210. How many days was in hospital?
My lord, 15 days, my lord.
Conventional heads, we will take 15,000.
Lord, my ground in this appeal is, my lord, the interest, my lord, 9% has been awarded.
You will reduce to 6%.
And, my lord, the future prospect, my lord, added by the tribunal is erroneous. 25%, my lord, future
To loss of income due to disability. Loss of income.
accident occurred in the year, my lord,
No, 1 minute. Loss of income during the laid up period. Which year is this?
2017. 10,250 is the income.
2017. 10,250 into 3. It comes to 30,750. Then now coming to the loss of future income. According to the doctor, what is the disability?
Doctor, my lord, stated that, my lord, 10% to whole body, he has stated. As it is, my lord, the tribunal has taken the 10% and awarded the compensation, my lord, by adding, my lord, 25% future prospects.
Future prospects will not grant. 10,250 into 12 into what is the multiplier?
Multiplier, my lord, 14 is the multiplier. She is aged about, my lord, 40 years.
It comes to 1,72,200.
200. As against 215, 250.
That will. It's coming to 1,83,960. 1,83,496. What was granted by the tribunal?
My lord, 3,460,000 has been awarded by the tribunal.
3 lakh?
460.
No, no. 3 lakh, 3 lakh 460. How can it be? No, no, some calculation error.
My lord, loss of future earning, my lord.
One calculation error.
Please.
72,000 plus 30,700. Comes to 2,84,000. 2,84,960. At 6% interest.
Please.
On submission. Even in case of injury, also the future prospect, even in case of injury, the future prospect has to be added.
It is that what we do with the settled law is if the disability is about 20%, then only we will add 40% future prospect.
One more thing.
Not for this one.
Not that, not one more that. In this case, the loss of in respect of amendment is concerned, the compulsion not awarded. It has to be reassessed.
Already.
Also,
No. Please
Pain and
understand.
suffering is awarded. In respect of amendment is concerned.
Loss of income during the later period is not awarded. That I have added.
They have not filed any appeal.
Amenities.
They have not filed any appeal.
It's a reassessment. Amenities will solve.
I have already granted. The tribunal has not granted loss of income during later period. I have added it to 30,000.
In respect of amenities concerned, I request to lordship.
Already, I think that much indulgence is not required. Agreed with award passed in. MBC number 289 of 2018, dated 18th March 2021. By so and so, the corporation is before this court. And counsel appearing for the corporation, the tribunal has awarded the compensation as per the table given below at paragraph number 33. Land counsel appearing for the corporation submits that, appellant corporation submits that the court had transferred the interest at 9%. The income, the court had granted future prospects on a disability of 10%. And even on the other heads also, the amount that is awarded by the court is not just unreasonable. Land counsel appearing for the respondent insurance company submits that. The respondent claimant submits that. Even though the disability is 10%, still they are entitled for future prospects. And the court had rightly considered and granted. And no, in fact, the claimant is entitled for compensation at the head of loss of amenities. The court had failed to consider the same. As such, he may be granted the compensation under the head of loss of amenities also. In response to that, land counsel appearing for the insurance company submits that. No, the corporation submits that. No appeal is preferred by the respondent, and it's not open to the claimant to argue on these aspects. Next para. Having heard the counsels on either side, there is a material on record. First, the petitioner, the first contention with regard to the interest, the claimant is not entitled for interest at 9%, and he's only entitled for interest at 6%. Then coming to the future prospects cannot be granted for a disability of 10%. Hence, under the head of loss of future income is this code, the 10,250 is taken.
Please.
This by the trial court also.
Trial court also, my lord, taken the chat income only.
This court is considering 10,250 into 12 into 14, 1,72,200. Coming to the loss of income during the later period, no amount is granted. This court is granting 30,750. Conventional heads 15,000. As he was in hospital for 15 days, this court is granting 15,000. Medical expenses as it is, and pain and suffering as it is. As such, the claimant is entitled for an amount of rupees 2,84,960. Accordingly, the appeal of the corporation is partly allowed by reducing the compensation from 3,460,000 to 2,84,960. The interest on the entire amount is at 6%.
Please.
Accordingly, the appeal is partly allowed.
Please.
Yes.
Serial number 22, ma'am.
Yes.
This is an appeal by the insurance company. On liability, challenging the liability, my lord.
Oh, both insurance company and claimants appeal are there. Yes.
Please.
On what ground you are questioning the liability?
The insured vehicle is falsely implicated. That is my case, my lord.
Let us see from the award how you have substantiated that.
Please, madam. Your lordship may kindly peruse. According to them, the accident was on 15/11.
Mr. Counsel for the insurance company.
Please, ma'am.
If at all there is an arguable point
Yes.
on this, please argue.
Definitely,
Otherwise,
no, definitely. I will try to convince. I will try to convince your lordship.
Yes, please come to the order.
Please, my lord. The date of accident is, according to them, is 15/11/2008, 2015. 15/11. 15/11/2015.
Yes.
And according to them, he died on 17/11/2015. Complaint was filed on 18/11. After his death, complaint was filed. In the complaint, it is in Kannada, my lord. If my lord friend is not disputing, complaint is filed on 18 by the brother of the deceased.
Yes.
He alleges that, my lord, on 15/11 he has heard that his brother met with an accident and he was admitted to the hospital. That is his case in the complaint. He went to the hospital along with his father and noticed that his brother was admitted to government hospital that is called KIMS, Karnataka Medical Institute of Science, KIMS Hubli. Whereas in the wound certificate issued by the very same hospital, KIMS hospital, it states that he came to the hospital on 15/11/2015 along with the complainant, his own brother. May I read it, my lord? Exhibit P9 is the wound certificate issued by the KIMS Hospital, Hubli. Manjunath Pariyappa Kuri, age 22 years.
In that medical records, what it says about the accident.
Which one, my lord?
Medical records.
Exactly. Medical record states that on the 15/11 he came to hospital along with his own.
Whether the complainant has accompanied or not. Medical records, what is mentioned, how the accident had taken place.
No, it states that RTA. But my respectful submission is that how the ingenious mind was used to implicate the vehicle. He accompanied the injured at the time of admitting the hospital. So he rushed to the hospital along with the injured. Whereas in the complaint,
basing on that, you say that the vehicle is implicated only on that ground.
No, there are several. I will come to one by one, my lord. Number one, the statement made in the complaint after a lapse of 3 to 4 days is afterthought.
Yes, next.
He has accompanied the injured, went to the hospital, and though he was admitted to the government hospital.
That submission I understood. Next point.
Yes, very same. Continuation of the first one. In that hospital, he was discharged against the medical advice. May I read the report? Complainant along with the injured went to the government hospital, that is KIMS Hubli. He was admitted there, but he was, in spite of the medical advice, he was discharged from the hospital, from the government hospital, and he was taken to some private hospital. Except this wound certificate, absolutely there is no any medical evidence. In which hospital he was taken to the hospital, what was his condition, in which hospital he has taken the treatment, what is the cause of the death, absolutely no medical records.
Yes.
And their case is that he was the pillion rider in that motorbike. It skidded, both of them fell down on the surface and sustained the injury. They fell down along with the motorbike. Motor vehicle ME inspector reports that absolutely there is no any kind of damage to the motor vehicle. If really it is fell down along with the pillion rider and rider, definitely there will be some damage to the vehicle, some parts. As per the medical record, MV report, absolutely there is no damage of any kind. May I read the MV report, my lord?
No, we will take it. We'll take it that there is no damage to the vehicle. Yes.
Therefore, my respectful submission is that there was no accident involving the insured vehicle. There may be accident, he might have sustained the injury. But it is not from the insured vehicle. Therefore, afterthought.
What happened to the charge sheet file?
Naturally, FIR was registered after a lapse of 4 days. It was transferred to some other police station.
They might have filed a charge sheet. What has happened to that?
Charge sheet is filed, my lord. Charge sheet is filed. Police have filed the charge sheet. That does not mean that, my lord, the insured vehicle is involved in the accident.
So let's please come to the order.
Since there is an abnormal delay because he accompanied the injured to the hospital.
Yes.
He was taken to some other hospital. But which hospital? What was the treatment? What is the cause of the death? Absolutely no medical records. Either by the police or before the tribunal. If that is the case, what prevented them to produce all the medical evidence from the time of accident or from the discharge from the government hospital against the medical advice till the
Let
death?
us read issue number 1.
Please, ma'am.
Yes.
Therefore, it is afterthought and they have falsely implicated this insured vehicle.
Yes, please read.
Please, madam. Issue number 1. Whether the petitioners prove that Fakirappa B. Godchihalli was died in an accident arising out of rash or negligent driving of the driver of the motorbike bearing its registration number KA25ES7455 as alleged. Whether the number 2, whether the petitioners are entitled for the compensation, if so, how much? Absolutely no issues on this. There would be an issues. Based on this, if he is in that King's hospital, government, naturally the police will report. They have not allowed.
R1 was examined.
No,
R1 is not exempt.
Why? Why not? You are the pillion rider. He is a rider of the motorbike. You would have examined. You are admitted in a government hospital. There should be MNC. You should have they should have been exhibited on your behalf.
But
If you want, I can give you an opportunity by remanding the matter.
what happens, my lord, after the accident?
It is also my respectful submission. It is a fit case for remand.
It was a serious head injury. After the accident, he was admitted to the hospital, by King's Hospital. Then he has taken.
No, we will accept all that. We will accept all that. You were a pillion rider.
Yes.
In support of the case, when they are seriously disputing it, you could have examined R1. You were admitted in a government hospital. There should have been a MSc. You should have placed it as one of the exhibit before the court. Nothing you have done. And when there is a serious dispute they are raising with regard to this, you should have examined them.
The accident, my lord, police have registered the case against FIR and charge sheet
No,
is
that
there,
is
my
not after the accident. That is after 4 days after the
After the,
accident.
yes, ma'am.
After you gave the complaint.
Yes, ma'am. After 3 days, we have given
No,
it.
there is some cloud on this.
But
I'll set aside this order and remand the matter.
Please.
Week's time may kindly grant.
Huh?
Week's time may kindly grant, my lord.
For what?
We'll see some
No,
documents.
No,
It is
no.
a matter.
No, no
Next week.
documents, nothing is required. Unless and until you examine that person, we can't consider. This has to go. If you want, I can only pass over. Yes, next.
Allah, next week, 29th, we'll argue the matter. Next week.
For what purpose? Please tell me.
Allah, I will search some any other documents are there or not.
Even if other documents are there, that that has
No,
to,
not-
that is
not
true.
like that.
That you have to lead evidence for
I will
that.
take instruction my party. At least next week, any date.
This matter has parted next week.
20. Okay.
Please.
Yes.
This is the difficulty.
Yes. Yes. Yes.
My lord, insurance companies appeal only on quantum of compensation. my lord.
Yes. Please come to that.
The claim petition was filed by,
On what ground you are questioning?
yes, my lord. Uh, The grounds of that, my lord, there is, the deceased was having only one dependent, namely the son, who is the claimant, my lord.
What is the age?
Age of the deceased,
19 years.
49 years,
No, not deceased. The claimant's age is 19.
19. Claimant's age is 19.
So which year is the accident?
Date of accident is 16/12/2018.
Income was taken as?
Income was taken as 11,000 rupees.
As per chart, my lord, 11,750.
Any evidence in that regard?
No evidence.
Then we have to take 6,000.
As per chart, my lord,
6,000, 2011.
No,
you said.
2018.
18.
11,750.
11,750. It may be taken.
And 1/3 has to be deducted.
That is what is challenged, madam. Because there is only one, there is only
50%.
one claimant.
But he is not a bachelor.
There is no question whether he is bachelor or not. My lord, family consisted of only two persons. Earning person will not spend less on himself and more on the dependent. Because the tendency of every person, my lord, who is earning is to spend some amount more on himself.
What do you say?
So trial court,
And
my lord,
this, in Sarla Verma's case, my lord, whatever guidelines have been given, in that, my lord, what is stated is, if the number of dependents is 2 to 4, then it is 1/3.
What do you say?
Lord, as per the
Here
trial-
only one
trial court,
dependent.
my lord, by considering
And there is a
the-
judgment of this honorable court, my lord, division bench of this honorable court, that when there is only one dependent, then it has to be 50%.
That is so, my lord,
Take that. What is it? What was 19 you said?
And another error committed by the tribunal is that if 30% has been added towards future prospects instead of 25%.
His age is?
49.
Court has considered 30%.
30%. And interest at 7% has been granted. I have challenged that also. 6% may kindly be granted.
What is the multiplier?
13 million.
13.
It's coming to 12,29,508.
Or by considering not excellence in 10%, not
Huh?
to excellence. in-
48,036.
Please.
Please come. Agreed with the award.
11,45,625.
Huh? That is loss of dependency.
Ah,
At 48,000, 36,000.
please, madam.
It comes to 12,29,508.
Yes.
Agreed with award passed in embassy number 309 of 2019, dated 11th June 2021 by so and so. The insurance company is before this court questioning the quantum of compensation. The tribunal has granted the compensation as per the table given below at page 30. Para 30. Learned counsel appearing for the appellant insurance company submits that the son is a claimant. The court, instead of deducting 50%, has deducted 1/3. It is submitted that he is aged 40 years. Court had taken future prospects at 30% instead of ages
49.
9 years. Instead of taking the future prospects at 25%, the court had taken at 30%. And the interest is granted at 7% instead of 6%. It is submitted that the compensation needs to be reduced on all these grounds. Ex parallel and counsel appearing for the respondent claimant submits that. He is a married person. As such, the court rightly had deducted 1/3. It is further submitted that when the court is reappreciating the quantum, the court had taken the income at
11,000.
11,000. Court had taken the income at 11,000. It should have been 11,750. This court may take the income at 11,750. It is submitted that on all other counts, the compensation that is awarded is just and reasonable. Next one. Having heard the counsel on so and so. The first contention with regard to the interest, the court ought to have granted the interest at 6%. Then coming to the loss of dependency, the court had taken 11,000 as income, as though there is no appeal by the claimants, as this court is reappreciating the same. This court is taking the income at 11,750 as per the table fixed for legal services authority. The future prospects at 25% comes to 2,937. That is 14,687. As rightly argued with the learned counsel for the insurance company, 50% has to be deducted towards the towards his personal expenses. It comes to 7,343 into 12 into 13. Loss of dependency comes to 11,45,508. Towards consortium 48,000. Funeral expenses 36,000. It comes to 12,29,508. Accordingly, the appeal of the claimant is partly allowed by reducing the compensation from 15,47,200 to 12,29,508. The entire compensation amount shall carry 6% interest. The amount in deposit shall be forthwith transferred.
Please, madam.
My lords, there is another appeal, my lords, filed by the insurance company, my lords, challenging the same order, my lords. It may be connected with that.
Maybe connected.
What is the number?
My lords, MFP 101366 of 2022, my lords.
No, it says 24. This is 20,
My
24.
lords, another appeal filed by the insurance company.
No,
my
no,
lords.
it is before the division bench.
Please, my lords.
The list this matter along with MFA number 100428 of 2022 before the division. No, but it is pertains to division bench. List along with so and so. Yes, 25.
Obliged.
So just say the connected appeal 100428 is before the honorable division bench. This matter also before the division bench. Yes, 25.
Appeal is by the insurer, my lord. Appeal has been preferred on two counts. One is the income has been taken at the rate of 8,000 instead of 7,500.
How much is taken?
8,000.
8,000.
It's an accent of 2014.
Hmm.
It should have been 7,500.
It should have been 7,500.
7,500.
Hmm.
And the petitioners are no other, but they are the sons, major sons.
Age?
24 years and 22 years.
That we will consider them. That
No, no.
count.
In evidence, he has said that he is an agriculturist.
They've said that.
He is an agriculturist.
Who is an agriculturist?
The one of the son who has led his evidence.
The light of the judgment of Seema Rani, we can consider them as dependents.
But
judgment of
but
Justice
my lord, what
Prashant
the-
Kumar Mishra, no, they are the sons of 35, 36. What they said, because they are all agriculturists, and considering that we can take them as dependents. That's what the judgment says. You have seen that, Seema Rani?
Yeah, I've seen it.
So this.
And another aspect is, though the husband is not a petitioner, consortium has been granted. That has to be given up.
How many are there? For the two claimants, we will grant.
Two of them, love and affection has been given to
In view of consortium, my lords, the Honorable Apex Court in my lords, the Magnum case.
He has to be a party to this.
He is the respondent. He is the owner of the motorcycle.
Huh?
He is the owner of the motorcycle. He is the respondent. He is the respondent, and one of the son is the writer of the motorcycle.
Even parental consumption has to be awarded, my lords.
That I am not objecting to that. As far as love and affection is concerned, I am not objecting to that.
He is saying about the husband.
Husband is not my lord claimant.
That's what he is submitting.
Please.
Consortium, they are entitled. There is no dispute on
Please,
that.
I'm not against granting of love and
No,
affection to the sons.
7,500. What was the age of the deceased?
38 years.
So 40%.
Here, there's again one hitch is here, man. They say that the disease is 38 years and the first son is 24 years. So in that case, 42 years at least it should have been taken for as far as the
Pardon certificate, what it says.
it says 38 again.
38.
You have to take it
So
like
then
that.
it goes to say that she is
Then you
married
have
to the
to
age of
know
13
that
years.
Now your contention that the age of 22 is not correct. He must be minor.
24.
He must be minor with what your contention.
If that is taken to, but one thing, if,
No,
if
those
at least 18 years it is to be taken as,
We are not a criminal trial here.
so only thing is income has to be changed and
Income is changed.
Huh.
Future prospects at 40%.
That is the
7,500, 3,000 future prospects would come to 10,500 into one by 3.
1 by 3. And 1 by 3 has been directed before the trial court also.
1 divided by 3. It comes to
Multiplier of
3,000.
15.
It comes to 7,000. 7,000 into 12, what is the multiplier?
ಇಲ್ಲ 500 ರೂಪಾಯಿ ಕಡಿಮೆ ಆಗೈತೆ ಅಷ್ಟೇ 7,500 8,000
Please,
7,500 is clarifying with me that whether the income has been maintained or not. I said 500 has been reduced.
7,000 in, we are taking 7,500 instead of 8,000.
Please.
So 7,000 into 12 into multiplier is
15.
it comes to 12,60,000. 48 into 2.
96.
It comes to 96,000, 36,000. It's coming to 13,92,000. How much is granted?
1444.
1444.
So around 50,000 I could say.
Interest?
6%. 8% was granted, it should be 6%.
Please come. Then the agreed with the orders passed, award passed in MVC number 645 of 2019, dated 22nd July 2021. The
by so and so. The insurance company is before this court questioning the quantum. The tribunal has awarded the compensation as per the table given below at paragraph number 26 extract. Land counsel appearing for the appellant insurance company submits that the accident had taken place in the year 2014. Court had taken 8,000 as income, ought to have taken 7,500. It is submitted that the sons or major sons, they are not entitled for, they can't be treated as dependents. The rate of interest is 8%. Court had taken the interest at 8%, awarded the interest at 8%. It ought to have been at 6%. Next para. On all these counts, the compensation needs to be reduced in the same para. That land counsel appearing for the respondent claimant submits to the court had granted the compensation, granted a just and reasonable compensation. There are no grounds to interfere. Though they are raised majors, but they are still dependent upon the deceased. This aspect was considered by the court. Next para. Having heard the counsels on either side, there is a material non-record. First, coming to the aspect of interest, the court ought to have granted 6% interest instead of 8%. Then coming to the income, as this accident has taken place in the year 2014, this court is taking the income at 7,500. Future prospects at 40% would come to 3,000, that is 10,500. As the sons have to be considered as the dependents in the light of the law laid down by the Honorable Apex Court in Seema Rani versus Smith. Ask her, she will give the judgment. 7,000, hence the 1/3 will come to 3,500. Then the contribution to the family is 7,000 into 12 into 14. Under the head of loss of dependency, they are entitled for 12,60,000. Towards consortium 96,000, funeral expenses 36,000. Altogether, the claimants are entitled for an amount of rupees 13,92,000. Accordingly, the appeal of the insurance company is partly allowed by reducing the compensation from 14,44,060 to 13,92,000. The entire amount shall carry 6% interest. The amount in deposit shall be forthwith transferred. After.
That's my request for future prospects, ma'am. Future prospects.
What future is granted?
Please.
40%.
Please.
After lunch.
Humble submission. Serial number 7, Lordship was pleased to dispose it of. Amount in deposit should be transmitted.
That will be.
Please.
My lord, serial number 29 and 52 was I have not filed because next is Thursday.
I will give you time for another 1 week after the disposal to file your wakalat.
No, I have not received any copy also.
You should have done it by this when it's an advance list is prepared. Because notice is served. At the request of land counsel for the respondent number 2. This matter next Thursday, no further time. Yes. Signatures?
My lord, on submission, my lord.
Yes, I said no mentions at 1:30, but unfortunately, all of you are making mention. Is it mentioned in the cause list? No mentions at 1:30 and 2:30. Please make sure tomorrow it's there.
Madam. Is it? Is it not, madam? Coffee and not.
ಏನ್ ಬರ್ತಾರೆ? ಹೋಯ್ತು. ಹ್ಮ್ ಹ್ಮ್ ಇಲ್ಲ ಸೆಂಡ್ ಮಾಡ್ಬೇಕು ಮೇಡಮ್. ಅವು ಇಬ್ಬರು ಬರ್ದಿದ್ದಾರೆ. Madam? Sitting late.
ಮ್ಯಾಮ್ ಲಿಸ್ಟ್ ಸ್ಟಾರ್ಟ್ ಆಗಿದ್ರಿ ಮ್ಯಾಮ್ ಲಿಸ್ಟ್ ಒನ್ ಇನ್ನ ಟೂ ಯಾವಾಗ ಮೇ ಬಿ ಯಾವಾಗ ಸ್ಟಾರ್ಟ್ ಆಗ್ಬೋದ್ರಿ
Madam,
For the rest.
My lord, I am for
Yes.
the appellant in this case.
20. Yes.
My lord, this is an appeal by the insurance company challenging the liability. The deceased riding the motorcycle, obtaining from owner of the vehicle, and in stray dog has come and he hit and fallen and died. Because the borrower of the motorcycle is not covered under the policy, as per the Ningamma's case and also Ram Kiladi, my lord. Therefore, there is no liability at all.
Is it insured or not?
Vehicle is insured, but he stepped into the shoes of the owner. Therefore, I request for time. I will produce these two judgments, Ram Kiladi and Ningamma.
Ram Kiladi, there is no, the further judgment need not be produced.
There is no coverage at all. In view of the Ram Kiladi also. Because he stepped section 147, he is not a third party.
Then because he's stepping into the shoes of the owner, he's entitled for personal accident coverage as per the judgment of Ram Kiladi.
Correct, my lord, but they have not claimed. There is a separate forum they have to claim.
No, we can grant that. Well, how much is where is the insurance policy? What is the
Policy
personal
exhibit
accident coverage?
R1. If policy is taken into consideration, this amount is covered. I don't. If policy taken into consideration, PA cover, this amount is covered.
So
I can't tell any other things to the court, because when you are having a knowledge of law in that regarding that PA coverage, lordship is right.
No, what choice you have now is, your contention is accepted, whatever amount is granted, partly allowed.
Therefore, the same thing I am telling. If lordship take into consideration of that policy, and taking the last paragraph of the Ram Khiladi case, then I have no voice to say regarding any other aspects, because the
What do
driving
you want?
license
You
is
want
there,
your appeal
policy
to be dismissed? No, your appeal to be dismissed or your appeal to be partly allowed? Whatever you want, I can pass.
partly allowed. that can be
Partly
done.
allowed.
Only to
The,
that effect I can say, because I have no other
award
voice
passed
to
in
say.
embassy 520 of 2019 dated 17 December 2021. The claimant is, the insurance company is before this court. Then counsel appearing for the insurance company submits that the vehicle, the owner of the vehicle has given this the vehicle to the deceased, and but the compensation is 4,12,500.
Yes, my lord. But the PA cover is more.
How much PA cover?
PA cover is now in this policy, it comes to 15 lakhs. Therefore, let them claim from that insurance company, let them get.
No.
Only
Then
I
I
am
will dismiss
telling.
your appeal. I will dismiss your appeal.
Observing this, my lord. This kindly be observed. Observing this, the PA cover is there. Observing this, my appeal may be dismissed.
The facts of the case are that the deceased, who was the son of the petitioner, is proceeding on his motorcycle on 13/4/2019 at about 3:15 a.m. towards Unkal from Dharwad. When he came near Dharwad oil mill, one of the dogs suddenly came across to the said bike and has taken his motorcycle towards the extreme left side, and he fell down and sustained fatal injuries. Immediately was shifted to the hospital. The claim petition is filed under section 163A of the Motor Vehicles Act. The tribunal has held that the insurance company is liable to pay the compensation and granted an amount of rupees 4,08,000 towards compensation. It is a submission of the learned counsel appearing for the insurance company that the deceased has stepped into the shoes of the owner of the vehicle and he is not entitled for any compensation. It is submitted that this aspect was not considered by the court, and in the light of the law laid down of the apex court in Ram Khiladi's case, he is not entitled for any compensation. Next para. Having heard the learned counsel for the insurance company, there is a material on record. There is no dispute that this issue is covered by the Honorable Apex Court in Ram Khiladi's case. In Ram Khiladi's case, the Honorable Apex Court has observed that though the deceased has stepped into the shoes of the owner of the vehicle, as the owner is entitled for the personal accident coverage, that the deceased is also entitled to. In this matter, the respondent or served, but no wakalat is filed. The amount of compensation that is awarded is 4,12,500. If this court has to pass such an order as per Ram Khiladi's case, the claimants would be entitled to much more amount. In that view of the matter, this court do not find any reasons to interfere with the order passed by the tribunal. Accordingly dismissed.
Lordship,
The
one submission, your lordship.
The amount in deposit shall be forthwith transferred. Yes.
One submission. Again, they should not claim PA cover. Therefore, as they are entitled for PA cover, and this amount, only one shabd.
They have not preferred any appeal, nor they cannot claim the PA coverage. Yes, next. 27.
Claimant appeal for enhancement, case of death, my lord. The only thing is liability is first hand upon the owner of the vehicle.
On the
ground that there was a violation of policy terms and conditions. There was a permit violation, ma'am. flight beyond the permitted age. That is the only issue. Liability to be passed upon
What
the
about the
rightly awarded, madam.
My lords, in Gohar Mohammed versus UP State Transport, my lords, the Supreme Court is very clear regarding the permit, my lords. It is on the,
There are also the judgments on pay and recover.
and here, my
also.
lords, there we have examined the RTO, my lords. Even the, and on
No,
that
even
particular,
even assuming that, there are judgments with regard to pay and recover. I've also passed several orders on that.
please, my lords, and on the day of accident, my lords, there was no permit. After the accident, my lords,
No, that's what, it will, as far as the third party is concerned, it will not pay and recover. Whatever judgment, please pass on, I'll record that.
my lords, at present, I'm not having, my lords, SCC 2022, my lords, it was not
The
possible.
word passed in embassy number.
My lords, and regarding quantum, my lords,
He is not questioning. He's not questioning the
no,
quantum.
because we are not having appeal because the liability was not saddled on the company, my lords. I am representing the company. But when for pay and recover, my lords, if your lordships pass an order for
What
pay,
is this, let us see?
because his father is the only dependent, my lords. Half, he's a bachelor, my lords. The deceased is a bachelor.
Which year is the accident?
50% is deducted, madam.
Let's see, which year is the accident?
2019, my lords.
2019, how much was taken
13,250.
by the court? Court officer. Look at it. Continuously they're talking, disturbing the court. So 9275
Yes.
into 12, into what is the multiplier 18?
17.
17.
It was age of 30 years as on date of death.
30 years, 1 month and 16 days.
Doesn't matter for future prospects. Then
My lords, permit was issued on 19/2/19, my lords, to 18/2/24. Accident occurred on 17/2/19 before the permit was issued.
only one dependent,
Yes, madam.
one claimant.
One claimant. Death of a bachelor.
It's coming to 19,86,100.
19,62,100.
Huh?
19,62,100.
How?
18,92,600 dependency. Plus
92,100. 48,000 towards consortium.
Yes.
36,000 towards funeral expenses. 10,000 towards legal expenses. It comes to 19,86,100. From 19 lakh, in fact, when he said he is not pressing for that, he should have left it there. We'll leave it there. Anyhow, you were not pressing.
Not so much, 10%.
The agreed with the award passed in embassy number 1477 of 20, dated 4th October 2021 by so and so. The claimant is before this court, mainly questioning the liability that is fastened on the owner of the vehicle. The tribunal has awarded awarded compensation of an amount of rupees 19,62,100. When it comes to the liability, the court has held that there is no permit as on the date of the accident. It's a fundamental breach of the policy conditions. As such, a owner alone is liable to pay the compensation. Land Council, appearing for the insurance company, submits that as it's a fundamental breach of the conditions of the policy, the principle of pay and recover will not apply. Is contingent first. Land Council, the petition submits that the court ought to have applied the principle of pay and recover. Next are contention. Then, having heard so and so, in the light of the law laid down in so and so. Ask Megha, the other orders are passed. Still, the principle of pay and recover will apply, and the insurance company shall shall pay the compensation and record the same from the owner of the vehicle accordingly.
No, and interest at 9%, my lord, 6%.
Interest and the entire amount 6%.
Much obliged.
Yes.
I have to respond claimant, my lord. So death of Tollius boy, my lord. Criminal is awarded 6,55,000. And in view of the Supreme Court judgment, my lord, the minimum wages.
NWKRTC appeals, my lord. My lord, challenging the negligence is there, my lord.
No, in case of death, there are other two judgments of the Supreme. What is that? Kishan Gopal is also case of a death. Later, no, the judgment which you are relying on has been rendered without even considering the earlier judgments of the Supreme Court.
May I take your lordship to the
Yes, Sanjay
Delhi High Court. Sanjay Court is there. Some other judges.
I've seen that, and if you want any order on that, this is adjourn this matter in the month. This is in the month of March. Yes, next. Please. Yes.
It's a claimant appeal, my lord. It's a claimant appeal, my lord. We have filed this appeal for enhancement, my lord. The date of
It's a case of death or injury.
Injury, my lord.
Come to the table.
The date of accident is of 2017, my lord.
What are the injuries?
Multiple injuries, my lord. Kindly please.
How many are the grievous injuries? How many are the fractures?
Yes, my lord. Exhibit P5, my lord.
Come to the order. Where is it mentioned?
Paragraph number 12, my lord. Further, the petition.
Bilateral limb extremely rotated, right leg open wound with exposed soft tissue and fibula had exposed grazed abrasion. Medical aspect of high swelling so and so. Pain and suffering another 10,000. Medical expenses as it is?
3 lakhs, my lords. Only 1,76,028 rupees has been awarded, my lord. That has to be increased, my lord.
How it has to be increased?
3 lakhs we have spent for.
Where from? Then there must be a discussion by the court on that.
Exhibit P10.
On that, I cannot. If you want, I can remand the matter. But on medical expenses, we can't sit here and count.
Okay. Since it is of 2017 year.
1 minute.
My lord.
Come here. Come to the table at page number 15.
Yes, ma'am. Future of that has to be increased.
How many days he was in hospital?
34 days, my lord. 34 days.
Already amount is granted on the higher side on incidental expenses. 45,000 is granted. We will not. We cannot enhance it.
Sorry, my lord, but he has incurred multiple fractures, my lord, and he has taken operation as well as in various other hospitals, my lord. Totally around 5 to 6 hospitals he has taken treatment. Around 5 to 6 hospitals he has taken treatment, my lord. Firstly, he went to Vim's hospital, my lord. Later he has went to.
All that argument is not necessary. How many days he was in?
34 days.
So that is already granted. It is 1,000 per day. That's what we calculate. So already more 45,000 is granted. So you are not entitled for any enhancement on that. Loss of income during laid up period.
75,000 is considered, my lord. Since it is of 17, my lord, 7,500 it is awarded, my lord. It has to be increased to 10,250, my lord. 10,250 as per the chart.
Which year is the accident?
2017.
Court has taken?
7,500.
But how come 75,000 is awarded? For how many days it is awarded?
It is for 10.
Come to that. Come to the discussion.
20th page, paragraph 20, my lord. Page number 15, my lord. Period from February 2017 to December 2017 is rupees 7,500 multiplied by 10, which has been 7,500. 75,000.
Then where is disability?
74%, my lord. Only
Let's see that.
24% is considered.
Let us see that. Where is the discussion?
Yes, ma'am. Exhibit 36, my lord.
Discussion in the order.
Paragraph 19, my lord.
Come
Page
to
number
paragraph number 15. One third is taken.
That has to be increased. ma'am.
Why?
Since he has incurred multiple injuries, ma'am.
Huh?
Multiple fractures, ma'am.
No, disability is 74.
30%. At least 30%, ma'am.
No,
24%.
just like
is
that, we will not take the disability. Code says, the doctor says 74% of the limb disability. We have to take one third. One third because it is more than 24% it is coming, we will give the future prospect.
And notional
We will take
income-
25 because it's coming to 24.6.
Yes, ma'am.
So 25, if we take 25, the income is 10,250.
Yes, ma'am.
What is the age?
28 years, ma'am. 17, 34.
What is he doing?
Agriculture is come driver, ma'am. He has not produced any kind of income certificate, ma'am.
Multiplier?
17.
It is enhanced to 12,10,458. Please come. Agreed with the award passed in MVC number 817 of 2018 dated 18 February 2020. The claimant is before this court seeking enhancement of the compensation. The tribunal has awarded the compensation as per the table given below. Learned counsel appearing for the claimant submits that this accident had taken place in the year 2017. The court ought to have taken 10,250 as income, but the court has taken 7,000.
Yes, 7,500.
Court has taken 7,500. It is submitted that under the head of pain and suffering, the amount that is awarded with the tribunal is not just and reasonable. It is submitted that the doctor has opined that he had sustained the disability of 74%. The court ought to have taken 30% as a whole body disability. Under the head of loss of amenities and other heads, the amount that is awarded is not just and reasonable. Though notice is served on the served on the respondent, no wakalat is filed on their behalf. Next one. The having heard the learned counsel for the appellant claimant peruse the material on record. Considering the claimant had sustained multiple injuries. Petitioner had sustained bilateral limb externally rotated, right leg open wound with exposed soft tissue tibia and fibular and head exposed, grazed abrasion present both the medial aspect of thigh, swelling with tenderness left thigh and left parietal area cut lacerated wound, and all the 5 injuries are grievous in nature. Hence, under the head of pain and suffering, this court is granting an amount of 70,000. Under the medical expenses and incidental expenses, this court is not interfering with the same. Coming to the loss of income during the later period, court is granted for 10 months. However, this income is taken as 10,250. It comes to 1,02,500. Coming to the loss of future income, according to the doctor, the disability that is sustained is 74%. 1/3 of it comes to 24.6, and this court is taking. Hence, this court is taking 25% as disability. As the disability is 25%, this court is also granting future prospects. 10,250 plus 40% future prospects would come to 4,100, and the income of the petitioner is 14,350 into 12 into 17 into 25 by 100 is 7,31,850. Towards loss of amenities, considering the multiple injuries and the disability, this court is granting 75,000. In the light of the law laid down in so and so, legal expenses 10,000. Altogether, the claimant is entitled for an amount of rupees 12,10,458. Accordingly, the appeal is partly allowed, enhancing the compensation from 7,73,228 to 12,10,458. Enhanced amount shall carry 6% interest. Yes, next. Yes.
My lords, a claimant bill for enhancement, my lords. It's a case of injury, my lords. My lords, the liability on first on the owner of the vehicle, my lords.
On the ground?
On the ground that, my lords, the rider of the vehicle was not having a valid driving license, my lords. Driving license. Please, my lords.
Yes.
And my lords, this is already settled, all my lords. As per Honorable Apex Court judgment in.
All the judgments are not required. Come to the compensation.
My lords, regarding the compensation, I'm not pressing, my lords.
Huh?
Regarding compensation, I'm not pressing.
You're
Please, my
not on
lords.
that. Yes.
I'm appearing from R2, ma'am.
Owner of the vehicle
No, how, ma'am?
or insurance company.
Insurance company, ma'am.
Pay and recover.
Ma'am, this yesterday we have received a wakalat, ma'am. We will file it, and my senior is today absent, ma'am. He is out of station.
No problem. He'll file. I'll permit him to file wakalat within 1 week from today. You already filed.
Filed, my lords.
Filed or you will file.
We will file, ma'am.
Yes. The agreed with about passed in MVC number 14 of 2019, date 7th November 2022. By so and so, the claimant is before this court. Land counsel appearing for the claimant submits that the claimant is only on the ground of only questioning the I filed this appeal only on the ground of liability. It is submitted that the liability is fixed on the owner of the vehicle on the ground that where do you get that?
Please, my lords.
Where do you get that? As on the date of the accident, the rider of the offending vehicle is not having a valid driving license. On that, the liability is fixed on the owner of the vehicle. It is submitted that in the light of the settled law, in the light of the law laid down in the Honorable Appellate Court in Forensic versus so and so, the insurance company is liable to pay the compensation and record the same from the owner of the vehicle. Learned counsel appearing for the respondent insurance company submits that the court has rightly fixed the liability on the owner of the vehicle. There are no grounds to interfere. Next, having heard the so and so, what is the material on record? The only ground that is raised before the court is with regard to the liability in the light of the law laid down and so and so. Even if the driver of the offending vehicle is not having a valid driving license, still the insurance company is liable to pay the compensation and report the same from the owner of the vehicle. Accordingly, the appeal is partly allowed and the compensation shall be paid by the insurance company and record the same from the owner of the vehicle. Land counsel appearing for the respondent insurance company so and so. What is the name? Is permitted to file vakalat within 1 week from today.
Please, my lords.
Yes, next.
Please.
Wait, just come in this list.
Kindly praise for short accommodation.
Mixed all the. When I said only MFA should be here, yes.
Kindly short accommodation may be given.
Yes, list this matter after 2 weeks.
Please.
Please, I beg to appear for the appellant. But in this case of amputation, injury, below knee.
Counsel.
Counsel, code word.
Yes.
Lord, amputation, year of accident 2007. Lord, he is an agriculturist. And my lord, 40% has been taken, disability, and awarded 5,86,000. My lord, future prospect has not been assessed. My lord, my submission in this case, my lord, he is an agriculturist. And my lord, the tribunal must have taken or to have taken disability of 100%. As my lord, in view of the judgment of Rajkumar and Ajay Kumar in para 10, my lord, the occupation as a profession. So he is doing agriculture. That finding is come in the, my lord, in the tribunal order.
What do you say?
My lord.
And also I have got
the amputation of the right leg below knee is there, my lord. As per the chart is there, my lord,
No,
maximum.
it's not above the knee or below the knee is not the question. Whether he'll be able to do his work or not. He's an agriculturist.
Yes.
Yes, my
He
lord.
carry out his operations with
My lord,
the.
he can do, my lord.
How?
Artificial limb is used at artificial limb, my lord. Not only there, my lord.
Okay, now with
His
an-
different work
Will he
can
do
do, my lord.
agriculture?
Right.
Agriculture
Like
is
in-
strenuous activity. How will he do with that?
My lord, he is not shown in the agriculture. Agriculture coolie work is there.
Let's see, it will be there.
this
The
finding, my
will be
lord,
there.
your lordship kindly see.
The
The finding, my lord, page number 21, internal page number 21.
He is not produced the
Just
record of
one.
rights, please.
21.
If
My
you-
lord,
if a person is
for-
an agriculture coolie, where will from he'll have a record of rights?
My lord, period of 40 days, he was in the hospital in so and so.
So where did you say that you are an agriculturist?
He was, no, I will, F, my lord, page, internal page number 21. My lord, towards loss of income during the later period, there is a finding also there, my lord. For a period of 40 days, he was in an hospital, indoor patient, therefore, he was not able to go for agriculture work. Since, and also, my lord, that has come in agriculture, and I stated in my chief examination, I am doing agriculture, but I not produced. But the tribunal has taken an income of 6,000 as an agriculture, though the accident has occurred in the year 2007.
It should have been taken as 4,000 only.
Yes, my lord, the tribunal has given, my lord, that in view of the Supreme Court judgment, they have taken.
Ramchandrapa's case also, it is not. Where is the
Allah,
Ramchandrapa's case also? 4,500 or 4,000?
Please.
6,000 is on the high
Yes,
side.
that part, my lord, I will leave it for the regarding quantum of compensation. But the agriculture, and I have also, my lord, judgments on this in division bench also. Yes, 100% disability has.
No, my lord.
Have the clarity on factual aspects first.
Yes.
Now, that if we have to, again, all that 4,000, we have to take 4,000 and then make the calculation,
Yes.
not 6,000.
Yes, ma'am.
Yes.
And pain and suffering, my lord, in view of the, my lord, 50,000 has been given. My lord, in view of the judgments, my lord, 2,50,000. And the amenities has not been awarded. At least 1 lakh rupees amenities. And my lord, artificial limb has not been awarded. At least, my lord, 1.5 lakhs for.
When we are granting and taking 100% disability, all other heads, why should we enhance so much?
No, my lord,
My lord.
division bench, my lord.
Doctor, my lord, depend upon, doctor is assessed, my lord, 65% to 70%. Doctor is assessed 65 to 70% is there, my lord.
What is that?
Doctor, my lord, doctor is assessed disability, my lord.
Doctor is assessed, my lord.
65 to 70% is there, my lord. As per the schedule, my lord, is there, my 50% in the below is there, my lord.
That's what I'm
Even
saying.
if it is
Just
considered, my lord,
Just forget about the percentage.
please, my lord.
The fact remains is his leg is amputated.
Amputation, my lord,
How
in
can
such
he
a
do the
circumstance, if
agriculture?
he is a driver, my lord, he is unable to drive that work, my lord. But he's an agriculture coolie work or in agriculture, my lord. He can do, my lord. He can do in artificial limb. Now is several examples we see that, my lord.
Relying on a division bench judgment, see,
Yes,
give him
my
a
lord.
copy of it.
Para 17.
Is
I'll
he
just
produced
pass
that
it.
is the what
I'll just pass
occupation
on.
is there. We'll see that, my lord.
My lord, just para number 17, we have perused the materials on record. Not disputed that there is an amputation of right leg below knee of the petitioner. The petition is agriculture. In view of the decision of Honorable Apex Court Rajkumar versus Ajay Kumar, the division bench of this court so and so dispose assess the disability of the petitioner at the rate of 100%. Considering the
Below knee, above knee, that is
He's a tailor in the judgment,
Yeah,
Rajkumar.
Tailor.
not in tailor, even occupation, profession. My lord, your lordship kindly see Ajay Kumar, para 10. I will just pass on it. Even occupation, what is a profession? Just they have given 2 examples, a carpenter.
I am looking at from the judgment you have read just now.
So he is agriculturist, that 100% disability I have considered by division bench. My lord. In this case also, he is agriculturist.
Give those judgments to him next Thursday.
please, my lord.
My lord, tomorrow, next,
Thursday,
yes, ma'am.
yes. Notice to the respondent. Yes, 6:35. Notice. 36. Oh no, why they have prepared the list like this? When I have asked them to prepare a list only of MFAs, randomly they have prepared, they have included everything, and I asked them to post only final hearing matters.
Beneficiaries appeal. Beneficiaries appeal their
The stay petition, same or similar order.
50%.
37.
Beneficiary appeal, madam. Not earlier with 60 ml.
38 also same. 39.
Then it's same ml. R1 and R2 ml government will take notice.
Huh?
R1 and
Same
R2.
order. 39.
Serial number 39, owner's appeal, my lords. In fact, owner is the company, my lords, which is already declared as insolvent by the NCLAT Bhopal, my lords. And no notice was issued to this respondent company.
Whatever it is, 50% deposit.
Please, my lords. Please, my lords. Subject to
Usual
default.
order.
Please, 4 weeks time.
Yes. 40.
Company appeal challenging liability, my lord. Unauthorized passenger goods vehicle.
So it is submitted that the claimant is an unauthorized passenger in a goods vehicle. Without considering the same, the tribunal has granted compensation 50%, 4 weeks. No permission to withdraw. Yes, next.
Appeal on liability, my lord. Appeal on liability. It's an employee's compensation act. Yes, we have deposited the entire amount here. Because as per.
What is on what ground the liability means?
First thing is, there's no relationship of employer and employee. One thing.
It's submitted that there is no relationship of employer and employee, and without considering the same, the tribunal has granted the compensation. There shall be stay
No condition because they've already deposited the amount. They shall be stay of all further proceedings. Notice to the respondents in all these matters. Yes, 42.
So same, my lord, unauthorized passenger, my lord. Goods vehicle in unauthorized.
Same, like unauthorized passenger.
43 also.
43. 43 also same.
Same.
By arising out of the same
Arising
accident.
same.
Yes. 44.
For the appellant, I have filed OS number 177 of 2022 seeking declaration and injunction. That suit came to be dismissed. I have filed RA, and in that I have filed IA for temporary injunction. That is also rejected. Challenging that, I am filing this.
Notice to the respondent.
Lordship. Suit is for partition, Lordship.
Yes.
I have filed IA number 1, Lordship. Initially, interim order was granted, Lordship. Then subsequently, after presenting that, they filed objection. It was dismissed, Lordship. There are 3 scheduled property, Lordship. To prove that this schedule number, item number 1 is ancestral property, I produced the records of right from 1933 onwards, Lordship. My grandfather, which was standing in the great grandfather of my property, Lordship. Item number 2 was.
Please come to the impugned order, we'll read.
Yes,
the
Lordship. Page number 18 was reason, Lordship.
Page number?
18, Lordship.
From reasoning, please read.
Reasoning. Directly, I will come at page number, para 11, sir. In order to prove this case, the plaintiff has produced the mutation entry bearing number ME2166 dated 2/9/1947. Sattava Lakshman Gorpade has sold his property bearing number 456/2A and 5A in Maliyappa Mudgepa. Here in this case, Lordship, we have not produced this document, Lordship. And this is not pertaining to this suit sold property also, Lordship. For sale considered 300. Further, he has produced 5 RTC pertaining to item number 1 of the 1964 to 2000, where the name of the Mudeppa Hannappa Gorpade is shown as the actual possessor of the said property as per ME number 2769. This is also not pertaining. And 5296. Further, he has produced. We have not produced this document also, Lordship. Further, he has produced the document of gift deed executed by Mudkeppa, son of Hanma Gorpade, where he has gifted the item number 1 of said property in favor of the defendant number 3, Lordship. This is their, Lordship. My grandfather in favor of my father, Lord. Further, he has produced the RTC pertaining to item number 2 for year 1982 to 2000, where in name of Mudkeppa, son of Hanumantappa Gorpade is shown as the actual possessor of the land. And in RTC, name of defendant number 1 is shown as the actual possessor of said land. Defendant number 1 is none other than my father, Lordship. ME number 5. He has produced the certified copy of sale deed dated 22/4/1977. It was standing in my grandfather's name, where it is stated Mudkeppa, my grandfather Gorpade has purchased the item number 2 of the street road from originally owner of the sale consideration for rupees so and so. Further, he has produced the mutation entry bearing number 92570, where the name of Mudkeppa got entered in records pertaining to item number property based on the sale deed. Further, he has produced the copy of mutation entry bearing number so and so of 90, where it is stated that Mudkeppa, my grandfather, has relinquished his right our item number 2 sold property in favor of.
No, the issue is with regard to item number 2 and 3.
Item number 2 and 3.
Whether item number 2 and 3 are the self-acquired property prime of essay or it's a joint family property, you are not able to show. That is basing on that, the court has dismissed.
Yes, Lordship.
What is your submission on that?
Lordship, with regard to item number 2 property, Lordship, kindly produce the. It was standing in my grandfather's name, Lordship.
No. Item number 2 was purchased by, who is Mudiyappa?
Mudiyappa is the father of.
No, my grandfather. My grandfather.
Son of Hanumappa,
Hanumappa.
while sale deed dated 22/4/1977.
Yes, Lordship. I produced the genealogical tree also.
Further, it appears that he has relinquished his right over the said property in favor of defendant number 1.
It is unregistered deed. Unregistered. Unregistered. My father's name got entry, Lordship.
It's an unregistered.
Unregistered. But still today, my lords, that this has been not challenged by any of the members.
How will they know?
No, not by him, at least by the brothers and sisters of the Mudiyappa.
If it is brought into existence.
And it was in the year of 19. Sorry.
When
1995, until today it has been not challenged
If
before.
it is relinquished from
Please, my lords.
1995 till now, entries are in whose name?
It was in the Mudiappa's name only.
Then
he
that
relinquished.
means that relinquishment deed is in nobody's knowledge.
Please, my lords. No, but till today it has been not challenged because in the year 90, it has,
Now.
it was
based-
purchased.
No, please understand.
Please.
Basing on that relinquishment date, if the entries in the revenue records, the
records.
entries have changed, at least people, they would have known that there is such a relinquishment date.
But they were, but it was purchased in 1997, my lords. 1977 it was purchased. In the year 1995, he relinquishes.
Then why your name is not mutated if that is the case?
What was?
And all are agriculturist, lordship.
One.
No, this item number 3 is purchased by him.
Purchased from joint family fund, lordship.
No, that is not as
Because
Now, when he has purchased that?
it is purchased in 1996, lordship. I produced that page number 97, lordship. All are agriculturist, joint Hindu family property, lordship. No loan.
As far as this property is concerned, where they will not grant injunction. As far as item number 1 and 2 is concerned, will grant.
Please.
Where is your application for injunction?
I produced. At page number, lordship, I produced 77, lordship.
70?
7. With respect to item number 2 and 3, we saw.
Item number?
2 and 3.
Only you sought for item number 2 and 3.
Yes, sir. No to align.
Agreed with the order passed in I number 1 in OS number 85 of 2025, dated 6 January 2026. By so and so, the plaintiff is before this court. The plaintiff has filed a suit for partition. In that he had filed I number 1 seeking injunction in respect of plaintiff. In respect of 2 and 3 properties.
Yes, lordship.
What is the injunction you sought?
And not to create third party rights.
Filed an IA seeking injunction restraining the defendant from creating any third party rights in respect of item number 2 and 3 of the scheduled properties. Initially, the court has granted injunction and later the same was vacated. Against that, the present writ petition is filed. The court, while vacating the injunction, has observed that item number 2 was purchased by Mudiappa, son of Hanamappa Gorakoppat, while sale deed dated 22/4/1977. Further, it appears that he has relinquished his right over the said property in favor of defendant number 1 by ME as per ME number 1458 dated 12/9/1995. Further, the defendant number 1 has purchased item number 3 of the suit scheduled property. But the said property is purchased out of the income of the joint family or not, whether the defendant number 1 has purchased item number 3 of the suit property out of the income of the joint family or not has to be decided by the court during the course of the trial. And at this stage, as the plaintiff could not make out a prima facie case, court had vacated the injunction. Then counsel appearing for the petitioner plaintiff submits that the relinquishment deed which the court has mentioned about is an unregistered document, and in respect of the item number 2 of the plain scheduled property, in the revenue records, the name of the grandfather of the petitioner is still mutated in the revenue records. It is submitted that the defendant number 1 has purchased item number 3 of the scheduled property from the joint family, from the proceeds of the joint family income, As such, the court had failed to consider and failed to the court ought to have granted injunction as he could make out a prima facie case and balance of convenience is in his favor. Next parallel. And counsel appearing for the defendant submits that originally the property, suit item number 2 of the property was purchased on 22/4/1977 and the relinquishment deed is of the year is on 12/9/1995. That was not questioned by any of the family members. Hence, at this point of time, it is not open for them to say that it belongs to the joint family. It is submitted that the item number 3 of the suit scheduled property is purchased by the defendant and it's a self-acquired property and there cannot be any injunction against the defendant. Next, it is submitted and on the same part, it is submitted that the court had rightly rejected the request of the petitioner for grant of injunction. Next, having got the land counsels on either side, there is a material on record. There are, how many properties are there?
Three.
There are 3 properties. There are 3 items of the suit scheduled properties. As far as one is concerned, that is a joint family property, and the plaintiff has not questioned the plaintiff has sought injunction in respect of item number 2 and item number 3 of the scheduled properties. According to the defendant, the grandfather has relinquished his right in favor of the defendant by way of a document dated 12/9/1995. That is a unregistered document, and nothing has been placed on record to show that pursuant to the document dated 12/9/1995, the name of the defendant is mutated in the revenue records. In that view of the matter, the finding of the court that it cannot be decided, the plaintiff is not entitled for injunction in respect of item number 2 of the plain scheduled property is contrary to the evidence on the contrary to the material on record. Then coming to item number 3, the defendant has purchased the property in the year, according to him, he has purchased the property in the year 1997.
6.
No,
Item number 3.
96 lots.
1996.
17/196, third property.
Third property, 1996.
6.
Purchased the property in the year 1996. According to the plaintiff, that is also purchased from the joint family properties. As far as that property is concerned, the court has rightly rejected the case of the plaintiff. In view of the above discussion, this court is of the view that the plaintiff is entitled for injunction as prayed for in respect of item number 2 of the scheduled properties. As far as item number 3 is concerned, is not entitled for injunction and the court had rightly dismissed the petition. Next, accordingly, this court is passing the following order. The order dated so and so is set aside as far as item number 3 of the item is set aside and the petitioner is entitled for injunction. As far as item number, the plaintiff is entitled for injunction as prayed for as far as item number 2 of the scheduled properties. As far as item number 3 is concerned, the case that is rejected. Accordingly, it is partly allowed.
Lordship,
Yes.
Lordship, observation with respect to item number 3 may not be. It is a matter of trial. With respect to observation with respect to item number 3, Lordship. It may go.
Any of the, no, but I have not made any observations. It is all subject to any of the observations made by this court are only for the purpose of deciding this application and the same shall not be construed as an expression of this court.
Much.
Yes, next. All these final hearing matters give on date. Next Thursday. Take up all these matters next Thursday.
For petitioner. Sorry, madam. One submission, first list, madam. 56, kindly connect with my appeal also.
List along with friends. Yes.
Appeal for petitioner. Order. Commercial shops, my lord, auction was called for a lease of commercial shops.
Who has called for the auction?
Respond number 1.
Municipality.
Yes. My lord, petitioners are highest bidders for shop number 1, 11, 13 and 14.
Now, my lord, there were other bidders along with me. These unsuccessful bidders files an objection that they have objection with regard to they could not file an application as there was. On their objection, my lord, that is cancelled and
Who
fresh.
appears?
My lord, Mr. Mane, he was present here.
Ask him to come. Next, once he comes, tell the court officer, it will be gone.
Process has begun from morning itself.
Later, it's okay. Ask him to come. Yes, two. This is matter under the same caption on 10th of February. No representation on behalf of the petitioner. Three. Same order.
And for the petitioner, main counsel is not well. Main counsel in this case is not well.
Counsel is not there.
Not well. I think so adjournment.
It's a date may be given, because there's an interim order operating against us.
At request, this is matter on 12th of February, interim order earlier granted is extended till the.
Interim order.
It's extended.
Yes. Yes, a week's time is granted for taking steps in respect, 10 days time is granted for taking steps in respect of deceased R2. Yes, 6, list after service of notice. 7.
Lordship, serial number 6, interim order may kindly be
It
extended.
will be extended. All these matters, list after service of, yes, 8. 7 also, after service of notice. 8.
Interim order.
It will be extended. 8. Whoever asks interim order to be extended, I will not extend in that case. Because I'm making it repeatedly clear that it will be extended. Yes, 8. The petition shall do the needful in respect of R5 to R7 for issuance of notice within a period of 1 week, or else the writ petition shall stand dismissed against R5 to R7. Yes. Is there? Oh, yes, call that. What are your instructions?
This case notes, clause number 8 in the tender document says that notes, the tendering authority reserves his right to postpone or cancel the tender.
But that doesn't mean that you will, so in every tender clause.
Because they are not the successful bidders. No, the tender itself has not been opened yet.
Yes, Mr. Counsel.
And your lordship may kindly, permit me, one more minute, But what the allegations made is that, some persons, have demanded money from him. They are not made party to these proceedings. And how can, this be believed,
Unsuccessful bidders.
Who are they,
Paul, where are you? How are you
Annexure K, we are the highest bidders.
Where from you are saying all this?
My lord, I have, my lord, quoted my lord highest bid.
Oh, you have decided that you are the highest bidder.
No, they have given that this petitioners may be considered for my lord grant of allotment of these shops. They have said it in their annexure
You are
K.
making a submission before the court saying that the petitioners are the highest bidders in
Yes.
respect of so and so.
Shops.
You will not, you can't declare yourself as the highest bidder unless that's for them to say that who is the highest.
No, they have said it.
Where is
Annexure K, my lord.
Where is page number?
Page number 21. Page number 21.
Yes,
Right
what
side,
is-
my lord, 12,600, my
Yes.
lord, 4,500. They have said it to consider my case.
What is this 21?
This is, the present, notification of tender. Once again, a new tender notification has been floated, cancelling, the earlier tender notification.
Based on the objection, they can't do it. Man. Unsuccessful bidders.
Now, my lords,
reason what?
Please wait.
So what has happened is,
The statement that is made by him is correct or not?
No, my lords.
What is this page number 21?
Lords, 18, the annexure K is the present, my lords, tender notification floated subsequent to, my lords, cancelling, my lords, the first tender
Please
notification.
answer my question. That
Please.
will make it clear. According to him, page 21 is that he has become from this, one can say that he has become the successful
No,
bidder.
no, my lords, no, my lords. This is a fresh tender notification. This is not a declaration.
If I was
Nor,
not a
my lords,
successful
the
bidder, kindly see in page 18. Now, all these notices have been addressed to me that your allotment is cancelled. Kindly see my annexure A in page 18. They are addressed to me. If I was not a my lord, I had no right, or there was no allotment.
Gone through the papers.
Yes, my lords. This says you have participated in the tender proceedings. Because of, my lords, the technical difficulty, the tender notification has been cancelled.
But unfortunately, on this white paper,
Please.
whatever that is there, the black print, it won't be like, you can't have two
Please,
interpretations.
please, my lords.
It should be one and the
Then
same.
the, my lords,
At least both
we
the advocates
will
should be
produce,
fair
my lords,
to
the translation of, my lords, the Kannada documents.
No, not necessary. Both of you should be fair to the court.
Or else, my lords, lordship may kindly take, my lords, the respond number 2 is the administrative officer. Who is, my lords, the assistant commissioner?
Please tell this.
Who can, my lords, assist the court?
No, my lord, he is a formal party. I'll seek deletion.
Look at it. From any of the documents, you take the papers from him. From any of these documents, one can understand that he has become the highest bidder in the earlier auction that is called. Look at it. Call the next page. Look at the papers and tell the court. If it is not, I'll impose exemplary costs on him or you for making these kind of
Please, please.
submissions. I make it very clear.
Please.
All the,
But the tender itself is not, my lords,
all
open.
notices are addressed to me that you have been said.
If what you say is correct, I will impose costs on
Yes.
him. What he says is correct, I will impose costs.
Please.
on him. Yes, next. Yes.
I represent the petitioner. One of the respondents, respondent number 10 is dead. I filed an application for bringing the LRs on record.
Where is the IA?
I filed it, minutes.
Memo for reporting of the death. That is
And
there.
along with that, I filed IA also.
IA 1026 filed by the petitioner is returned. It is not there on record.
Returned with office objections because there was no one on record to be
So
served.
that you have to comply. That you have to
I
comply.
have to serve the copy, man. I'll do the needful.
List this matter next week.
Lordship,
Yes.
My lordship.
I want to undertake to file wakalat for respondent number 21, my lord.
So and so submits that he has instructions to file wakalat for respondent number 21.
Interim order may kindly be extended.
Interim order granted earlier.
Obliged.
You heard it?
Lordship.
Heard it. If anybody asks, I will not.
I'm sorry.
10.
This is the tender matter, my lords, where there is a direction, my lords, for the government to secure instructions. Twice, my lords, the matter has been adjourned for them to secure instructions. In respect of this mobile medical units, my lords, where the allegation has been made, my lords, stating that, my lords, the tender conditions are so well designed, my lords, in order to
Please,
help.
your lordship.
You have written instructions.
Please, your lordship, we have instructions, your lordship. I need to file objections. Matter is,
Please,
please.
as far as that instructions are concerned, if you can pass on, and look at it,
No,
then you
because
can review.
AG will appear, your lordship, in this because it affects the policy decision, is your lordship.
Come now, if it affects.
Please, your lordship, and another next week, your lordship, I need some more
They
time
are
because your
processing the
lordship,
tender, my
as it affects the our
Let them not
policy.
precipitate, my lords.
Please, your lordship,
He should be
please,
here arguing the matter. This is matter on 29th.
please, your lordship.
Let's
No
let, till
further-
then, my
on
lords,
that-
let them not precipitate, my lords,
On
with the
that day,
process.
without
We will
fail, I
not pass that kind, what you were not able to get on the other day, now we will not give. Yes.
Serial number 12, my lords, I appear for petitioner. My lords, appear for petitioner challenging the annexure A endorsement and annexure B notice issued to me for conducting the survey. My lords, there are at the instance of respondent number 5, respondent number 2, my lords, 3 has issued a notice for conducting of survey and, my lords, subdividing the property. In respect of very same property, my lords, there are 3 suits pending. two suits filed by me. One is bare injunction suit and one is declaration suit. And as well, respond number 5 and his family members have also filed, my lords, bare injunction suit in respect of very same property. And despite bringing notice to his knowledge about all the three suits, he issues an endorsement stating that since there is no injunction order passed in the civil suit, I cannot stop the survey work and subdivision of the property, my lords. Since suit is bare injunction suit, definitely, my lords, it will affect my rights, my lords.
Your lordship, as the suits were pending, your lordship, between the parties, and as per.
Them are disputing their, with regard to the properties and
Please,
file
Your
their
Lordship.
respective suits. When the civil suits are pending, what you will do?
Earlier also, they have approached this honorable court, your lordship.
Oh, the-
Please, your
The
lordship.
survey that's going to be conducted is
Conduct.
with the dispute inter se.
Please, your
You have
lordship.
already
There.
approached the civil court. What you will do by doing all this?
Please, your lordship.
Please come. When counsel appearing for the petitioner submits that which respondent?
Respond number 4.
Respond number, my lords, 3 and 4, my lords.
3, your lordship. 3.
The respondent number 3 and 4 have issued the notice to the petitioner,
Endorsement, your lordship.
issued the endorsement for conducting the
Survey, your lordship.
endorsement is not for
Endorsement
conducting-
issued by the respondent number 3, your lordship, annexure A,
Hmm.
saying that will conduct as there is no interim order passed by this honorable court.
That endorsement is questioned.
Please, your lordship.
The endorsement issued by the third respondent
Please, your lordship.
is questioned before this court. The land counsel, the petitioner submits that in respect of the very same property, both the petitioner as well as an official respondent, there is a respondent number 5, have filed the suits. When both of them are disputing, there are disputes with regard to the property, there is no purpose of conducting the survey by the respondents. Considering the submission, there shall be stay of all further proceeding pursuant to the so-and-so. HCGP takes notice on behalf of.
Respond number 1
to 4.
Please, your
1
lordship.
to 4, issue notice to respondent number 5.
Please, your lordship.
Yes.
Please. Obliged, my lords.
Appealing for respondent filed, I for withdrawal of amount.
I number 1 of 25 is filed seeking to withdraw the amount deposited by the petitioner. Land counsel, the petitioner submits that he has no objection. Accordingly, IA is allowed and the respondent is permitted to withdraw. Next 14.
Please.
The petitioners have. In this, we have initiated the proceedings under section 14 of the Karnataka Public Means Unauthorized Occupants Act. Notice was issued and it is duly served on them. And final order is also passed under section 5 of the.
It's already passed. It's an appealable order.
Yes, my lord. Under section 10, they have to file the appeal with the before the district.
Passed under section 5.
Please, my lord.
10 is the appeal provision.
Appeal lies to the district judge, my lord.
District judge.
Please.
My prayer was that only I should be evicted by due process of law.
Naturally.
That is there.
Unless when an order is passed without questioning that, how can you ask that?
My lord,
They followed the procedure by. they
Earlier
followed
to
the
this-
procedure.
earlier-
Now order is passed. Now it's
after
only-
this, they have passed. my lord.
Whatever it is, now the order is there.
No, no, no. Order is passed long back. May I pass out? Sorry. It is in Kannada language. It is passed on 26/12/23.
Please, my lord.
The present writ petition is filed. Seeking the following prayer.
After this, we have issued a tender notification that is challenged before this honorable court.
The facts of the case are, it is the case of the petitioner that he has allotted with shop number 1 on a monthly render basis belonging to respondent number 3,
3 and 4. my lord.
3 and 4. It is the case that the shops are old and the petitioner invested the amount for its improvement and started stationery shop in the said premises. Original agreement was for 11 months and same was continued till today. Very cleverly, no dates, nothing.
Which one?
Agreement is in the year 2010,
Yes, my lord. Since from,
11 months.
if they have accepted the rent, same was continued, my lord. I have produced the rent receipt, my sir.
Maximum period is 3 years.
But they have accepted.
What are you doing? What were you doing without vacating the tenant?
2000 till 2023, 24, they have received the rent.
After this, my lord, they are unauthorized occupants.
When is the lease?
Lease period expired
2010.
long back, my lord.
So that's what I'm asking. When did you wake up? That's the question. What is it? Till today.
Last rent was paid on
You have
19
no
by
vest-
2020.
you have no vested right. You can't come before the court first.
Please,
It is a case that the petition is in possession of the shop more than 16 years. The respondents, without removing the petition number 1 from the said shop, cannot conduct the auction. The land counsel appearing for the respondent submits that a notice was issued to the petitioner under the public
premises eviction.
Karnataka Public Premises Eviction of Unauthorized Occupants Act.
notice is issued by
Pass
the respondents under section 5.
4 notice was issued. Final order is passed on section 5.
4 of the Karnataka Public Premises Eviction of Unauthorized Occupants Act 1974. And an order was passed on
Final order was passed on 14/12/2023. Sorry, my lord. 26/12/2023.
26/12/2020.
12/2023.
26.
After that only we have issued a notification.
12/2023.
Tender.
And thereafter, they have issued the tender notification. He has questioned the said tender notification before this court. It is submitted that against an order that is passed under section 5 of the Karnataka Public Premises Eviction so-and-so Act, then appeal applies to the district court.
Court under section 10.
Under section 10 of the Act, it is submitted that without questioning that order, the petitioner cannot stall the tender process. Next, for having heard the counsel for on this act, there is a material non-record. Admittedly, in this case, the lease was granted in the year 2010. It is for a period of 11 months, extendable up to 3 years. In this case, for a period of 16 years, the petitioner has been in occupation of the property. The petitioner has no legal right to continue in that property when the lease is not extended. Mere acceptance of the rent by the respondents would not give any right to the petitioner. That apart, when an order is passed under section 5 of the Act, as long as back in the year 2023, the petitioner, thereafter when a tender notification is issued, petitioner has come before this court by filing a writ petition in the year 2025. Even on that ground also, the writ petition is not maintainable. Accordingly, the writ petition is disposed of, giving liberty to the petitioner to avail the appropriate remedies.
Much obliged.
Please, Lord, this matter listed previous equation. Lord, this pertaining to, Lord, the laborers, Lord, where now the corporation has decided to pay them, Lord.
Yes,
Now the,
my
Lord,
lord.
yes.
That's why he was saying that he's out of the court, we'll send him.
Yes, any allegations against these petitions?
Please,
my lord,
just kindly,
Do that
Lord, even some FIR also filed.
against him.
Present petitioner ಮೇಲೆ ಇದೆ.
There are, no, Lord, there is serious, Lord, there are more than 58, Lord, just I'll take, Lord.
His client is properly not instructing him.
ಇಲ್ಲ ಇಲ್ಲ
Taking
my lord,
back by
No,
everything.
there are, Lord,
Strictly
more than 80, 50, just, Lord.
Now let's see, who is the petitioner?
No, there are, Lord, more than, in the present matter, Lord, there are more than 14 petitioners, Lord, separate the senders, Lord. But total, Lord, Hubli Dharwad Corporation has, Lord, given more than 58 different
please point out in respect of this petition.
My lord, since I have, my lord, kindly, please, my lord, the first annexure, my lord, I've just narrated, my lord, given the representation given by the entire laborers, labor unions, my lord, including the persons who are working in the, who are the members, my lord. My lord, the first is since in English, my lord, I've just, it's the paper cuttings I produced just to show it, my lord. I'll go by one, my lord. They demanded, my lord, that in terms of government, that the payment has to be made directly, not through the, my lord,
Where are you reading?
the first annexure, my lord, the first page itself, my lord, memo. This is a paper cutting, my lord.
Yes.
So initially, my lord, they given, my lord, since from last 2-3 years.
Understand, what is that you want to point out in this?
Now I'm just pointing out, my lord, there is representations were submitted by the entire laborers, my lord, from last 2-3 years, requesting that, my lord, these, my lord, contractor are not, my lord, giving the payment, my lord, properly, and therefore, my lord, they requested that the payment has to be.
That I understand.
Now, sir, these are the representation, my lord. Now the running page 3, my lord, it's in Kannada, my lord. This is by the Legal Service Authority. The legal state legal authority, where they given the direction, the legal in turn, my lord, requested us, the state legal service authority, and also, my lord,
Yes.
us to consider their claim, page number 3, my lord. It's
Yes.
in 3 is, and 5 also, my lord, district legal service authority. They direct, my lord, now the district authority not only directed us, they given a report to the, my lord, the High Court Legal Service Authority, that such a prayer is they made, since still they are not considering their answer. Now the 7 onwards, all the representation, my lord, by these labor unions. Yes.
Where is that in, specifically point out about this petition?
The petitioners. No, these laborers unions are working in the all the laborers where we are contract is granted, including, Lord.
Please come.
Please.
The present writ petition is filed. Seeking the following prayer. Facts of the case are: petition is a contractor carrying the work of solid waste management on contract basis. It is the case that the petitioner's husband was entrusted with the work order to collect waste from door to door and to keep the streets clean from 1/11/2009. One contract was signed between the petitioner's husband and the respondent number 1 on 30/10/2009. In the year 2020, 14 laborers of the petitioner were employed under direct payment scheme, and hence presently there are 9 workers with the petitioner. The work order passed by respondent number 3 in favor of the petitioner's husband is placed before the court. The said work order was extended from time to time. As per the work order, the petition has employed 23 workers for effective implementation of the implementation of the contract. In some cases, due to unavailability of the labor, the petitioner also got workers from other states and districts for successful implementation of the work. And without fail, he has been paying the salaries. It is stated that the petitioner has invested more than 15 years of life tirelessly
implementing the work order and contract. It is the case of the petitioner that the respondent number 2, in consultation and under direction of the state, has been issuing directions and orders. He has passed an order dated 24/4/2025, wherein the respondent number 2 has order for fixing of minimum wages, variable earners relevance, and it has to be, VDA has to be fixed from 1/4/2025 to 31/3/2026. Even the petitioner has been implementing the said order. And the same was intimated to the respondents. It is a grievance of the petitioner that respondent number 2, without issuing any notice or opportunity to the petitioner, has passed an order dated 22/9/2025. As for the said order, the respondent number 2 has instructed respondent number 3 to pass an order terminating the contract and work order of the petitioner from 30/9/2025. It is stated that the respondent cannot unilaterally cancel the contract without issuing any notice. Till what time this contract is there?
From 2009.
Nine,
Now, after extension.
there is no extension. It's only,
They're just.
only one order. It stays till next. That's only, there is no extension.
Huh?
From 2009, earlier, from 2010, it was extended. Still, until.
No, there is no, till next date of order, next order is, there is given, only one order. First time, there's only one.
Understood, I understood. It is submitted that they have represented to the respondent, but the respondents have failed to consider the same. Then counsel appearing for the second respondent, you appear?
Please, do anything.
Then counsel appearing for the second respondent submits that there are several complaints received from all the workers who are working with different contractors like the petitioner, that they are not paying their wages. In this regard, they have given the complaints to the Legal Services Authority and to different authorities. Then in the interest of the
There is proceedings under the Provident Fund is also initiated, and
the proceedings
and
under
that list also I
Provident Fund
produced, not where they have not deposited the.
initiated. It is submitted that in the light of these complaints which are received by the petitioner, by the respondents, and taking into consideration the interest of the laborers,
Please.
the respondents have passed the order whereby they are utilizing the services of all the
Yes.
laborers who are working with all the contractors, and now the corporation.
Yes, yes.
And the corporation is directly paying the salaries to them.
Please.
This action of the respondents is in the interest of the larger public, and the petitioner has no right to question the order, as there is no existing contract, that is an existing contract in favor of the petitioner. Next part, having got the learned counsels on either side, where is the material on record? The learned counsel appearing for the second respondent has placed before this court a bunch of representations, the representations to several authorities, and the news items in the print media, which shows that the contractors were not paying the workers, paying the labor, and also even the Provident Fund is also not paid. In that regard, already the proceedings are initiated. The petitioner, who has no legal right to come before this court, and a decision that is taken with the second respondent is in the larger public interest, this court exercising the jurisdiction under Article 226, and the petitioner cannot pass any order, and find any reasons to interfere with the order impugned accordingly dismissed.
Please.
Oh, all are same order.
Please.
Grant permission. 18.4 my lord, 15.4.
15.4.
my lord. That my lord, the annexure E my lord, for a moment. In that they have stated that my lord, after even in the.
Please understand,
Please, my lord.
there is no
have
existing
extended-
contract between, agreement between you and them.
Please, my lord.
Now, it is, now if they have, they said that from now onwards, we don't require your services. And they have engaged all your labor, all your employees who are with you, all laborers. So we can't, there can't be, we can't find fault with, which is done in the larger public interest. That too, you can't avail a public law remedy for that.
But my lord, they have issued a notice stating that my lord, until March 2026, you have to provide the services. That has been stated, they have.
Anyhow,
submitted-
now they have taken a uniform decision, will not find fault with it. Yes, till 15.5, dismissed. Yes, 16. All similar facts. Only that petitioner's husband and all what is that, not just verify from other.
Your Lordship, in these matters, in this.
In 16, I
16
appear
and
for the
18.
petitioner.
Yes.
If my lord recollects, on 8/1/2026, my lord, we had filed an order of the coordinate bench. A detailed order, my lord, wherein the government order, which is questioned in this petition as well, has been quashed already. So,
Please,
my
Your
lord, this,
Lordship, that is quashed.
it is squarely covered, my
Your
lord.
Lordship. But we have filed, prefer an appeal also, Your Lordship, on those matters.
Then
We
you
have
will, you will prefer appeal in this also. Why should he be deprived of an order?
Please.
Yes, please. No interim order in that.
No, Your Lordship.
Yes.
No interim order.
Where is that order?
I had filed it
This
on
is the
8/1.
one.
That is.
Do that. The present petition is filed, seeking the following prayer. When counsel appearing for the petitioner submits that this issue is clearly covered by an order passed by a coordinate bench of this court in writ petition number 105933 of 2025. Then counsel learned HCGP does not dispute the fact. However, it is submitted that they are, it is submitted that they preferred a writ appeal against this order.
Please,
And the same is pending consideration. Next one, having heard the counsels on either side, there is the order that is passed by a coordinate bench of this court. There is no dispute about the fact that in the appeal, no order is passed with the division bench. In that view of the matter, in the light of the order dated, order in WP number 105933 of 2025 and batch dated 10th December 2025, the present writ petition is disposed of like same. The operative portion, same one.
Serial number 18 also, Your Lordship.
Same order.
18 also.
18, yes.
Please.
18 also same order.
I'm grateful. ma'am.
Lord 17, my
Yes.
lords, I appear, my lords. Lords, may I request, my lords, for tomorrow? Why a
Yes.
senior advocate, my lords, is held up.
What is this matter?
It's regarding the tender, my lords. Initially, I applied for the tender. NWK it is called tender for some shops. I am the eligible. Then, my lords, they stated that wrongly some shops they want to use for civic amenities. So I gave up my right. After that agreement, now they have called again fresh tender for the same shops on which initially I was the successful bidder, and on their request I have given up my right. So no.
You were a successful bidder and
Please.
your term is not complete.
No. Term is till 2032. So they
What we
said
had
that-
what we had given him was, my lords, 6,861 square feet. I have produced
Lords,
the
may-
agreement along with my statement of.
Lords, may I make one submission, my lords?
Senior, my lords.
Yes.
My lords, may I make one submission, my lords? If the respondent, my lords, is ready with the matter, my lords, if he is ready with the proposal, my lords, if they can call, my lords, re-tender, my lords, the same issue, my lords, then we can participate. Or, my lords, if they say they will not allot it to, my lords, the business which the petitioner is running, then that is also, my lords, fine with the petitioners. Now, my lords, I am running.
If I had engaged a senior, he is my colleague.
My lords, he is held up, my lords.
Yes.
That is why, my lords, in fact, initially I requested. Am I audible? my lords?
I did not understand their offer. But if they have an offer, well, I'll put forth that to my clients, and we can come back, my lords, if we are agreeable, or else we can go on
My lords,
merits.
if they call a fresh tender, my lords, then, my lords, we have no grievance, my lords, this can be closed.
Already tender is called now by virtue of interim order, this tender has been stayed. Now, I'm still not able to understand his offer.
Forget about what is his offer.
Please.
Now that is for you to say, when you have taken the, he has become an highest bidder. isn't
He
it?
is the highest bidder for own plots. What we had called in the first tender was only 6,861 square feet, but he had, my lords, encroached upon 10,000 square feet. 6,800 was what was allotted to him. An agreement was entered into between the corporation and the petitioner, and he was, my lord, supposed to occupy only that.
But you have not initiated any proceedings for that.
We have issued him the
My lords,
final
there is
notice
no
also.
encroachment, my lords. My learned friend may make it correct, my lords. It's not an encroachment. There was a, please.
Let him complete. Yes.
We had issued
My lords,
him
in fact, there was a
notices
mediation
on
that
the
was
same
held.
lines.
Please.
On the same lines, my lords, so we had issued him notices. 2-3 notices were issued. Final notice was issued after, my lords, the final notice. My lords, there was a kind of settlement talks, my lords, which had taken place between the petitioner and this corporation. There, my lords, he had made an offer that he says he is going to give up the excess land that he has. No question of giving up, but that is his terms. That he will give up the excess portion of the property he is encroached upon, provided he puts certain conditions. And my lords, he gives a map along with that. We said, as for the first tender and as for the agreement, you are entitled to only 6,861 square feet. You stick on to that. Other conditions, we are not going to accept it. He agreed to this. There was also a supplementary agreement executed. I have produced that. Thereafter, my lords, we have called for fresh tender. Now, his contention is that the fresh tender that we have called it on his portion of the land. That is not true.
No. What his submission is not that. What he says is you wanted this land for some other purpose, and
Yes.
after taking this land from him, you have put it to auction. Is his
That is
contention?
no, because he.
From what is the
Certainly,
material in
certainly,
support
my
of
lords.
that?
May I, my lords?
There is a
Sure.
my lords, consent agreement entered upon between the my lords.
The court is more comfortable hearing counsels who are before the court than online.
Well, I agree, my lords. But Annexure D is the earlier agreement, which is in Kannada.
What is it?
No, the agreement is in English. I have produced it
No,
along with.
whatever you are saying,
Prastavana.
where is that? Where is that? That they have,
38.
they have promised you something
38,
and.
page 38, my lords.
30?
8.
Yes, what is this, page 38?
My lords, this is the settlement, my lords, that I am talking about. In this settlement, my lords, he gives two proposals. We accept these part of the second proposal, wherein he says, I will give up the excess land on certain conditions. That the remaining portion you will not call for tender, you will not call for commercial tender for commercial purpose. He is on an assumption, my lords, that he occupies the entire area. He is to only.
Why are you signing all these kind of, being a corporation? Why
Please.
are you indulging in this? He will say 101 things.
But that's why, my lord, this is only his proposal. I have also produced, my lord. My lords, let me show, my lords.
No, his proposal is his problem. Where is where? According to them, you both of you have accepted and signed.
Sign, please.
Yes, there we have only, my lords, said that we agree with his map that he has, hand sketch map that he has submitted along with his proposal. That is the only thing that we have agreed to, and not to the conditions. His condition was that for the.
Everything is written on a paper.
Please, my lord.
You will sign it and you will say, I
Please.
have not accepted for one, but I have accepted for two. How
We have
is it
said that we will
acceptable?
take into consideration your hand sketch map. Accordingly, my lords, we have also entered into a supplementary agreement to which he has also signed.
No, why are you doing all this exercise with
Lords,
him?
what had happened, my lords, in the first tender where he was the successful bidder, a certain portion of the land measuring 6,861 square feet was allotted to him. He, my lords, occupied 10,000 square feet.
Let him also participate, call for the.
No,
fresh
we have
tenders.
already, my lords, called for the fresh tender. No,
Happens now. Now that is stalled.
bids that is stayed, my lords, we have already received the bids. No, my lords, he, being at fault, cannot, my lord, dictate terms to the corporation. That is one thing.
No, corporation is also not right by entering into these kind of.
No, in the, my lords, let me, my lord, just show the agreement where we have, my lords, along with my vacating application, my lords, I have filed at page number 8. Page number 7, my lords, is the agreement. Then page 8, my lords, next page.
Why you have not participated in the tender? When they have called for the tender, you could have participated.
Since my lord, there is a agreement
Whatever
in my
is your
favor.
internal understanding between you and them,
Please.
if when the tender is called, why you couldn't participate?
My grievance is, my lord, since it was, there is agreement between me and him. And my lord, it was also agreed that they will not use it for commercial purposes.
If he, that is his
That
property.
is not accepted by the corporation.
No, that is his property. Whatever he wants to do, he will do it. Who are you to dictate terms?
That I agree, my lord. But my lord, since I am a successful bidder and I have invested, the initial bid was in year 2022. And my lord, from 2022 to 2024, I constructed.
Both of you are entering into agreements and signing on papers. We can't call them even agreements, which are unenforceable.
No, my lord, as per their agreement, if they use it for civic amenities.
Assuming that, can anybody stop you from participating in the auction? Why did you not do it? Now the proposal which you are putting forth before the court, why can't you do it? Is it an agreement that you should never enter into any, participate in any tender process?
The agreement is that, my lord, they are not going to call a fresh tender itself is the agreement.
It's all, you want to litigate for the purpose of litigation.
Tomorrow, my lord,
may I make one submission, my lords?
Yes.
My lords, may I make one submission, my lords? My lords,
Yes.
my lords, we have no objection, my lords.
For what?
His intent tells that, my lord, if they call a fresh tender.
You have no objection for what?
Objection, my lord, for them, my lord, initially to, my lord, we passenger on for my lord, and I went back give out the end without any damage for corporation. They proposal.
May I make one submission?
No, my lord,
It seems, my lords, they have some offer.
activity.
It seems, my lords, the petitioner has some offer to make. Now, one of these conditions, my lords, that he should be allowed to participate in.
The thing is that
Assume
Why are you taking these kind of agreements?
the agreement, my lords, as far as our stand is concerned, it is only in respect of 6,861. It is very, my lords, in black and white, it is mentioned, he has signed, we have signed. It is only 6,861 square feet. Now, if he has encroached upon the excess, there is no question of he giving up on some conditions.
Whatever agreement that
Please,
he is relying on.
Please.
In that have you.
Kindly see it is an order.
No, that was his condition which he did not agree.
That's not there in the paper.
That is not there in the paper.
Then basing on what you say that this is what they said.
Annexure D, my lord, it is very much stated in Prastavana 2, the condition number 2.
Read it for him.
ಒಂದು ವೇಳೆ ಸದರಿ ನೀರಿನ ಟ್ಯಾಂಕ್ ಉತ್ತರ ಪಶ್ಚಿಮ ಪೂರ್ವದ ಸ್ಥಳವನ್ನು ಪ್ರಾಣಿಗೋಸ್ಕರ ಅಥವಾ ಲಾಂಚ್ ಇತರೆ ಬಸ್ ನಿಲ್ದಾಣ ಅಂದ ಹೆಚ್ಚಿಸುವ ಕಾರ್ಯಗಳ ಸಂಸ್ಥೆ ಉಪಯೋಗಿಸಿ ಹೆಚ್ಚಿಸಿದಲ್ಲಿ ನಾನು ಸದರಿ ಮೂಲ ಸ್ಥಳವನ್ನು ಬಿಟ್ಟು ನೀರಿನ ಹಿಂಭಾಗಕ್ಕೆ ಹೋಗುತ್ತೇನೆ.
That is his proposal.
No, that has been said, my lord.
It is his proposal. In fact, there is an agreement also. There is an agreement also, my lord, which after this proposal. I'll, my lord, put.
Are you trying to say that even the proposals will also be signed by both the parties?
No, no, no. It was his proposal.
What is signed?
No, that was, my lords, in the meeting. That meeting was signed by all who were present. In that, he puts forth his proposal.
Please file the
Translated copies. So may I, my lords, request this matter to be taken over second or third, depending upon the convenience of the court. Lords, yes.
Please.
Interim will be extended.
Yes.
Interim order, my lord.
Why should we grant an interim order in this kind of matter?
Because, my lord, since the property which I have given up my right has been put to auction.
What is your right? Are you the owner of the property?
No, my lord, but I have.
He's an encroacher, that is our objection, my lords. He's an encroacher on that.
I will definitely, once I look at that agreement,
Please,
whatever so-called agreement, I will definitely pass switches on your officers for entering into these kind of agreements with and creating unnecessary litigation. Yes, next.
Granted, my lord. Next.
Interim order earlier granted is extended till then.
Please, ma'am.
Please. I'm for the.
Where for the
Statement.
petitioner minutes. Petitioner has filed an application. Recently, my lord, and he has paid 5,10,000 rupees. If a bank recovery proceeding is initiated, one ODS scheme, my lord, he has made an application that is not yet to be considered. My lord. They recently made a 5,10,000 rupees. That is the 10% of my lord, the required amount is.
How can you question this order of under section 14?
My lords,
The what ground?
surfacey matter. Initially, this court, my lords, had granted an interim order, my lords, subject to deposit of 50%.
Did he deposit?
No, my lords, that
There
has
is
not.
an interim order. Give the order sheet. Yes,
He has not deposited, but I am not
you are
disputing.
not, first of all, writ petition is not maintainable. Second, you have not compared with the interim order. Nothing survives for.
The only ground on which my petition is filed is
We
the,
will not entertain this kind of writ petition.
the property is situated my lord, in outside the jurisdiction of the, my lord, the court.
That you can question before the DRT also.
No, it is under section 14.
Yes, section 14. After that, you can go before the DRT.
No, this trial court my lord, has,
Order of section 14 can be questioned before the DRT under 17.
Please.
Agreed by the order of the present writ petition is filed, seeking the following relief. It is
my
stated
my
that-
request my lord, is it's only to settle the matter. He has already made a 5,10,000.
Petition you would have paid, you would have completed.
Yes, yes, I do agree, my lord. Because of the COVID, my lord, he has suffered the loss, huge loss in the business. Therefore, this,
Every case in with every bank loan amount.
but recently has made the, my lord, 5,10,000 rupees and submitted an application. So 50% of, my lord, that amount is there.
What is the outstanding?
68 lakhs and odd, my lords.
The petition has availed a loan of 45 lakhs from the respondent number 2 bank. And mortgage the properties. That is 2 open plots, number 110 and 111, situated at Katagi. It is the case that as a petitioner has failed to pay the loan amount due to his financial constraints, the bank has initiated the proceedings as the Surface Act. A notice was issued under section 13(2) of the Act. Thereafter, even 13(2) is not applied.
No, my lords. Now they have given the OTS, my lords, in the month of January.
Thereafter, the bank has filed an application under section 14 of the Surface Act, and an order was passed on 29/4/2025. That is assailed before this court. Learned counsel appearing for the petitioner submits that petition is ready for a one-time settlement, and hence till the one-time settlement is considered, the bank shall not, there may be a direction to the bank. His proposal is pending.
Now in the month of January, he has given OTS representation.
That is open now.
That is open, my lords.
Then we will do one thing, till consideration of that, don't take any coercive steps. Or else then if you don't accept, you'll go before the DRT. If you are considering and at the same time you're going ahead under Surface A, it doesn't make any sense.
We have already taken the possession.
No, let it be there as it is.
Please.
Till, don't take further steps from 14.
Please.
What did you do? Offer is considered by the respondent. No coercive steps shall be taken by the bank. Land counsel appearing for the respondent submits that when they issued a notice under 13(2), the petitioner has not even replied to the same. A coordinate bench of this court on 18/6/2025 has passed an order directing the petitioner to pay 50% of the amount. So far, he has not paid the same. It is submitted that the petitioner has an effective alternative remedy before the debt recovery tribunal, and he cannot come before this court. The petitioner has failed to comply with the interim order. Even on that ground, the writ petition is liable to be dismissed. It is submitted that the petitioner has come up with a one-time settlement proposal, and the same is pending consideration before the bank.
Please.
Pending consideration before the bank. Next, for having heard the land counsels on, you have specific instructions?
Pardon?
You have specific instructions on that?
No, it's-
Whether it is, no, whenever he gives a proposal, you can't, there should be a proposal, can you get instructions?
There must be a prevailing OTS scheme, my lords.
That's what I'm saying.
Please, please. There is no such.
This is matter, on the top of the list, type it and keep it in the file. Get instructions tomorrow.
Please, tomorrow, please.
Tomorrow or some other day?
No, some other day.
It's a matter on Tuesday,
28,
Tuesday,
28. May I?
28.
Please, great.
28 as part heard. Yes.
Please, my lord, for petitioners, my lord. Petitioner are the agriculturist, my lord. Without issuing notification or anything, my lord, the government authorities are forming a new road. On the last occasion, earlier bench of this honorable court has directed the government advocate to secure instructions, my lord.
To see that also. Restraint from forming a new road in the petition property.
Your Lordship, page number 17.
Have
Your
you filed
Lordship.
your objections?
No, Your Lordship.
So from now onwards, when an interim order is passed and no instructions comes from the respondent, we will adjourn, we will extend the interim order forever. It will never come till you file your objections. That should be the procedure. An interim order is granted on 18/12/2025. The respondents have not filed their objections. The interim order earlier granted is extended until further orders.
Please.
If you want to file the vacate petition, it will come.
Please.
In all the matters, I'm going to do it. I will extend the interim orders until further orders. If a vacate files, then it will come. Yes, 20,
Here, my lords.
20 or 21.
So I've challenged the constitutional validity of an amendment, my lords. But your lordship, the amendment is brought in, my lords, to the Karnataka Sauharda Sahakari Act 1997, my lords. It's for a moment, but before the, my lords, the,
What is the interim order you're seeking?
but for implementation, my lords. But the Sauharda Act, my lords, the statement of objection, if lordship would see 1 and 2 of the statement.
Come up with please objections.
Now what has happened? The act initially, my lords,
If you're questioning the act by they have to file their objections.
no,
to
if
the-
they start implementing, my lords, for example, my lords, 1,000 crores of investment is there in the society, my lords. 20 crores, my lords, I have to keep with the state liquid reserve. Now they,
I'll ask AAG to come. Please, this matter on 3rd of February.
please.
Yes.
Petitioner is challenging the entire proceedings under section 12 of a domestic violence. Yesterday, your lordship has asked me how writ petition is maintainable. Recent Supreme Court judgment, your lordship, wherein in this case, your lordship, this honorable court has set aside the 482 petition saying that there is no 482 jurisdiction to try quash the section 12 proceedings of domestic violence. However, your lordship, it is clearly mentioned, your lordship, even writ petitions are also not maintainable. Both are maintainable, your lordship. The only interpretation made in this judgment is, your lordship, the DV Act, your lordship, jurisdiction was only explained in section 27, read with section 2, 1, clause 1 of a DV Act, your lordship. However, it is clearly stated, your lordship, it is a civil in nature.
Come to that.
Please, it is a civil in nature, your lordship.
Where did you say that writ petition is maintainable?
Clearly, it is not stated writ petition is not maintainable also. It is stated that, your lordship, it can be tried in the both. Otherwise, your lordship, I'll furnish the memo for conversation. However, it is writ petition, I'll make correction read with.
Petition is not maintainable.
Please, I'll withdraw, will your lordship, with liberty to file for it.
Yes.
Yes, I'll furnish the memo immediately.
Petition is filed. Questioning the procedure, questioning the order that is passed under the Domestic Violence Act. The petitioner, the present writ petition is not maintainable. The writ petition is disposed of giving liberty to the petitioner to avail the appropriate remedy.
Please,
Yes,
grateful.
Yes.
Your Lordship, this is a
Last
recreation,
occasion, my lords,
recreation club, your lordship, where I have got information that they are doing some illegal activities. For that reason, they used to visit the premises. For that is there,
Now
for
let us
checking
see-
up, your lordship.
Let us look at the petition. According to you, what is the kind of interference? When did they come?
Lords, if that is the case, my lords, they would have initiated the.
First of all, before going to the respondents, you have
Please.
you have come before the court saying interference.
Please.
Where is the interference? When is the interference?
My
How
lord,
is the interference?
They are directly they are directly calling us, my lords, and they are harassing
You
that.
can tell
to
the,
close.
you can tell them and when, where they have called, where did you say?
Lords, they visit.
They're all called vaccination writ petitions. Even before something is done, you file a writ petition, take an order, so that they shouldn't do anything.
Indeed, my lords. In the last occasion, when the petition
Tell
was
all
filed.
that. I will please tell the court, come to this petition, show one line, where did you say, when did they come to you? There should be specific averments in
Please.
a writ petition. Please show.
My lords, I would I would present the videographs or photographs, my lords, while.
What, without any pleadings, why
Please.
should we look at all that? In all these writ petitions, what I am finding is just like that, because there is an order covered, we should file another writ petition, one writ petition.
My lords, the general problems, my lords, we are facing in that particular area, my lords. The several writ petitions are filed. While the new officers are getting appointed, they are
Not on that, Mr. Counsel.
Please.
I'm not on that. You're not understanding what is the query of the court. I am saying, if you say this is your problem, you are at liberty to say everything and anything. That you should be there in your petition. Where did you say?
My lords,
Please come to that.
Let's to show that exactly where the police authorities are disturbing, like they are not issuing any handwritten notices or nothing.
Necessary. You're saying police have called. You're saying police have come. Can't you say on which date they have come if it is, if you're so assertive of the facts? And writ petitions can't be filed like this and entertained like this.
Well, let's see if that is the case, my lords, let them do something.
Why should they? It's for you to say. You have come to the court. It's for you to say. At least I'm not asking you to prove it. I'm asking you to at least to say what it is. Without even a pleading, how can this kind of writ petitions
Let's,
are filed? And why should the courts pass orders like this?
Lords, with respect to that point, my lords, I'll try to make specific amendments, my lords.
Shall
But
file the petition shall come up with a better the additional,
please,
what do you call, affidavit stating when and where and how the interference is from the police.
please, my lords.
Yes.
Lords, I request it on 28, my lords.
Huh?
28. I'll file it, my lords.
Yes, 28.
I'll have it.
Yes,
29 or 30th, your lordship. 29 or 30th, your lordship.
No, that's
Meanwhile,
for him to file an affidavit, please.
Please.
Yes.
For the petitioner, your lordship, we are challenging annexure A and B, your lordship. That is the order passed by respondent number 2 and 3, your lordship. Here, the petitioner has been disqualified under section 29C of the Cooperative Societies Act, your lordship. Here, the fact is that, your lordship, the petitioner has availed a loan amount of rupees 25 lakh just because he has not he has not pledged any property as a security. On that ground, they have disqualified, your lordship. But that ground is not been specified under section 29C, your lordship. So my submission is that section 29C is not applicable to the petitioner, your lordship. And another important submission is that, your lordship, before passing an order by the respondent number 2, your lordship, before passing an order of respondent number 2, your lordship, I have mortgaged a registered mortgage deed, your lordship, on 22/8/2025. And I have also made an application to the registrar seeking an encumbrance of these records, your lordship. And in column number 6, the respondent number, the fourth respondent society has been reflected, your lordship.
Yes, what do you say?
Lord, today, my lord, I have sought a statement of objections. Not I am permitted. Much of the case is not. The petitioner is a director. My lord. In the year 2018, he sold the landed property in favor of a third person. 2019, the property which he was sold, he availed a loan from the society. 2019, 20, 21, 22. 4 years.
When was the property sold?
In the year 2018.
When was the loan availed?
19, 20, 21, 22. This is a crop loan. When he not a owner of the property, but
that in respect of that agricultural
that land, old record of rights have been furnished. As he is a director, he furnished and availed a loan, and for that is one of the fraudulent act committed by him. Then another is he availed a loan, a sum of rupees 25 lakhs in the year April 25. At the time of availing loan, he has not executed any mortgage deed. When we filed and raised the petition before the first authority seeking a disqualification, he appeared. Immediately, he approached the competent authority to get mortgage his father's land as a security to the loan. Therefore, the act of the petitioner is
acted fraudulently and gross negligence, contravention of the provisions of the Act and rules. Section 29,
Under which provision?
under section 29C, 8 provides,
Let's see.
please. This is not a defaulter or anything, Lord.
You have given her a copy of objection?
Yes, Lord,
Your Lordship,
I've given the other,
my submission is, Your Lordship, the disqualification before this present petition is only with regards to availment of loan, rupees 25 lakhs.
Let's look at section 29.
please. But may I read now?
Yes.
Lord, 29 is disqualification of membership of the board. Lord, we considered, my Lord, 8, my Lord. If any member of the board of the cooperative society during the term of his office, my Lord, A, my Lord, I skip
29C?
29C 8, my Lord.
8.
8.
Clause 8.
8, my Lord.
Yes.
Please. If any member of the board of the cooperative society during a term of his office becomes subject to any disqualification specified in subsection 1, 2, 5, Lord, that is not applicable. B, Lord, has acted or has been acting fraudulently or with gross negligence or in contravention of the provisions of this act, rules and the bylaw of the cooperative society. Lord, this my contention, Lord, I have made a complaint on this provision. And D, my Lord, and is not discharging his duties satisfactorily, the registrar may either on the report or on the complaint. But I have made a complaint on the allegation of not these 3 grounds. Lord, he appeared before the Lord, original authority. He remained silent. Lord, he not filed any objections, not produced any documents. The first authority, Lord, prima facie found that loan was taken in the year 2000, property was sold. Lord, I produced a sealed copy in the year 2018 sold. 19 loan was availed, and up to 2022, every year he used to take more crop loans.
Now you have stated all this in your
Yes, statement of objections.
the comes for the
Your Lordship,
the-
one
the
submission, Your
petitioner shall file the petition, the rejoinder, if any, by the next date of hearing.
Please,
Plus this
Lord,
matter on 10th.
Your Lordship.
Lord, I will take
Your-
note, notice to Lord, other respondents, respond number 7, 9, Lord, remaining respondent, except Lord, the notice has to go to Lord, the society only.
Your Lordship, my one
The
humble
respondent-
submission is that, Your Lordship, whatever the loan transaction they're speaking about regarding 2018-19, Your Lordship, in the complaint itself, they've stated that all have been repaid in the year
It's not about
2023.
repayment of the loan.
Not
You
repayment.
have taken
But-
the loan in respect of, you have taken a crop loan.
Please,
For
yeah.
that, you need to have a property. That property is sold much before.
But that property is not in dispute, Your
That's why you
Lordship.
reply. That's why I've given you an option. Yes.
But others not, I have taken notice, not, notice to respond number 4 is not, Lord's issue notice.
Respondent number 4, issue notice.
Please.
Yes,
Your Lordship, I'm seeking for interim order.
yes. Yes.
My lord, defendant's writ petition, my lords. My lord, 3912 filed by the plaintiff comes to be dismissed before the trial court, rightly on the ground that when the construction took place, she has slept over her rights. First appellate court reverses the finding.
Let's see that order.
Please. My lord, annexure E, my lords, that is an impugned order. My lord, annexure E impugned order is the interim application which is allowed by the appellate court.
Yes.
Miscellaneous appeal as on today is still pending.
Yes.
Please, my lords.
Come to 65.
Please, my lords. My lord,
65.
please. My lord, plaintiff files a suit for partition separate possession, alleging that the properties are ancestral in nature and they are ancestral joint family properties.
Who are you?
My lords, I am the grandson.
Relationship between you?
My lord, she happens to be my cousin, my father's sister's daughter, my lords. My lord, now,
Read the order.
please, my lords. My lord, para number 9, my lords. My lord, it is the case of appellant plaintiff that the suit scheduled property originally belonging to Syed Nasruddin Chapa Saab. The suit scheduled property was granted to him under Kabuliyat on 12/12/1936. He died on 1960. After his demise, his daughter Syed Nasruddin Chapasab by name Papa B got entered her name in the revenue records as per versa. Said Papa B had daughter by name Babyjan. The appellant and respondent number 1, defendant number 1 are the said daughters of Babyjan, and her 2 other sons died without any issues. Said Papa B had no male issues. The said respondent number 2, defendant number 2 is not a biological son of Papa B. The defendant number 2, by misrepresenting the revenue authorities, got changed the khata item number 5 to 7 of the suit schedule properties into his name, and item number 3 and 4 of the suit schedule properties are standing in the name of appellant and respondent number 1. Said respondent number 5 is the son of respondent number 2. Due to the old age and illness of the grandmother of Papa B, without her knowledge, the said respondent number 5 created willnama with respect to item number 1, 2 of the suit schedule properties. On the basis of created willnama, the defendant number 2 and 5 illegally started to construct a new house in serial number 2 of the suit schedule property. The plaintiff has filed the suit for declaration and partition against the defendants on 4/11/25. The said respondent number 5 has filed caveat. Due to the improvement and technology, and defendants started construction work through JCB and ready-made items for filler, and also started to construct a new house in item number 2 of the suit schedule property. If the defendant number 2 and 5 are not restrained from any alleged construction, they would complete the construction work and also cause great loss to the hardship to the appellant and deprive the rights of the appellant in item number 2 of the suit schedule properties. Hence, the present bill. My lords.
What we do is, we'll let him complete the construction.
Yes.
Let him not claim any equity, because this is half the way.
My lord.
Construction is half the way.
No,
Now
it is just commenced, my lord.
My lord,
Number
I have
1.
produced photographs, my lords.
Till the
Please.
suit proceedings are completed. If they do not do anything, now in view of the escalation of prices, construction and all, no, let them file an affidavit before the court that in the event the suitors decreed, let them not claim equities. That should be the order.
My submission is that, my lord. Number 1, the property is not in the name of the petitioner. It is in the name of my grandfather, who is no more.
Well, grandmother, my lords. Grandmother.
What is the relation between your grandmother and?
I have denied the relationship with the father. I said, even your lordship.
No, that's why you are permitted to construct.
He is not my mama, means he is not the son of my grandmother. My mother is only one daughter to the deceased. He has no right, title and interest over the property.
Then why is he in possession of the property?
Sorry, my lord.
Why is he in possession of the property?
He is not in possession of the property. That is,
My lord, she admits in her plaint herself, saying that she is staying 100 meters away from this particular suit property where I'm constructing. And my lords, this particular suit property is 5 guntas. In 5 guntas, around 4 guntas, there was already a structure existing on which my grandmother was running a small dhaba. Along with her, I was running. Subsequent to that, she is staying in the suit property which my grandmother has given to her daughter. That is plaintiff's mother, my lords. She is staying in that property for more than 15 years now.
If he is not in possession of the property, you would not ask for a relief, restraining him from making construction.
I have not sought the possession. I have not the.
Not possession, restraining them from making construction.
Because.
That means he is in possession of the property.
No. I have not admitted his title. I have stated that he has no title. It stands in the name of the deceased still now, number 1. Number 2, they have not obtained any permission from the local body or panchayat for the construction of the building.
Independent relief, you can file an application, you file a petition, that will be taken care of.
But it has come in the judge orders that, my lord.
Annexure F, my lords.
The mother of the petitioner is the president of the Gram Panchayat. So taking undue advantage of that power or as the president.
You have a further remedy. If her mother is a panchayat president.
Yes.
So there is panchayat officer above her and all that you can. Now.
Yes, without obtaining any, they have not obtained any permission.
That is an independent remedy. That would be taken, you can question it.
Therefore, if they are permitted to complete the construction, again, there will be complications. Therefore, my respectful submission is that, my lord, trial court may be directed to dispose of the entire appeal within a week or 2 weeks. I will be ready for hearing.
My lords, no.
Yes, I will instruct my party to be ready for hearing because it is my appeal.
This miscellaneous application is only for injunction.
Yes.
Should there be an interim order in this by the court?
My lord,
Within a week or 2 weeks, entire
my lord,
appeal
that
may
is
be
what my
disposed.
I'll set aside this order and ask the court to decide the MA itself.
No, if that is the case, my lord, trial court has, now they will commence the construction, illegal construction. Because
Nothing will happen.
he has no title, number 1.
In an MA, the whole purpose of questioning the interim injunction. Again in that another IA, why?
My lord, please,
come.
please.
The
Otherwise,
I will set aside this order, let MA be decided.
I will make a submission, my lord. Let him file an affidavit before this honorable court stating that he will not claim the equity.
Come on.
Please.
Then in that case,
My lord,
nothing
it is-
remains MA.
Please, my
Straight
lord.
away it can go for.
Straight away.
That is different. So
My lord.
if there is an order, an undertaking before this honorable court, the matter would be different.
For the petitioner. Shall file if the petitioner wants an interim order from this court, he shall file an affidavit before the court stating that in the event is unsuccessful in the suit, he shall not claim any equities.
Please.
Yes, when will you?
My lords,
Let's the matter on 10th of February.
my lords, now my only prayer would be, my lords, annexure F, my lords, for a moment, I'll take one. My lord, now I have put the concrete, I have put the slab construction, my lord. My lord, annexure, photos may be seen for a moment, that is why I'm requesting, my lords. Now, my lords, bar bending work, everything is done. My lord, if,
File it tomorrow.
my lord,
I
now,
will pass orders.
my lord, now I am constantly pressurized by these builders, my lords.
No, you can't have both, Mr. Counsel. Either you file an undertaking.
Please, I will file an undertaking, my
Whenever
lords.
you file an undertaking, then I'll pass the order.
Please, my lords, Tuesday, my
Yes.
lords, please.
Yes, Tuesday.
Please, grateful, my lords.
My lords, petitioner herein is seeking writ of mandamus, my lord, to consider representation as per annexure A, C, D,
Presentation given to whom?
to the second respondent, my lords.
Seeking what?
Seeking that initially the Karnataka State Small Industry Development Corporation Limited, Bagalkot, was allotted 57 sites to the people who are having interest in doing industries, my lords. Out of the 57 sites, only 55 sites have been allotted to the industries. In those sites, only few of the
Along with it, please give that also. Yes.
only few of the sites have been used by the
Instructions.
Please, your lordship.
This is matter next week.
I'll take notice for respond number 4, 1 and 4, your lordship.
CGP takes notice. The respondent, all respondents.
1 and 4, your lordship. Uddamba, respond number 3, notice has to go, your lordship.
Anyhow, they are seeking relief against whom?
Respond number 1 and 4, your lordship, I'll take.
PF?
1 and 4.
You are seeking representation is given to whom?
representation is given to respondent number 2, my lords.
Who appears for respondent number 2?
District Industry Center is there, your lordship, notice has to.
Notice as notice to second respondent. HCGP takes notice for respondent number 1 and 4.
Please.
Yes. Next.
So madam is seeking,
I seek adjournment because if I take instruction from the concerned department now. Because of
Let me first hear him what he wants to say.
Please.
Yes.
so madam is seeking consideration of my annexure representation, my lords. The
Respondents.
respondents
I'm for the
are
respondent. 1, 2, 3.
What is your representation?
is in the Kannada Madams I seek.
What is the sum and substance?
Sum and substance is, my lords, I have taken a tender from the respondent authorities in 2024. I have completed it. Against that, my lord, bill was approved. That bill was withheld by the respondent authorities only on the contention that in some other tender, criminal case has been filed against me, not against this
So
tender.
what is it you are seeking in that?
I am seeking, my lords, release of the bill, my lords.
Yes.
So I take instruction because of he is facing the criminal case along.
Tell them why in instructions here, it's a representation. If he is not entitled, you tell him.
One point is there, madam, which was is produced before the getting the tender. These are documents also fake, my lord. That is
That
it.
is what he is seeking. He is not seeking a positive direction. He gave you a representation. You consider it and tell him that for so and so reason you are not entitled.
Yesterday you give the copy. I take instruction. Yesterday is given.
Yes, the present petition is.
In that, my lords, before that representation, they issued me a show cause notice. In the show cause notice, they themselves state that if you admit.
Now again we submit, this becomes complicated and we have to adjourn it. If it is only the mandamus you want, I'll pass orders.
Please, my lords.
The present petition is filed, seeking a direction to the respondent to consider the representation dated 10/3/2025. And counsel appearing for the, which respondent you have given?
All the respondents. Respondent number 2, my lords, is the one who to consider.
You appear for the second respondent.
No, 1, 2, 3, my lord.
All the respondent. I am sole
You
respondent.
appear.
No, my lords.
Executive engineer, oh.
No,
same.
my lords.
The,
Authority.
it is submitted that the petitioner has given a representation to the second respondent. Then counsel appearing with the second respondent submits that. They'll get she'll get instructions in this regard. The petitioner has given a representation dated
10/3/25.
Huh?
10/3/25.
10/3/2025. The respondents, the second respondent shall consider the same in accordance with law and pass and shall consider the representation in accordance with law within a period of 8 weeks from the date of receipt of the copy of the order.
Please.
Yes, next.
Petition, my lord. Challenge in annexure A and A1, my lord, auction notice. Issued by respondent number 2, my lord, scheduling to have the auction on tomorrow, my
This is
lord.
the respondent number 2.
Auction is a bank, my lord,
Appearing for KVT, respondent.
Cooperative bank.
a cooperative bank, my lord.
What is the auction?
Sorry, my lord.
What is wrong with the notice?
Notice is not in accordance with the section 38(2) of Karnataka's corporate society rules, my lord. I have extracted at page number 8 of my petition.
Page
my lord.
number?
8. Para 13, my lord. Rule 38, attachment and sale of immovable properties. In the attachment of sale of immovable properties without attachment, the immovable property and following rules to be followed. In that annexure, G, my lord, the sale shall be after the expiry of not less than 30 days calculated from the date on which the notice of proclamation was affixed in the office of the recovery officer.
When was that?
It was not done, my lord. That was not done.
When was it affixed?
It is not fixed, my lord. Now the only the notice is
Please, my lord, the notices are to letting them to participate, my lord. It is not for the execution of award. This section rule 38 has to be complied when the award is getting to be executed, my lord. There was an earlier auction, my lord, and as there were no bidders under section 101B, the property has fallen into the share of cooperative societies, my lord. That order is not challenged by the petitioner, my lord. Now, my lord, the notice issued for them is to participate in the auction which is to be held tomorrow. In that case, my lord, there is compliance of.
Oh, for conducting the auction, there is a rule that the section 38 applies to it or not?
Please, I will, let my lord, section 101B may kindly be seen.
Yes.
May I read, my lord?
Yes.
101B, property transfer of property which cannot be sold. When in any execution of any order sought to be executed under 101, any property cannot be sold for want of buyers if such property is in occupancy of the defaulter or some person in such behalf or some other person claiming to be a title created by the defaulter after the issuance of certificate by the registrar or any person authorized him under 101. There is an order under 101 by ARCS authorizing the bank, my lord. They have transferred the possession as well as the title. There is no need of conducting auction, my lord. They have, as per the order, they have produced, my lord. It is produced at annexure F of the petition. It may kindly be seen, my lord. The order says that the bank are at liberty to sell the property.
Is at liberty to sell?
Please.
While selling the property, there are rules or not?
Please, my lord, I am submitting on that behalf. They have to comply section rule 138A, my lord, not the 38. As it is already complied, it is for the execution of award. In that case, rule 38 needs to be complied.
Come to that rule 38.
Please, 38A.
A. 38 deals with attachment and sale of
Please.
immobile property.
Please, ma'am.
2A.
38A, my lord.
What is 38A?
Transfer of property which cannot be sold. It says, my lord, when there is order under 101B, they have to follow the rules and conditions which are
No, read 38.
Please.
Attachment and sale of immobile property. Read it.
38, my lord. Attachment and sale of immovable property. Immovable property shall not be sold in execution of a decree unless such property has been previously attached.
That is, that's over. That is, we are not connected, we are not concerned with one. Next two.
Please. In the attachment or sale without attachment of immovable property, the following rule shall be observed. A. The sale officer shall serve or cause to be served a copy of demand notice issued under sub rule 3 and rule 34 upon the judgment debtor, or if he is not available upon some
Two applies in case of attachment, with attachment or without attachment. When the sale is taking place, this should be followed.
Please. My respectful submission is that, my lord, it is to be complied when award is being executed. Now, my lord, award has already been.
If it is not, then you should have some other rule.
Please,
When you are selling a property, what is the procedure to be followed?
Please.
When it, how?
Please.
Where is that?
Please, my lord. Order under 101 may kindly be seen, my lord.
101 doesn't give you the particulars about how the sale has to be conducted.
Please, it says that how the sale has to be conducted, my lord.
Let's see.
Please.
Just now you read more.
Annexure F, my lord, and at page 20 of the petition may kindly be seen.
101.
My lord, 101B.
Section.
Section. May I read, my lord? When transfer of property which cannot be sold, when in any execution of an order sought to be executed under section 101, any property cannot be sold for want of buyers, or if such property is in the occupancy of the defaulter or of any person on his behalf.
In this case, that is in your position according
Please.
to you. Oh, yes.
There is order, they have produced that order as well, my lord, and it is not been challenged. In that case, my lord, they cannot challenge the auction.
You are not answering my question.
My lord.
Where is the procedure
Please.
for conducting the auction?
Please, my lord. Annexure F, my lord, operative portion may kindly be seen.
Annexure F.
F.
F of what?
Petition, my lord.
I'm asking you to tell from the rules, from the section.
Please, my lord. It says that when there is a order under 101B, my lord, they have to follow the procedure that are imposed in the order, my lord, in which is.
Here it says, read it, 101B, complete it.
Please. My lord, where the property is transferred, subclause 2, my lord. Where the property transferred to the cooperative society under subsection 1, where the property is sold under 101, the court or the deputy commissioner or a registrar, as the case may be, in accordance with the rules, place the society or the purchaser, as the case may be, in possession of the property transferred or sold. Now, my lord, bank has come into the possession and the.
It's not that. Notwithstanding all this, there is a, when you know you're conducting the sale.
Please.
For conducting the sale, again you have to fall back on 34 or 38, which is relying on.
No, my lord, I am submitting in that sense. 38 shall not be complied. 38A needs to be complied, my lord.
That's what? What is 38A?
38A says that whatever the condition imposed by the ARCS while passing 101B should be followed, my lord. In that manner, my lord, I am bringing your lordship attention at annexure F.
Please file your objection.
Please, my lord.
Not able to understand.
Please.
Till then, the stay may be granted because tomorrow.
Yes.
No, my lord.
Because you're not able to convince the court what to do.
My lord, let me submit, my lord. Rule 38 needs to be complied when the order of passed by the ARCS is being executed, my lord. Now the order is already been executed. As there was earlier auction and as there were no bidders, the property has come into the possession of bank.
Of the rules or something should say what is the procedure.
Please, my lord.
If not 34, then there should be some other clause.
Please, my
some
lord.
other provision. I am not convinced with what you are submitting.
My lord, annexure F may kindly be seen, my lord.
Yes.
Order passed under 101B, my lord, which says that the possession and the title is handed over to the bank. And in operative portion, my lord, it says that it is valued at 1 crore 13 lakh and 8744 rupees, my lord. And thereafter, the bank can sell the property, and if they fetch higher amount, it needs to be returned to the petition.
That is what you're not understanding. Even under the Securitization Act also, the rules contemplate when you are selling the property, what is the procedure to be followed? That procedure is there in this, in this act also.
That
Whatever it is, you have to follow the procedure. No, a notice is issued. How much is the time between the notice and the auction?
My lord, that notice is not under section 38, my lord. If we have issued the notice under section rule 38, it has to be issued prior 30 days. Now the notice may kindly be seen, my lord. It is a notice stating that the petitioners can participate in the auction. It is not for them to repay the award amount, my lord.
Heard the land counsel the petitioner. There shall be stay of all further proceeding pursuant to the same till the next date of hearing. The respondent shall file their objections. Yes, 30.
Please, obligation.
Notice, your lordship.
Notice to the
It's for
Respond
R1.
number 1. your
R1 is government.
I'll take notice in that
R1 to
R1.
so and so CGB takes notice. Yes. Yes, 30.
I appear, my lord. Lord, the petitioner is a licensed contractor. In the tender which is floated by the respondents, he had applied, and his bid has come to be rejected, refused, only on the sole ground that previous work done order is not submitted. But it is already submitted. It is reflected in my application. In page 32 may kindly be perused.
Respond number 3, your lordship, who has respond number 3 who has called for and has
Who
to
is
answer.
respondent number 3?
Town Panchayat, your lordship.
No counsel for this.
No, your lordship. Raibag. Maybe there, your lordship, but I don't. There is no panel.
A list of panel counsels who are
Please, your
appearing.
lordship, but it is not there, your lordship. Somebody notice has to. Shivraj Hiremat, your lordship. Shivraj Hiremat. lordship.
So and so is directed to take notice on behalf of the third respondent. Counsel for the petition has served the copy of the writ petition. List this matter on Tuesday.
My lord, I am seeking for stay, my lord.
No,
because they are
Tuesday. Without instructions, I will not.
I'll take notice for respond number 1 and 2, your lordship.
Yes, 1 and 2 CGP takes notice. Yes, 31.
My lord, for respond, please.
Yes.
So this is an order 64 appointing an inquiry officer. Challenge. Lordship would see the order, my lords. Absolutely, my lords, there is no reasoning. Annexure D, my lords. C is the complaint, D is the order. The first para, my lords, what it says is, my lords, I had been to the bank on inspection and I found some deficiencies. Therefore, law on the point, my lords, that whenever, my lords, under section 64 and section 25, my lords, both sections, section 25 Societies Registration Act, my lords, and section 64 of Cooperative Societies Act, they are perimetry, my lords, same, my lords, inquiry, my lords. What the law says is not the full bench decision of this honorable court.
First of all, you please make the court understand what are the facts.
Yes, I'm sorry.
We'll look at the law later.
But the society, my lords, it will complete, my lords, 102 years, my lords, next year.
What is this order dated 13/6/2025?
That is an order appointing an inquiry officer on a complaint by an ex-employee.
An order of 13/6/2025 now.
No, a notice was issued, my lords, subsequently. We have replied to the notice also. Then, my lords, our reply is not considered. They don't want to drop the inquiry.
No, it is an order of 13/6/2025. No urgency for this. Who takes, you take notice for whom?
Please, your lordship. Respond number 1, 2, and 3, your lordship. Only 1 and 2.
1 and 2,
Please, your
if
lordship.
he takes notice,
3, 4, 5, notice has to go.
issue notice to 3, 4, and 5.
Notice is issued recently, my lords, in this, my lords, after the inquiry officer, my lords.
No, it is
We
not
we have
issued.
given
Notice is not
reply.
issued.
No, our notice is also issued, my lords. That is annexure.
Not that
In
notice,
case
notice in the writ petition.
No, what I'm saying is not after this impugned order, then, my lords, they issue notice to the society.
See, we will see. Well, let other side come. We can't understand everything like this.
On this, the order passed on IA for impleading malad under order 1/10(2) of the CPC. Now, the first respondent here in malad has filed the suit, wherein the claim per malad is for the recovery of an amount in pursuance of an
agreement, my lord, stated to have been entered into between the petitioner and the first respondent, and wherein the suit is for recovery of the amount.
You are?
My lord, I am the dependent.
Hmm.
My lord, in the agreement, my lord, in fact, an agreement in pursuance of the agreement, certain amount has been received. Subsequently, my lord, as per the request made by the very first respondent itself, the sale deed was executed in favor of her daughter, the second respondent, my lord, who is not made as a party. Thereafter, she filed a suit for recovery of the amount which is stated to have been paid by her in the as per the agreement. Her sale deed is already been executed. So, my lord, the second respondent, my lord, the petitioner, my lord, intend to, my lord, bring the second respondent as a party to the suit. But that application was rejected. Para reasons, my lord, at page number 16, my lord, in fact, point number 1. Whether the presence of the proposed dependent is necessary for effective and complete adjudication of all the issues involved in this suit. The plaintiff has filed the suit for recovery of the facts have been narrated. Then, my lord, at the stage of my lord, facts is not in dispute. My lord, at the stage, the dependent has filed an application to implead the daughter of the plaintiff as one of the party to the proceeding. It's a settled principle of law that if the presence of the party
Specific performance or recovery?
no, not for specific performance. She has not even sought for, my lord, cancellation of the sale deed.
What is the present suit for?
Recovery of the,
Says between the plaintiff and defendant.
yes, recovery of the
So
amount.
the property has executed an agreement of sale.
Agreement, so, my lord, in agreement was entered into between the plaintiff and the dependent. The dependent is the present petitioner. In the agreement, my lord, certain amount has been paid by the plaintiff. That amount, in fact, has been paid to her by her daughter. Then, my lord, she requested to execute the sale deed in favor of her daughter. Sale deed was effected. After, my lord, the sale deed is effected, she says that she is intent to take back the amount, my lord, which she has paid, because the sale is already been given in favor of, my lord, her daughter, the second respondent herein. And without making her daughter as a party, she has filed the suit. She has not even, my lord, that's why, my lord,
What is wrong with this? The entire judgment is with regard to the specific performance suit.
my lord, that's not correct. In fact, if it is the specific performance of the contract, her daughter is also necessary party.
Where is the plaint?
Plaint is, my lord, at page number, it is in Kannada, my lord, in fact. Wherein, my lord, there is an agreement, my lord, what she is saying there, but there is an agreement.
Forget about the agreement. The
Yes.
suit is for the relief of recovery of money or. specific
Recovery of the
performance.
amount, my lord, page number 24.
20?
24. ಪ್ರತಿವಾದಿಯು ದಿನಾಂಕ 17/1/2022 ದಿನಾಂಕ 28/3/2022 ವಾದಿಯ ಹೆಸರಿಗೆ ಬರೆದುಕೊಟ್ಟ ಅಗ್ರಿಮೆಂಟ್ಗೆ ಅನುಸಾರವಾಗಿ ವಾದಿಯು ಸದ್ರಿ 2 ಅಗ್ರಿಮೆಂಟ್ಗೆ ಅನುಸಾರವಾಗಿ ಪ್ರತಿವಾದಿಗೆ ನೀಡಿದ ಒಟ್ಟು ಕ್ರಯದ ಮೊಬಲಗು ರೂಪಾಯಿ 52,050 ಲಕ್ಷಗಳನ್ನು ಮುಂಗಡ ಹಣ ತಡೆದ ತಾರೀಕಿನಿಂದ ಶೇಕಡ 15 ಬಡ್ಡಿ ದರವನ್ನು ಆಕರಿಸಿ ಪ್ರತಿವಾದಿಯಿಂದ ವಾದಿಗೆ ವಸೂಲು ಮಾಡಿಸಿಕೊಡಿಸುವಂತೆ. She is requesting for
Then counsel for the petitioner submits as far as suit for recovery of money. Either the petition is a defendant in the suit, and the plaintiff had filed a suit for recovery of money. It is a case of the plaintiff that he has executed that he has paid part of money to the defendant, and the defendant has executed a sale deed in favor of the. Is it his case? He accepts it? That you executed.
My lord, in fact, it's executed in favor of the second.
Is it plaintiff accepts it?
My lord, she accept. And that's why, my lord, she is seeking for recovery.
The defendant has executed a agreement in favor of the daughter, and hence he sought for recovery of money. In that regard, the defendant has filed an IA seeking impleadment of the defendant, the daughter of the plaintiff, which came to be dismissed. Then counsel submits that the court, relying more on suits for specific performance without even considering any of the contentions that are raised by the petitioner, had dismissed the IA, considering the same. There shall be stay of all further proceedings pursuant to so and so. The petitioner shall take out hand summons on the counsel appearing for the respondent before the trial court and shall file a memo to that effect by 12th of February, or else the stay granted by this court stands vacated. Yes, next. Yes.
Yes, my lord. The amendment application is rejected under Annexure C, my lords. Page 56.
What is the suit for?
My lords.
What is the suit for?
Suit for declaration, my lords. The sale deeds executed by dependent number 6 is not binding on the
Which year is the suit?
2017, my lord.
When is the amendment filed?
2019 I have filed.
What is 2000?
19 I have filed, but it is decided in the year 2025 December, my lord.
What is the amendment you are seeking now?
My lords, in the description of this property,
Please come to the affidavit in support of the IA.
yes, my lord. As page number 61, my lords, I would like to draw my lord's attention at the schedule of amendment, my lords. Page number 61, Annexure C, my lord. In the second line of the description of the suit property, 60 into 50, that is 465.888 square meters, be amended at 100 into 50, that is 5,000 square feet, my lords. This is the amendment, my lords.
Come to the order.
My lords.
Order.
Yes, ma'am. Page number.
Page number.
75, 76, my lords. At operating portion, my lord. 75, my lords. Para number 20. Admittedly, the plaintiff contended that he has been allotted 51 into 68 and 3,000 square feet. The family arrangement deed in terms of the merits came to be, my lords, before this, para number 19, the plaintiff has included a certain document in those documents extent of 465.88 square meters are shown. In some of the document, 465.88 square meters is rounded up and shown as 288.37. Against this, the proceedings are going on, my lords. And secondly, admittedly, the plaintiff contended that he has been ordered 51.6 into 60.3, that is 3,1100 square feet in the family arrangement deed. In terms of the matter, it comes to 288.37 square meters. The plaintiff intended to show it 288.37 has been shown to 465.88. For this effect, I have produced that family arrangement deed of 1998, my lords, before the honorable court, my lords. But that has not been considered and rejected my prayer, my lords.
You have sought for a declaration.
Yes, my lord.
That so and so sale leads are not binding on you.
Yes, my lords.
Now you want to change the whatever is a measurement of the land that is mentioned in the sale deeds.
My lords, what had happened? The dependent number 6 has constructed the building.
Whatever it is, what
Yes,
is
my
the
lord.
business of the court in that? You say that a particular sale deed is not binding on you.
Yes, my
Whether
lord.
it is binding on you or not will be decided by the court.
Yes, my
How
lord.
can the court go into the question of what is the extent mentioned in the sale deed?
Because-
Will it be changed?
My lords, because they are interpreting in my possession in view of the
That is not to be decided by the court at all. Court will only decide what is a limited prayer. Seeking a declaration that sale deed is not binding on you.
yes, my lord.
Not whether the sale deed contains that a measurement should be this or not, that has to be altered. How can the court decide all that?
My lords, in that sale deed, there is an entire extent of land has been mentioned as 7,200 square feet. My lord.
Whatever are the sale deeds, it will remain. They can't be changed. Dismissed.
My lords, I request for a notice, at least let them come, my lords, because there is an family arrangement deed I have produced, my lords. In that, the dependent number 6 has allotted 5,000 square feet and 5,000 square feet to the plaintiff, my lords.
The council, please understand this. You are seeking a declaration that the sale deeds are not binding. Whether they are binding on you or not is the only limited issue before the court. Can the court go into any of other aspects which fell to your share, which fell to their share? Is it the concern of the court?
Because
It is not. Court cannot decide. Court rightly held. No notice is required. Dismissed. Yes, certificate.
Please. Trial court, my lord, rejected the application, my lord, for production of document
Lord, the documents are, my lord, public
For,
suit for declaration and injunction, my lords.
for the,
Plaintiff. Lords, the IA, my lord, rejected on the ground that, my lord, it is filed belated stage. Lord, the IAs are, my
what is the present state?
lord,
Correct. Reasons will follow. Yes.
lord, case is, evidence is completed, case is posted for argument tomorrow. Lord, the documents,
That you should have the additional document.
my lords,
Then when the court, when the matter is posted for arguments, then you have realized.
issues are created, my lord, issues are framed. Based on issues, my lord, we have sought for the documents from Tahsildar office. Tahsildar has issued the, my lord, endorsement, wherein, my lord, the defendants, my lord, claiming that, my lord,
When the
based on the
Tehsildar issued the-
relinquishment deed,
When the Tehsildar issued the documents to you.
my lord, 21/6/24.
21/6/20.
Lord, another document is, my lord, the genealogy. One is for genealogy.
When
And
did you get it?
Lord, that document was not with me, my lord, it was with my brother. My lord, I applied, my lord, it was late, my lord, therefore I received from my brother and we produced it. Lord, the case is, my lord, the relinquishment deed was executed by my father in their favor. Lord, therefore, based on that, their names have been entered in the mutation records. That records, my lord, I have sought, they have not produced any document. Therefore, I applied, my lord, for documents.
That's why I asked you, when did you receive it? You say you received in the year 2024. What were you doing keeping it with you? And why did you file an application now? After the trial is
24,
concluded?
25, it is there, 24, 25.
Huh?
It is there.
The application.
Lord, application is filed 14/1/26. 14/1/26, my lord. Please, my lord. That application, my lord, was rejected only for production of document. For this reason, there were two issues were created.
Question of after concluding the trial and when the matter is posted for argument.
One IA is, my lord.
Was the
There are
trial
two
completed?
IAs, my lord. One IA is,
When was the trial completed?
lord, 25/11/2025.
Hmm.
Thereafter, my lord, when case is posted for evidence, applications are filed.
What is evidence after trial? You're saying
Lord,
arguments.
two IAs are filed, my lord. One is for recall of, my lord, chief examination only to mark those documents. Another IA is, my lord, to production of documents. Lord, order 7 rule 14 application is there, my lord. Order 18 rule 17 application is there. Only there are two IAs. Two IAs are, my lord, clubbed and together rejected by the trial court.
Come to the order.
Please, ma'am.
Read the reason, very
Lord,
small order.
page 21, my lord.
Para 7, read.
Para 7. Plaintiff has filed a present suit against the defendant for the relief of declaration permanent injunction in the present case. Trial has already commenced when the case is posted for argument by the plaintiff side. The present application is filed. Present case on dated 18/2/2019, plaintiff present examined PW1 and documents got marked. After that, on dated 1/4/2021, PW1 full cross examined by the learned counsel for the defendant. Then the 14/3/2022 to 17/1/2022, during this period, two PW2 and 5W5 were examined, fully cross-examined. Then on dated 17/6/2023, defendant number 2 present and examined as DW1, documents got marked and DW1 partly cross-examined. 23/8/2024, again the date 9/1/2025, DW1 present and partly cross-examined. On dated 17/9/2025, DW1 fully cross-examined. Then case was going on for further defendant evidence 23/9/2025 to 13/11/2025, and on the same day case is posted for argument. Then the period from 25/11/2025 to till filing of the present application, learned counsel for the plaintiff 5 times took adjournment for the addressing the argument. Therefore, filed application. The plaintiff filed a suit for declaration permanent injunction based on the registered sale deed executed by the Sivappa Nagappa in favor of the father of the plaintiff. In such circumstances, no genealogy takes much importance. However, perusal of the genealogy, names of the plaintiff is not appeared as son of Hussein. It is not correct, my lord. The very genealogy is stated, my lord, the son of present petitioner is son of my lord, father of son of Hussein Gowda. It is stated in the genealogy itself. The object of the above said provision is to give opportunity to the parties through trial courts should fear not arbitrary in the cases on hand. Principle of natural justice applied and opportunity has given and applicant plead evidence. The allowing the application should not abuse the provisions. Despite sufficient opportunity, the applicant has failed to use the opportunities in a proper way. It appears that the application should not be allowed to fill up the lacuna. The conduct of the party shows the could not diligent will filing the applications. It's having intention only to drag the matter. The court relied upon the following decision. MRS Aqua Solutions represented by its GPA holder Rajesh Kumar Thakur versus Indo-American Technologies represented by GPA holder.
I've seen.
My lord, please, my lord, even I have, my lord, quoted some judgments. In those judgments, your lordship may kindly see para 16 of my petition. Lord, para 16 may I read, my lord. Lord, that in the case of my lord Haldiram India Private Limited, Haldiram Bujiwala 2009-5 ILR Delhi
It
held
all
that.
depends upon facts and circumstances of the case.
Please, my lord, but my lord, mere
Able to
mere
convince the
mistake
court.
on part of the parties, my lord.
I mean, it's not a mere mistake.
Lord,
It's not a mere
it is there.
mistake.
Lord,
No, you have let the trial go on. Court has discussed how many opportunities were given to you. You kept quiet.
even
And
both the
whenever you
parties, my lord, both the side, my lord, have took adjournment. Even they have not cross-examined, my lord, the PW1.
Dismissed.
Lord, for a moment, my lord, limited. Lord, tomorrow is the, my lord, for
I said
argument.
dismissed. Yes, 35.
Yes, I appear. Milords, the respondent Milords had called for a tender Milords for work of construction of automatic driving test track Milords. The petitioner had applied the tender Milords. The respondent number 2 Milords without any giving reasons Milords which are rejected. Thereafter Milords, the petitioner filed an appeal Milords and annexure D Milords.
What did they do?
They rejected they just sent the mail Milords at annexure C. Annexure C may kindly be seen Milords. Your bid status rejected. Then Milords on 3/1/2026 Milords by annexure D Milords, page number 24. I made an appeal Milords to the to the respondent Milords. Milords, may I read Milords?
Yes.
Yes. However, to my surprise, my bid has been rejected. Even though I have attached all the relevant documents, I have been qualified to the best knowledge. Then Milords, I requested the fair and transparent evaluation in accordance with the tender process of rules.
Instructions.
Respondent number 2, Your Lordship, NWKRTC, who has this.
Who appears for them?
Prashant Osmani appears.
So and so is directed to take notice on behalf of all the respondents.
No, Milords. Respondent number 1 is the government Milords. Respondent number 2 is.
On behalf of respondent number 2, respondent number 1, SCDP takes notice. This is matter on 16th of February.
Milords, once humble submission, may I request for an interim Milords. Now Milords, if my tender has been rejected, if it has been allotted to somebody Milords, then come with this.
First of all, without even understanding how can we grant an interim order? List on 3rd February.
Obliged.
If it is wrong, we can always set aside.
Milords,
Yes.
May I request in preliminary hearing?
Yes, preliminary hearing on, yes, 36.
Obliged.
Yes.
Petitioner was a bank employee. Bank is respondent number 2, my lords. I borrowed loan from the bank and petition recovery was initiated and it was ordered that I should pay 7 lakh and odd amount, my lords. Against that, I preferred an appeal. My contention is I was not provided an opportunity. Notices were served on 20th of February and on the same day evidence was recorded and same day evidence was closed and on the same day order was passed.
Where do you get that?
Page number 17, my lords, but it is in Kannada. Typed copy is at page number 18. Prakarno.
No, now you are aggrieved with the appellate order.
Yes, but even before the appellate authority, the same contention.
That we will see. That is in English.
Yes, please note. Annexure D is the order of the appellate authority. Reasons.
Paragraph 18.
The appellant has not explained as to why he remained absent. Before the learned first respondent, in spite of service of notice under such circumstances, it can be said that appellant remained absent without any reason, and the notice of the dispute is duly served. I do not dispute that notice is not served, my lords. Notice is served, but very, please.
You didn't appear before them.
Yes, only on one date they passed the order. Notices were served on 4/1/2019.
Submitted that without giving an opportunity to the petitioner. An order is passed, and when he has questioned the same, by filing appeal number 111 of 2019, the same, what is the date of this order?
Order of the appellate authority, my lords.
The appellate authority at
October
17th,
Annexure D.
17th October.
has failed to consider the same. And it is submitted that the orders that are passed by the primary authority is contrary to the provisions of contrary to Rule 31(4)A of the KCS rules. Considering the same, there shall be stay of all further proceedings. Pursuant to the order dated so and so.
Annexure B, my lords. Annexure B, that is the original order. My appeal was dismissed. Annexure B has to be stayed.
First respondent. You appear from.
I'll
whom?
take
You don't
notice.
appear for
Respond
anyone?
number 1 only.
Respondent 1.
Only
Only
one.
one. Your Worship.
Respondent number 1, HCCP takes notice. Other respondents issue notice. Yes.
Plaintiff is the petitioner before this honorable court against the rejection of the application for amendment of the plaint. Petitioner
What is the suit for?
Suit is for partition and separate possession.
What is the amendment?
Amendment sought is to remove the survey number 662, which was shown as Schedule B, on the count that it is not the joint family property and no share is being claimed in that, by way of amendment of the plaint and for deleting that prayer.
That was dismissed.
That was.
Come to the order.
When this matter is posted for cross-examination of PW1, plaintiff has filed the present application praying to permit him to amend the plaint as per the proposed amendment. In the proposed amendment, plaintiff is praying to permit him to delete the entire para 5 of the plaint and its place, prays to insert the facts inserted in the proposed amendment. I have produced the facts stated in para 5 of the plaint. Facts stated in para 5 of the plaint are got included by the plaintiffs as per order passed on IA number 5, which is application under 6 Rule 17 of CPC. In para 5 of the plaintiffs contended that
Come
Schedule
to
A
paragraph
property.
number 11.
My lords.
11.
It is settled principle of law that if by way of amendment to pleading, it among to withdrawn and admission as such withdrawn is causing defense of the defendant, then the amendment cannot be permissible. In the
So,
present case.
by way of an amendment altogether, a different case you're introducing.
No, my lords.
Or already.
Actually, what had happened, my lords? Defendants
Come to
set
your
up.
affidavit. Where did you, what is that exact amendment you
Please,
want?
madam.
Where is that?
May I state the facts in brief, my lords?
Come to
By
that.
way of defense, the defendant had set up a case that.
No, let us see which
Please.
page it is.
Proposed amendment at page 42, my lords. It begins, in the entire new para 5 may kindly be ordered to be deleted by way of amendment, and its place the following sentences may be inserted by way of amendment. It is submitted that the defendants have submitted in their written statement on false and illegal grounds. Defendants have taken false contention that out of sale consideration amount from defendant number 4, defendant number 1 to 3 have purchased the land bearing RS number 662. It is submitted that as per the knowledge of the plaintiffs, defendants 1 to 3 have not purchased survey number 662.
Now what happens? First, you accept that it is a joint family property.
Please, my lords.
Now you say it is not a joint family property.
And I don't want to claim any share. I don't want to claim any share.
Now you say that it's your property.
But I'm not claiming any share
No,
also.
no, that is what it
Now,
is.
it was contention of the defendants.
No, you said it is a
That I have
joint
not
family
included
property.
662.
They filed a written statement.
Please, ma'am.
After that, the trial has commenced. Now at this stage, after the trial has commenced, what you
Only-
want to say?
Lordship,
You
only
want
chief
to,
is
no,
recorded.
you want, by way of an amendment, you can't introduce new and contrary, different, taking different stand, different facts.
It will not affect the defense of the defendants because they claim it is their property and purchased out of the proceeds from Schedule A property. So I'm not sharing, claiming any share in that property. On the contrary, I admit it is the defendant's property, my lords.
What are their objections, defendant's objection?
Page 45, 46, my lords. 49. I'll come to para 3 minutes. This fall to say that plaintiffs have no legal knowledge and their counsel informed this fact to them, hence only with an intention that they should have a share in Schedule A property. Further, it is false to say that if plaintiffs ask their counsel to include
Notice
block
to
number.
respond.
Of pleasure.
Petition is permitted to take out hand summons and file a memo to that effect.
Please, ma'am.
Yes. Yes.
Senior copy of senior.
I appear for the petitioner's counsel, my lord.
Yes.
First thing is, my lord, I apologize that a translation is not furnished, but I will,
yes,
it's a simple, this thing, I will give the facts. The petitioner is a housing society of which respondent number 4 assistant registrar would be the jurisdictional registrar. Some of the members who had taken
what is
this-
the order now?
Now, 2 minutes, 2 minutes. Who had taken the lease cum sale deeds, they did not comply with the conditions. Therefore, lease cum sale deeds were cancelled, allotment was cancelled, lease cum sale deed was cancelled, for which they have taken up the matter before the assistant registrar, deputy registrar, and even one or the two matters are pending before the High Court also. They make a complaint to hold an inquiry alleging that the housing society is harassing them. Accordingly, an inquiry is held and inquiry report is submitted that it's a civil matter, cases are pending. There are some persons who are non-members who have nothing to do with this. That inquiry report is at annexure B2, page 17.
Senior counsel.
Please.
It's a senior counsel. No,
Please.
What is the prayer of the petitioner? That I'm not able to understand.
Yeah, the next sentence is that, Miller. Now again, a notice is issued on 12th, dispatched on 12th, to be present on 13th. The deputy registrar comes with 50 persons to the office of the society, leading them as if none of them are members or anything. I have produced all those photographs. Without notice, he leads a horde of 50 persons, wants to take over the records, all these things. It's being done every time, it's being done. If they want to hold inquiry.
But with this, no, what I want to know is, with this prayer, can a writ petition be filed? What is the prayer in the writ petition? No impugned order, no notice, nothing, some saying that issue a writ of nature of prohibition.
Please, my lord, it is because of this.
When the writ of prohibition can be issued?
The person who is leading these persons is not the registrar for this society.
Writ of prohibition, when it has to be granted?
That is whenever it is without jurisdiction. That is why I pointed out. Now the respondent number 3 is coming.
No, we can't entertain a writ petition of this nature.
He is not the registrar.
With this prayer, how can
I would only request two more sentence, Miller. Kindly see page 30. Kindly see page 30, my lord, 30.
Yes.
Notice is supposed to have been dispatched to me on 12/1/2026 at 11:26 PM, AM, 11:26 AM, to be present in the society on 13th. On 13th, even before I received the notice, kindly see the photographs. Deputy Registrar leads about 50 people to my society and enters the society. If I say anything to him, he will file a complaint saying public authority is, I am coming in the way of the public authority discharging the duty. Kindly see the
Take notice.
photographs. He brings as
Yes,
many
sir.
as 50 people. Even before the notice is.
I go ahead, see, GP takes notice for the first respondent. File your objections.
Please, Your Worship.
Yes.
Please.
1 to 4.
1 to 4.
1 to 4, Your Worship. 1
Yes,
to
1
4.
to 4. Yes, next.
Minutes,
39.
Appearing for the petitioners, my lords. The present petition has challenged the filing of the execution petition, my lords. It is at annexure B and B1, my lords. My lords, petition number 1 is the son of the petition number 2, my lords. Petition number 1 has obtained a loan for purchasing of a lorry from the respondents, my lords. He has already surrendered the vehicles, my lords. Despite that, the arbitral award has been passed, my lords. Already the auction, seized property has been already sold to my lords. Again, they have filed the execution petition, my lords. The trial court has
Order.
lords, at annexure, my lords, I'll place the memo, my lords. Attachment warrant has been issued against me, my lords. Lords.
You have to question some order, isn't it?
Yes,
When
my
you're
lords.
filing a writ petition.
No, my lords, I have questioned the filing of the execution petition itself, my lords.
What do you question?
My lords, in the meanwhile, attachment warrant has been.
Question it.
My lords,
Does this matter after a week?
my lords, at least 2 days time, my lords, I'll.
You file.
Yes, my lords.
Whenever you file, it will come.
Yes, my lords.
This is matter on 3rd of February.
Much obliged.
Yes. 40.
Please appear for petitioners. But petitioners are all the members of the model respond number 6 cooperative society. Now, pursuant to the model initiation of the election process, but out of 2,694 members of the respond number 6 society, the respond number 6 now has prepared the model list of eligible voters and a list of ineligible voters. Out of 2,694.
When the.
But Sunday is the model date of election. But Sunday it is scheduled.
I'm the curator,
I'm
my
only
lords.
seeking for permission to
Tomorrow.
cast the vote,
Tomorrow.
not for contesting. In fact, not this honorable court in several matters has granted the.
Tomorrow, my lords, I will get the information.
Tomorrow.
Copy illa salವಾಗಿ.
In fact,
It is on 25th. Give him the copy.
I don't have any different.
Tomorrow.
Film meeting.
But, in fact, his caveat is not put up along with this petition for the reason that.
No, forget about the
Yes.
caveat. Now he is here. We can have the instructions of the, yes,
Please,
tomorrow.
Film meeting.
in preliminary hearing.
So and so
Please, my Venkatesh Amkari.
submits that he has filed the caveat.
Please.
Caveat, let council the petition, serve the copy of the writ petition on the council.
And in
Yes,
fact, my lord, if
all
my
these
lord-
matters, 41
Film hearing
till
la.
till the end
Film
of the
hearing.
list, wherever interim order is there, extend the interim order. And Lizzie's matters, give like two matters, date from 9th to entire month of February.
May I request for serial number 40?
This tomorrow it will come.
Is the preliminary hearing list for?
Preliminary.
The preliminary hearing list. Preliminary hearing.
Yes.
Please.
Serial number 1 is passed.
Yes, what about that?
Please, Your Worship, in that matter, they have stated he is the last person who has submitted his bid. Your Worship. ಗ್ಯಾರೇಜ್ ಸಂಕೀರ್ಣದಲ್ಲಿ ವಾಣಿಜ್ಯ ತಾವು ಅಂತಿಮ ಬಿಡ್ ಸಲ್ಲಿಸಿರುತ್ತೀರಿ. ತಾವು
It
ಅಂತಿಮ
didn't
bid
say that you are the
last person who has submitted.
highest auction bid.
Yes.
Then why were you submitting?
Highest,
Since it doesn't say so,
highest bidder.
you are not.
My lord, she says that.
No.
No, she's not saying that.
Last person who has submitted bid. Last bid ಸಲ್ಲಿಸಿರುತ್ತೀರಿ.
And my lord, notices are issued to cancelling to all the petitioners, addressing to the.
First of all, what is the right that has accrued to you, which has been taken away by this tender? That I am not able to understand.
No, no, no. On the objection, my lord, this has been again fresh tender has been called for. Once the tender was over.
Participate. Now no rights have accrued to you. They have a right, they have cancelled. Now you participate in the auction.
Participate in the auction, you also.
When I am the highest bidders, petitioners.
Again, you have come back to square one, Mr. Counsel. No, except you, nobody is accepting that.
Somebody files objection and that comes to be cancelled, my lord.
What is that?
My lord, unsuccessful bidders.
First of all, you are saying that I am the successful bidder. That you show me from the documents.
My lord,
I'm
let
repeatedly
let
asking you.
respondent number one say that I am not a successful bidder, my lord,
That's
merit
what he
petition
said
may be
so.
dismissed.
He already said so.
It has not even been accepted by the lords, the
And
authority.
they have not opened.
Whether he
When
is,
they have not done anything, how will you, how you are the, I mean, presuming it?
My lord, they have opened it and my lord, they have said
When
it
did they
that.
tell you, when did they tell you that you are the?
My lord, on 10/12 itself, on the
What-
day which the.
Where is the correspondence? Where are the proceedings?
My lord, but in the endorsement, they say that because of objections being received.
Let them, you file your objections. File your objections with, no
Please,
interim
my
order.
lords.
Yes.
My lord, serial number 49, my lord.
Huh?
Serial number 49. my lord.
Any call 42? Interim order extend, you look at it, if it is interim order is there, extend. 43?
43 first week, my lord, kindly have it in first week,
Huh?
February. 43, I am the respondent.
Yes.
First week, my lord.
List, no, not now, it will not come now. List this matter on 16. Yes, interim order is there, extend. 44? This also look at it. Give, huh? It will be extended. List on 17th or so. 45? 45 also, look at it.
There is interim order.
Yes, interim order will be extended. 47?
My lord, have it next week.
Huh?
Next week have it.
Yes, not next week, not possible. 18th, look at it.
Well,
Interim
18th
order.
better, 18th better. Earlier or 18th and the 18th.
18th.
Well, 10th it's 10.
10th, yes.
In this matter, my lords, in connected matter, he may be directed to take notice for respondent.
Yes, in which matter?
47.1.
In 47.1.
Yes.
The Patel is directed to take notice. Yes, 48. Look at it, interim order is there, extend, all after 16th.
My lords, appearing for 49, my lords, my name may be shown. I have entered NOC appearance for petitioner and the matter may be referred for mediation, my lords, on 29th.
No, it can be referred to mediation.
Both the parties submit that the matter may be referred to the mediation. The registry is directed to place this matter. Yes, the party shall appear on.
Passport method, my lord.
Which
There
date
is
you
no
will
interim
appear?
order.
28th, mother.
50.
On 30th of January, yes.
Passport, 50 passport. There is no interim order. Kindly have it next week, my lord. Passport method, it's covered by judgment, my lord.
50 on Wednesday.
Please, ma'am, please.
Yes, 51.
My lords, the election has been commenced, my lords. The voting of the votes have been stayed by this honorable court, my lords. Kindly have it on the next week.
This also on 28th. 52.
My lord, for petitioner, my lord. My lord, yesterday respondent number 2 has informed us, my lord, it has become infractuous. We'll see, my lord, on 20, kindly on 28th, my lord.
Yes, 28.
Please.
Yes, 54. It will be extended. Yes, 54. In all the matters, look at it.
56 and
Wherever interim order extend.
interim order there.
Yes, 58,
58 interim order there.
Date.
59. Pioneering it is there.
My lord, in serial number 7, there is an.
Serial number 16. Passover matter, 16. Passover matter, I am the respondent. Regarding the two insurance liability.
My lord, serial number, my lord. Serial number 42. Serial number 42, my lord, next week of.
22 in which list?
42, my lord.
Huh?
42, serial number 42, my lord.
42.
First week of February or second week of February, my lord.
What do you want?
First week of February, my lord.
It
Yes.
will come. It will come.
My lord,
Whenever-
serial number 7, my lord, there is an interim order, it has to be extended. 7, my lord.
Particularly in that matter, don't extend.
No, my lord, because.
Don't extend.
My lord, 59. My lord, when matter was called out, I was absent, my lord.
Times I have to tell you that it will be extended. You're wasting the court's time, nothing else.
Apology.
ದಿವಸ ಹೇಳ್ಬೇಕಾ
ಆನ್ಲೈನ್ ಮೇಲೆ
ಏನಂತ
ಅವು ನಮ್ಮ 56 ಮತ್ತು 58 ಡೇಟ್
ಡೇಟ್ ಕೊಡಲ್ಲ.